Supplementary daily item 1.
Still not. Loknath really is no, he's not in this year. No, এটা হচ্ছে সিঙ্গেল এইটা হচ্ছে কনফাইন করছি only for তাহলে আরোটা বোধহয় একুটালি আরোটা বোধহয় একুটালি না সেটা না কনভিকশন দুই জন ফেস করে ফেলে তাহলে এসে আসেনি এটা আসছে না দুইটা সিআর এ রে তাদের দুজন ফাইল করছেন লেট আস কাম টু সিআর এ সিআর এটা ফাইলিং জি appeal memory ada ভোক্তার স্বপ্নাম খালি মরিগলাম যে সিঙ্গেল ফাইল করছি যে সিআরএল 36/2002 ওটা সার্টেন করা হয়নি ওটা সার্ভিস লোকনাথ লোকনাথ একটা রিপোর্ট দিয়েছি আমি বলছেন বেল হিলিজ বলে ফাইল একটা নিয়মিত আপনার নম্বর 2 আজ রিলিজ অন জেল ছোট দেখেন বেলি 15 বেরিয়ে যাবে All of you, the criminal offense, 59, this is the bill of that. The transfer of the Bokara in the plan. Bokara will eat in a plan. Well, now, Bokara will start the jail criminal appeal level. City into some money. The sea jail criminal appeal dispose of a you. Can they have very much? As you also posted a comma, but failed to ascertain the current letter. Even local gentries are not able to tell about it. To a certain extent. এইটাକୁ dispose of করবো কিন্তু JCR related লিখি দিଅନ୍ତୁ JCR number 36 of 2002 ଦି ଜଣ ଅଛନ୍ତି
ଅଛନ୍ତି ଓହୋ
dispose of କରିଦେବା ଯେ
ଗୋଟେ ତ ମରିଗଲା ଆଉ।
ଗୋଟେ ମରିଗଲା ଆରଟା ଯେହେତୁ ସେଇଟା appeal
ଅଛି,
file
ତେଣୁକରି
କରିଛି,
ଆମେ ଏଟାକୁ ଆଉ-
dispose of କରିବା ହଁ ଦି ଜଣ ଯାକ ତା ଦେହରେ ଦେଇଛନ୍ତି ଲେଖନ୍ତୁ this jail criminal appeal has been filed by two appellants, namely Bhukka Sapnami and Loknath Satnami. Stop. It appears that both of them have also filed CRA number 58 of 2002.
କେତେ 58
हाँ ये जो उपरटा जो CRA जोटा आसीची सेटा भी दी जन जाके फाइल कर এটা হচ্ছে JCR লেটা ଦି ଜଣ ସେଇଟା ବି ଦି ଜଣ
ଏଇଠି କ୍ରିମିନାଲ ଏପିଲ କେ ଦିଆ
କୋଉଟା
ଏଇ ଅର୍ଡରଟା
ନାଇଁ JCR ନା
ହଁ କିନ୍ତୁ ସେଠି ସେ ଲେଖିଛନ୍ତି it appears that the appellants have already filed a regular criminal appeal bearing 58 of 2002
ହଁ
which has already been admitted. In that view of the matter, it would be appropriate to ask the superintendent, ask the appellants to this
ଗୋଟେ କନଫାଇନ୍ କରିଦେବା
or declaration.
start. It appears from the report of Senior Superintendent, Circle Jail, Welfare Service, Sambalpur, dated 27/9/2016, that the appellant Bhukka Satnami was expired on 1/6/2015. And Loknath Satnami has been directed to be released on bail. Right, has been directed to be released on bail on 2/5. Has been released on bail on 2/5/2002. Even though an order was passed on 15/7/2002, to ascertain from the appellants to the Superintendent of District Jail Bhavani Patna as to whether the appellants want to proceed with the jail criminal appeal or criminal appeal number 58 of 2002. But it seems that no such report has been received. Since a regular appeal has been filed by both the appellants, this jail criminal appeal is disposed of. Tapore CRA ko pade asantu 58 of 2002. This criminal appeal has been filed by the appellants Bhukka Satnami and Loknath Satnami. Loknath Satnami, appellant number 2, has been directed to be released on bail by order dated 15/4/2002. Stop. Report has been received from Senior Superintendent, Circle Jail, Welfare Services, Sambalpur dated 27/9/2016, that the appellant number 1, Bukka Sapnami, is dead. In view of such report, this criminal appeal, so far as appellant number 1, Bukka Sapnami, is concerned, stands admitted. So far as appellant number 2, Loknath Sapnami, is concerned, who is on pay command, the reports furnished by the IIC Komna Police Station dated 8/8/2025 indicates that he could not ascertain the current location and address of the said appellant, even though he contacted with some local gentries. In view of such, the report furnished by IIC Komna Police Station, we superintendent
IG administration.
let the IG administration furnish a report regarding the well-being of appellant number 2, Loknath Sapnami, was released from custody on 2/5/2002 as per the order of this court dated 15/4/2002, as reported by the Senior Superintendent Circle Jail, Sambalpur, in his letter dated 27/9/2016. Put up this matter on Place this matter on 11/11/2025. A free copy of the order be handed over to the Land Council State for compliance. It will be school fail, GCR, এইটা করতে আপডেট করলাম number 1 11/11/2025 है ना? Okay, next.
Item 2.
Single appellant. Single appellant. कौन चीज? Alif. देखो, पेरुजी. Alif. हाँ? Alif. सुगुनी.
Alive.
हाँ, alive था. Peruzi report furnished by the IIC Sarat Police Station dated 8/8/2025. It shows that the appellant is alive, is staying in his village with his family. Where is the council? Is a regular appeal. Where is Mr. Lord? Give him a ring. We are just a order pass korchu, but he should come that whether he's ready or will take up on some other day. Ask Mr. Dhar and Senior Advocate. ଏତିକି ରଖିଥାନ୍ତୁ ସେ ଆସନ୍ତୁ ନେକ୍ସଟ ଆଇଟମ ଟା ଦେଖ
Item 3.
ସିଆର ତିନି ଜଣ ଆକ୍ୟୁଜ ଟ୍ରାଏଲ ଫେସ୍ କରୁଥିଲେ ତା ଦେହରୁ କଣ ଥିଲା ଜଜମେଣ୍ଟ
One is convicted.
ୱାନ୍ କନଭିକ୍ଟେଡ
Minor.
evidence in the result I found I hold guilty to accuse Lokhu Das accordingly convicted in বাকি technical court লেখা হয়েছে the evidence of other witnesses are not this evidence is very much matter it is found that the prosecution has been able to prove the charge against ତିନି ଜଣ ଫେସ୍ କରୁଥିଲେ ନା
Minor.
ଲୋକୁ ବାଙ୍ଗା ଆଉ କଣ ବୁଟରୁ
Loku Banga.
ସେ ଯୋଉ ବାଙ୍ଗା ଆଉ ବୁଟରୁ ପାଇଁ ଆକ୍ଚୁଆଲ ଆଚ୍ଛା ଓ ଏଠି ଦିଆଯାଇଛି ପେଜ ନମ୍ବର 5 page number 5 ଗୋଟେ ମଝିରେ ଲେଖିଦେଇଛି I am driven to the conclusion that these two accused persons cannot be held guilty by taking assistance of section 34. Accordingly, accused Banga and Butru are acquitted of their charges of the Bhakti Janu Kaitala. Report कौन असला?
Maintaining livelihood.
Das अच्छा
Alive.
found he has
Loitering here, nomadic life.
देखो peruse the report furnished by the inspector in charge, plant site police station, Rauthala, dated 8/8/2025. He shows that the appellant is alive. What about the HS Mission? ତାଙ୍କୁ ଟିକେ ଖବର ଦିଅନ୍ତୁ ଏଠିକି ଡାକିକିନା ଆମେ ରଖୁଛୁ ବାକି ଖବର ଦିଅନ୍ତୁ ତାପରେ ନେକ୍ସଟ ଡାକନ୍ତୁ
Item 4.
ଆସିଲା ତିନି ଜଣ ଆପେଲାଣ୍ଟ ଅଛନ୍ତି ରିପୋର୍ଟ କଣ ଆସିଲା
So was it?
staying accused staying
The lady was staying for livelihood.
ତିନି ଜଣ ଯାକ ଅଛନ୍ତି
Teaching only.
ପ୍ରକାଶ ଛବିଳ ଆଉ
Munsi.
ମୁନ୍ସି these are the
Munshi.
three accused
Injured.
judgment ଟା ଦେଖି ପ୍ରକାଶ ଛବିଳ ମୁନ୍ସି ଠିକ ଅଛି ଦେଖନ୍ତୁ peruse the report of the officer in charge and
The voice is Jarmal face.
peruse the report of the
Voice is Jarmal.
YC Charmar police station.
Sambal.
It was forwarded to the ASP,
Hmm.
which was forwarded by the superintendent of police Sambalpur, and it's so dated for them 10/9/2025, and it shows that all the three appellants are alive. All the three appellants who are on bail are alive. या धीरे पण एते लोक ना अछि की करबे विजय लक्ष्मी त्रिपाठी तो बर्तमान आपनकर ये को पळैचंदी रगड़ को ना अछि जीपी सामल इस टाइम टू टाइम चेंज करचंदी काउंसिल लेटेस्ट वकालतनामा कहार अछि equals to विजय दुई नहीं तापर देखो
तापर विजयलक्ष्मी देले 9/9 तापर
Charge. 189.
2011 ରେ ଆସିଛି ଆରକେ ପ୍ରଧାନ युवर जेना विकेदा के এটা হচ্ছে লাস্ট এটা 6 এটা 11 রে 29/4/11
11 ଲାଟେଷ୍ଟ वकालतनामा
ନାମ 14ରେ ବେଲ୍ ଆପ୍ଲିକେସନ ଫାଇଲ ହେଇଛି ଆଉ 674/2014 ଟା ହଉଛି ଲାଷ୍ଟ ବେଲ୍ ଆପ୍ଲିକେସନ ସେଇଟା ଫାଇଲ ହେଇଛି 5/5/2014
that is the वकालतनामा
advocate clause
Senior
ହଉଛି
counsel.
ନିରଞ୍ଜନ ସାହୁ ଏଇଟା ଓକାଲତନାମା କାହାର?
ଦିନକ ଦି ଦିନ
ଆଁ?
4/14 ହାର୍ଡ ମିଷ୍ଟର ରଗଡ଼ ପୁରା ଅଛି।
ଓ ରଗଡ଼
ହାର୍ଡ ମିଷ୍ଟର ରଗଡ଼
ଆଚ୍ଛା
for appellant number 1 and 3, Mrs. Kasturi for appellant number 2 and Mr. Pradhan.
11/2014
नहीं 4/4
ଆଚ୍ଛା
लास्ट वाला 4/4
ହଁ ରଗଡ଼ର ଅଛନ୍ତି 1-3 ପାଇଁ ଆଉ ମ୍ୟାଡାମ କସ୍ତୁରୀ ଅଛନ୍ତି 2 ପାଇଁ ତାଙ୍କୁ ଟିକେ ଖବର ଦିଅନ୍ତୁ ବଞ୍ଚିଛନ୍ତି ନା 3 ଜଣ ଯାକ ସେତିକିରେ କେମିତି ଛାଡ଼ିଥାନ୍ତି ଆସୁନି ତାପରେ 5ଟା ଦିନ
Item 5.
ଆଜିରେ 4 ଜଣ ଆସିଲାଣି
Here for all.
And for all.
ବେଲରେ ସମସ୍ତେ ଅଛନ୍ତି
3 and 4 were allowed on them.
center residing the person
ସେ 2 ଜଣଙ୍କ ଦେଇଛୁ ମନିଆ ମାଝୀ ଆଉ ଦନିଆ ମାଝୀ ରିପୋର୍ଟ ଅନୁଯାୟୀ ଏମାନେ ହଉଛନ୍ତି ରିଜାଇଡ୍ କରୁଛନ୍ତି with their respective families. That is with the verification report of the IAC Kasipur police station superintendent of police forward କରିଛନ୍ତି.
Appellant sir, Bibhishana Naik.
What about the rest group?
you lost perhaps item 6 is only Manyamaji item 6
Item?
item 5
Item
होती
five, madam.
विभाषण नायक
ନାଇଁ 5 ରେ
we are on 6 but
we are on 5.
we are on 5 huh?
We are on
Manya-
5.
Manyamaji item 6
ସେଟା ରିପୋର୍ଟଟା ତା ଦେହରେ କାହିଁ ଦେଲେ ସିଆଡୁ କାହିଁ 6 ନମ୍ବରଟା କଣ 4 ଜଣ ଆପେଲାଣ୍ଟ ଅଛନ୍ତି ଦେ ଆର ବିଭୀଷଣ ନାୟକ ବଳରାମ ନାୟକ ଗିରିରାମ ନାୟକ ଆଉ ହାରୁ ମାଝୀ ତାଙ୍କର ରିପୋର୍ଟ ଆସୁଛି
they are residing
ଏଇଟା କଣ ମନିଆ ମାଝୀର କଣ ଆଧିରେ ପୁରେଇଦେଲେ
Manyamaji
ମନିଆ ମାଝୀ ତ ନେକ୍ସଟ ଆଇଟମ
मनिया धनिया विभीषण तातारे मित्र
this report that flag report IAC faces that wrongly
हाँ 3 जनकर जेहेतु से माने रायगड़ा पुलिस स्टेशन अंडर रे बोधे सेतमे 3 जनकर से दे दीची काशीपुर अपन बाइपोर्ट करते
314 item 6 ର report
ଏଇ ଯୋଉଟା ଆପଣ ରିପୋର୍ଟଟା
विभीषण इज देयर
IAC କାଶୀପୁର ପୋଲିସ ଷ୍ଟେସନର ଯୋଉ ରିପୋର୍ଟଟା
ଆଜ୍ଞା
ସେଟା ହଉଛି 20/8/2025
ଆଜ୍ଞା।
ଲେଖା ହେଇଛି ତା ଉପରେ ଲେଖା ହେଇଛି where about of the report of the appellant ଦିଟା କ୍ରିମିନାଲ ଆପିଲ ଏଟା ଜଏଣ୍ଟ
जॉइन
କରିଛନ୍ତି
कर दिस
314/2005 ଯୋଉଟା କି ଆଇଟମ ନମ୍ବର 6 ଆଉ 284/2005
या भीतर से केवल जनकर दला विभीषण
Balaram, Giriram,
the accused person is different in both the case
ହଁ ନାଇଁ କେସ୍ ଅଲଗା ନା ଆଦେରେ କେବଳ ବିଭୀଷଣ ନାୟକଟାକୁ ଦେଇଛି ଯିଏ କି ରେଲେଭେଣ୍ଟ ଅଛି କ୍ରିମିନାଲ appeal appellant number 1
284.
but what about the appellant number 2, 3 and 4 they were released on bail or not?
yes
All the accused persons are released.
they are alive also
They are released on bail.
no they are released on bail is all right
No information.
Well being, I don't have any.
ବେଲ ହେଲାଣି 2013 ରୁ
2 ଜଣ 10 ରେ ଯାଇଥିଲେ 2 ଜଣ 10
So why are you not talking to them? What is this type of report? ଆପଣ ପ୍ରତ୍ୟେକଟାରେ individual ଅଛନ୍ତି ଜଣକର ଦଉଛନ୍ତି ଆଉ 3 ଜଣକର କିଛି ଲେଖୁ ବି ନାହାନ୍ତି ଯେ ଆସର୍ଟେନ୍ କରିହେଲାନି କି କଣ ହେଲାନି କି କଣ ରିପୋର୍ଟ। ଯୋଉ 4 ଜଣ ଯାକ ବେଲ୍ ଅଛନ୍ତି, ବେଲ୍ ଅର୍ଡର ଡେଟେଡ୍ କେବେ କହିଲେ?
First 3 and 4, that is bail order dated 22/2/2010.
22/2
Well,
22/2/2010 ହଁ ଏଇଟା ଆଜି ଯାଇଛନ୍ତି 3/4।
3 and 4.
ଆଚ୍ଛା ଜଷ୍ଟ ମିନିଟ୍ 3/3/4 released ତାପରେ ଆର ଦିଟା
February 17/7/2013, 1 and 2.
17/7/2013
2013.
ଆଚ୍ଛା
Well,
17/7/2013 ଆଜିରେ ଯାଇଛନ୍ତି A1 ଆଉ A2।
A1 and A2.
ବର୍ତ୍ତମାନ ଯୋଉ ରିପୋର୍ଟ ଆସିଛି ତା ଦେହରେ କେବଳ ଜାଣ A1 ର ଇଏଟା ଦିଆହେଇଛି
नहीं 17/7 रे किए रिलीज हेले
1 and 2.
नहीं तो
Okay.
नहीं apply but they have not been released and there is no supervening circumstances to admit the appellant number petitioner 1 and 2 on bail. According to him, appellant number 3 and 4 are similar or admit appellant 1 and 2 program on such अच्छा allow last paragraph allow.
तो ये जो रिपोर्ट ଆସିଛି it only confines to ବିଭୀଷଣ ନାୟକ ପାଇଁ relevant ହେଲା ଲାଷ୍ଟ
ଆଉ 3 ଜଣ ପାଇଁ କହିଲେ
ଆଉ 3 ଜଣ ଲେଖନ୍ତୁ ଆର 3 ଜଣଙ୍କର ଆଣନ୍ତୁ ଲେଖନ୍ତୁ this criminal offense has been filed by 4 appellants, that is Bibhishan Naik, Balaram Naik, Giriram Naik and Haru Majhi. Hello? Right, order dated 22/2/2010, comma.
all are released.
Giriram Naik and Haru Majhi, comma, appellants number 3 and 4 have been directed to be released on bail. Similarly, as for order dated 17/7/2013, appellant number 1 and 2, namely Vibhishan Naik and Balaram Naik, have been directed to be released on bail. The IAC Kasipur, the Superintendent of Police Rayagada has forwarded the report of IAC Kasipur Police Station dated 28/2025, in which the well-being of only appellant number 1 is mentioned, that he is staying in his village. But nothing has been stated about the well-being of the rest 3 appellants, that is appellant number 2, 3 and 4. Stop. Let the Land Council for the state obtain specific instruction regarding the well-being of the aforesaid 3 appellants through Pirauji ଆମେ ସେ ଅର୍ଡରଟା କରିଥିଲୁ ସୁପରିଟେଣ୍ଡେଣ୍ଟ ଅଫ ପୋଲିସ ଯୋଉଟା କି ଲେଖା ହେଇଛି ଉପରେ ମଧ୍ୟ ସେ କମନ ଅର୍ଡର ହେଇଥିଲା ଆଉ 241/15/2025 ଠିକ ଅଛି well-being of through the Superintendent of Police Rayagada. Free copy of the order be handed over to the Land Council for the state. The 11 तारीख रखुछु list this matter on 11th of item number 5. Mayor Mr. Das. Oh, Asha, you are Mr. Nalinikant Das. Mr. Nalinikant Das, Land Council for the appellants, is present, but he is also not able to sit the modular project. He is also not able to think about the well-being of the appellant number 2, 3 and 4. Next item, 6.
Item 6.
The report is there, both the appellants are alike, Niyamaji and Daniyamaji.
These under let's give us a look on the periodic report of the Superintendent of Police Council, which indicates that both the appellants, namely so-and-so, are alive. They are residing in their respective villages. अच्छा या किए करेंगे मिस्टर गोपीनाथ पाड़ी ना अच्छी कुआड़े गले रेगुलर क्रिमिनल अपील टा वकालत नंबर 5 देते मिस्टर गोपीनाथ पाड़ी एपी मिश्र वांशो खबर टी दियो बुदान आगे मैटर सब अधा ही रहा एमनु खबर देले तो जो आरो मैटर जो कोई जो डीपी धर एचएस मिश्र है आउ ये गोपीनाथ पाड़ी लिखे खबर तापर डाकुन
Item 7.
In the last processing, after the order be confirmed. So we have communicated on 26/9. Pray for some time, take instruction about the confirm.
नौ फास्ट ऑर्डर है
Again,
अपनी टाइम ले ले तापर 25 नौ उठिला पुनी टाइम ले ले
I pray for one opportunity today I am coming.
रिप्रेजेंटेशन टाको डिस्पोज
आगे।
करिया पई ऑर्डर हेतिला 7/8/2024 रे from the date of production of the certified copy within 3 months ଆଉ सी प्रोड्यूस कले 12 ना 2024 ताने आपनकर डेट सरी जाउची 12/12/2024 भितर अब ये करी कम्युनिकेट करियो आसिकनी अक्टोबर मास हे गरान
Pray for next week only today.
The land council for the petitioner is present, land council for the state submits that as per the last order dated 25/9/2024. Instruction has already been sought for regarding the status of representation filed by the petitioner before the opposite party. However, no information has been received and the matter will be taken up next week. Put of this matter, Amar Guruvar Rakhiva, put of this matter on 23rd October 2025. Yes. Okay.
Item 8.
This case also the representation was direct to consider within 2 weeks. That I pray for 23rd also, the letter was
Yeah, for last order for the our status of representation, say, 3 तारीख ना शुरू
8 9 dita na kon 9
8 and 9.
8 and 9.
9 both
2025 रे 8टा आसिबो और ये आसिबो
Item 10.
Now should keep it away. They prepare on 23rd. Representation. They are quoted in the page 3.
ये रिप्रेजेंटेशन के बाद
Again,
कौन ला
and we have intimated but not reached, instruction not received. I prepare on 23rd.
माने स्टेट ये जो लिटिगेशन केमती बढ़ुची देखो दिस इज द ग्लेरिंग एग्जांपल
Yesterday I also telephonically contacted with the director in this regard. So since there is order and previous orders, number of orders has been communicated and complied. This is not. Today,
cases गुड़ाक adjournment होची most of the time at your instance
and
cases are being filed because of the non-compliance of the order. जेतियो content petition list है सब गुड़ाक वर्षे हलानी order pass हलानी and you are representation टाउ dispose of अपन करना.
then 23rd
Don't think that we are helpless, but we are giving you time. That does not mean that कौन पाई से content petition file गला. अपन तो time limit दिया ही थी, बट representation टाउ 3 मास समय दिया ला. ଆପଣଙ୍କୁ representation dispose of କରିବାକୁ ତାକୁ order ଟା communicate କରିଦେବେ ତାପରେ ସେ ତାର
dispose of କରି communication.
But 23rd, I will ensure that I will.
The whole thing is that one should give priority to all these matters. Before the moment it is received, the very next day he should have gone for this.
Yes.
And for months together he is ignoring it.
representation ଟା ଦେଇଛନ୍ତି
Let any order be passed.
ତାକୁ dispose of କରିବା ଗୋଟେ ରିଟ୍ ଫାଇଲ କଲେ ସେଥିରେ
But
ଅର୍ଡର
what-
ହେଲା ତାପରେ ପୁଣି ତାକୁ dispose of କରି ବର୍ଷେ ପକେଇ ରହିଲେ ସିଏ ପୁଣି ଗୋଟେ contempt petition ଫାଇଲ ହବ
But on 23rd, I will ensure that.
all these cases if you do not comply the next date will call for the
Yes, sir.
personal appearance of these fellows
No.
personal appearance
My lord,
and the rest of the thing you know
that may be observed,
And
because since number
give
of
this
intimation
signal
has
to all.
given. Number of intimation has.
we may
given.
pass very adverse order same order for them to 23rd October.
Item 11.
And we have already had a stated to the learned advocate general also. That you should see that this is the, he has assured that these things will be done. Chief Secretary has also been. Yes, item number 11.
No, I don't have 24. Bench 25th. Bench on 24th.
24th, this bench is not functioning.
Item 11, the order of the Honorable Court has not been complied. 3 months of time.
Last of the prayer for amendment is allowed. We are also sent the letter on 26/9/25. So we are not received that complaint. 23rd week.
Amendment petition allow ही
Consolidated plan also.
कहीं लिखो
On 25/9/25.
ठीक है here is the consolidated content petition which was filed as for the order dated 25/9/2025. This content petition has been filed by the petitioner Vijay Krishna Tripathi for non-compliance of the order dated 5/11/2024 of this court passed in WPC number 23480/2024. In the aforesaid order, we in the operative portion we directed the executive engineer Jajpur Irrigation Division Jajpur the opposite party contemner to dispose of the representation filed by the petitioner dated 13/5/2024 within a period of 3 months from the date of production of the certified copy of the order. If the same has not been disposed of, and the result thereof to be communicated to the petitioner within a period of 2 weeks of taking the decision. From the argument made in the content petition, it appears that the petitioner submitted the certified copy of the order of this court before the contemner on 11/11/2024. And the copy of the application has been annexed as annexure to It further seems that the petitioner issued reminder on 28/2/2025 by registered post to the party container, and the postal receipts have also been annexed as Annexure 3. It is the contention of the Land Council for the petitioner that in spite of the communication made, he has not received, the opposite party has not complied the order of this court. Land Council for the state submits that instruction has already been sought for.
26/9/2025.
26/9/2024, 26/9/2025
25.
regarding the status of representation. And the matter will be taken up next week. Vote of this matter on 23rd October 2025. Yes.
Item 12.
Compliance of the order passed by the Senate for disposal of application of 28A by the special LO.
25/9/25, the amendment petition has been allowed. Not received that consolidated.
IS and
नहीं, consolidated content application receive करना है, copy देना जरा। होना कुछ नहीं।
same day daily IS and कौन
कौन सी?
आइएटा दे सुन आइए
आइए में माँ consolidated ये टा देवे ना, आइए टा आलो है ला।
IS and अटैच करके देखिए सही
देखो check करो। देखो the as for the order dated 25/9/2025, consolidated content petition has been filed. The reason of the said petition should have been just previous GMT order. Are you having that copy or not?
No.
Let a copy of the content petition be served on the Land Council. On the Land Council of the state.
in course of the now you know
There's no change beyond solve the in-court problem. To sit some time to obtain instructions regarding the compliance of the order dated 13/1/2025 passed by this court in WPC number so on so on. এটা ওটি অধিকা সময় দଉଛୁ যেহেতু ଆପଣ ଆଜି ରିସିଭ୍ କରୁଛନ୍ତି তো let it come ତାପର ୱିକରେ ଗୁରୁବାର ଯୋଉ ଅଛି 30 ତାରିଖ ଆସିବ ଏଟା 30th of October 2025.
So far as item 13 is concerned, we are already communicated the letter to the collector, but that sanction has been not made, but the file has been processing for the giving that amount. Because of on that village, the sanction has not been made. Because that
after ensuing Puja holidays to apply this court about the status of the disbursement of the compensation amount.
since
There is a-
2012 land has been acquired order has been passed in slack 1 year manner
the Fauzdar also sent the letter to the
last occasion
collector.
compliance report filed
ଆପଣ ଚିଠି ଇଏ ତାକୁ ପଠେଇଲା ସିଏ ତାକୁ ପଠେଇଲା ତା ଦେହରେ ଆଙ୍କର କିଛି ନାହିଁ ସେ ତା ଜମି ଯାଇ compensation ପାଇବା ଦରକାର ସେଟା ହଉଛି କଥା
ଆଗ ମୌଜାଟା ସେ ଯୋଉଟାକ
last occasion compliance report filed dear lordship have a glance last occasion compliance report filed in spite of that they have not yet complied measure order has been passed since last 1 year land has been acquired since 2012
ଯାଜପୁର କଲେକ୍ଟର ଦରମା ବନ୍ଦ କରିଦବା କଣ କହୁଛନ୍ତି
2012
giving the last
ଏପର୍ଯ୍ୟନ୍ତ ତାଙ୍କ ପଇସା ନ ଦେଇଛନ୍ତି ଦରମା
I frame a letter of that last time we given because of their moved the file for the sanction because of ସେଇ ଗାଁ ପାଇଁ sanction ଆସିନଥିଲା ସେଇଥିପାଇଁ that
100% ପାଇ ସାରିଲେଣି
ଅନ୍ୟ ଗାଁ ପାଇଁ ଆସିଥିଲା ବୋଲି ଦିଆଯାଇଥିଲା 3,31 ଲକ୍ଷ ଅନ୍ୟ ଗାଁ ଗୁଡାକ ଆସିଲା ସେଟା ଦିଆଯାଇଛି ଆଙ୍କରି ଆସିନଥିଲା ବୋଲି
କେବେ
ଫାଇଲ
ରଖିବା କୁହନ୍ତୁ ଆପଣ କେବେ ଡିଲେ ହବ ଆପଣ କେମିତି କଣ ଫାଇଲ ଏକ୍ସପିଡାଇଟ୍ କରିବେ ତା ଜମି ଆକ୍ୱାର ହେଲାଣି ବୁଝୁଛନ୍ତି ତ ଡେଟ୍ କେବେ 2012 ରୁ ଜଣଙ୍କ ଜମି ଆକ୍ୱାର ହେଲାଣି ତାକୁ କମ୍ପେନସେସନ ଏପର୍ଯ୍ୟନ୍ତ ମିଳିଲାନି 13 ବର୍ଷ ହେଇଗଲାଣି ଆପଣ ଫାଇଲ ମୁଭ୍ କରୁଛନ୍ତି
30th, that's the last one.
Felling which will.
Land council for the state fixed for an adjournment. To obtain instruction regarding the disbursement of the compensation amount to the petitioner. As per the order dated 24/9/2024,
Yes.
24/9/2024, passed in WPC number 23592 of 2024. Order very clear ଅଛି ତା ଦେହରେ
Right.
ତାର land କେବେ acquire ହେଲା କଣ ହେଲା Huh?
On that basis, the inquiry has been made and the other also written the letter to the
ଆପଣଙ୍କର କେତେ ଜମି ଯାଇଛି? ହଁ 17 ଡେସିମେଲ ଜମି ନେଇଛନ୍ତି ଆପଣ
70.
village ଅସଳପୁର ଖାତା number 112 acquired there. अब ये ऑर्डर देखो सबमिशन कौन थिला से पैराग्राफ 5 रे an additional government advocate submitted that the compensation amount has already been deposited with the opposite party and the same shall be disbursed within a short period. This statement was made in September 2024. The clear harassment. So we are bringing it on 23rd 10/2025. Next.
Item 14.
No. What happened about these three matters? Forgot the legi. Item number 2. Mr. DP
associate
DP item number 3 रे HS मिश्र ଆଉ ଗୋଟେ କୋଉଥିରେ
ରଗଡ଼
ନାଇଁ ପାଢୀ ନା 6 ନମ୍ବର ପାଢୀ ଗୋପୀନାଥ ପାଢୀ ଆସିଲେ ତାଙ୍କୁ କହିବେ immediately matter take up on
also kindly fix a date for final hearing.
कितना नंबर आइटम
Item 2 years.
केबे को वर्षर क्रिमिनल अपील को वर्षर क्रिमिनल अपील
2002.
2002 रो केते वर्ष हे गेला केते वर्ष हैला 23 years बेल ले पड़ी चंदी तापर टाइम नहीं चलते The regular appeal, it's not a jail criminal appeal. Otherwise, you would have disengaged you.
Last.
Uh-huh.
That's a last chance.
No question of last chance. We are taking up other matters since those are part-heard matters. Thereafter, we will take up the matter. Ask Mr. Dhar to remain present. Will not adjourn this matter. Will not write anything that in 2002 matters we are granting adjournment for to another date for hearing. The man is alive and is enjoying bail for 23 years now and will not grant further time. Yes. Call the matter.
Item 14.
May I please, Your Lord? I an application is a criminal appeal, my lord, where I have challenged the order of convictions of just like 2 accused persons out of 6 accused persons. Altogether, 6 accused persons were charged sheeted, my lord, in a case under section 302 by 34 IPC. The allegation is, my lord, these
6 persons.
6 persons. My lord,
Please come to the judgment.
my lord,
Charge sheeted 6 persons.
charge sheeted 6 persons,
That's it.
four persons were
4 persons face trial.
first trial, my lord, 2 persons
absconded.
subsequent to first trial.
Oh, they,
So it was split up, my lord, because they were absconded, subsequently 2 persons first trial, my lord. These 4 persons who placed trial initially, my lord, that in that trial, my lord, 2 witnesses were examined, some witnesses were examined, my lord, 19, and PW 19, my lord, and 10, my lord, who are the PW 10 with the eyewitness, my lord. On the basis of his statement, my lord, there were conviction in respect of 2 accused persons and 2 were acquitted out of 4, my lord. 4 accused persons who were placed under trial on the basis of the statement of PW 10. 2 persons were acquitted and 2 persons were convicted. The case was split up against the rest too, because I have mentioned because
We find from the judgment, Mr. Nayak, that Lakshmidhar, Subhas, Akshay and Titu, they faced trial.
yes,
Out of which who were acquitted?
acquitted, my lord. Yeah, acquitted. We are acquitted, my lord.
But who were key?
Lakshmidhar and Titu. They were convicted, the rest 2 were acquitted.
हाँ, चलो ये paragraph 24 of the judgment रे कुहा होची, Akshay, Swain and Subhas Rautrai. Yes. They were acquitted.
Yes, right. Titu, Lakshmidhar Swain, Titu alias Deepak Kumar Mahanti were convicted under section 302 by 34 and sentenced to under RI for life.
Okay.
And my lord, the eyewitnesses who were examined, in that case, his name is Prasant Kumar.
In this case, there are 2 eyewitnesses.
One eyewitness, my lord.
Dita Kuchunti?
Prasant Kumar Behra, who was examined with PW10.
Sole eyewitness.
Yes, ma'am.
Is PW 10.
Yes, ma'am.
कौन था ना कौन?
Prasant Kumar Behra.
Prashant Kumar Behra. Yes.
On the basis of his statement that he said that I have seen these 4 accused persons, my lord, and also attributing the overtax in respect of those accused persons, my lord, they were convicted, my lord. 2 were acquitted and 2 were convicted, my lord. These 2 who were convicted, they were sentenced to under RI life for life. They have preferred this appeal, and in appeal they are on bail, my lord. So for the other case is concerned, the 2 persons against whom the trial was split up because they were absconded. Subsequently, my lord, their trial was commenced in ST number
57 by 2002.
57 by 2002. So in that case, my lord, those with the eyewitnesses who were there, my lord, they were examined here in this case, my lord.
Eyewitness on PW 10 was examined again.
Yes, yes.
So he is examined as PW
13. PW 13.
Okay. 30. 13. Asha.
And this PW, my lord, in the subsequent trial, said that I do not know about the incident.
So what?
So my respectful submission, my lord, if these witnesses on the basis of whose statement we are convicted in the first trial,
I do not know.
I do not know anything about the incident. Nobody, he has not implicated anybody. He has stated that he doesn't know anything about the matter. We were declared hostile. My respectful submission, my lord, the very same witness, on the basis of whose statement he said that this is the man and this is the man who was assaulted.
No, Mr. In view of section 145 of the Evidence Act, suppose in the first case, the witness would have stated that he did not know anything. And in the second, as an eyewitness, you would have stated all the details. Then you could have confronted the previous statement, which is recorded in the earlier trial, to the witness that, look, you were examined earlier in ST number so and so, and in that case, you have stated like this. So, in the subsequently, if he has given
Therefore, since I had no occasion,
the scope of confronting,
since I had no occasion to raise that point, my lord, because that was a subsequent trial. By that time, we are already convicted, and I have raised this point.
In law, are you permissible to confront now? Suppose you have filed an application to adduce the additional evidence. So additional evidence means you want to confront a statement that has been made by this eyewitness subsequently.
Yes, ma'am.
How can you, under which provision? Under which provision?
My lord, I have filed this certified copy of the statement.
No.
On
So please come to one for the
391, my lord.
No, 391 is
Additional evidence.
Please, 391 definitely additional evidence.
We want to,
But
we
we
have
have come to the Indian Evidence Act, section
we
145.
have filed the
which is-
judgment. I pray, my lord, the judgment may be utilized as the additional evidence in this case because the judgment, the certified copy of the judgment, no question of examining them again.
So why have you filed this IA number 1 of
That-
2020?
that
Because
is-
that has come for orders now.
That is,
You-
yes,
you-
ma'am.
your-
That is why I filed the judgment.
Let us see that,
May be accepted. That may be accepted. Not the witness to be examined and confronted.
IA number, the IA টা বার করলে you file IA number 1 of 2020. What is your prayer in this IA?
Yes, ma'am. My lord, to accept the judgment of the previous case, my lord.
Not previous case, it is a subsequent case.
Yes, my lord, in this appeal, because the appeal is the continuance of the
No, no,
trial, my lord.
Under
Appeal is the continuance of the trial.
provision. How can it be taken as an additional evidence? 145, let us read the language. A witness may be cross-examined as to his previous statement made by him in writing.
We are not on the statement, my lord.
That you are not. So definitely that prayer is not there, that you
No.
want to further put some question. Now the question is, let us say that subsequently the trial in respect of some accused persons whose cases were splitted off, those were taken off. And in that case, a different set of evidence was adduced. We
Yes.
can say
Yes.
maybe that some of the witnesses were common in both the cases, or all the witnesses are common, but they were examined and an order of acquittal was passed.
Yes.
So under
I have filed the certified
No,
copy
but
of the.
why this provision?
My lord,
Under why this provision? This is a judgment in RAM. It's an
391.
open judgment.
391,
It's a open,
Additional evidence,
it's a
my lord.
judgment. Anybody can have it.
additional
It
evidence.
is
my lord.
only to be referred.
If additional evidence I can, my lord, file during the trial, my
Under
lord.
which provision?
Appeal is the continuance of the trial, my lord.
No,
The
this
appeal
is
during the
there.
appeal,
We are not on enabling provision of 391.
my lord.
We are on the subject of a subsequent event.
Because the subsequent event, my lord, now I have got the chance, my lord, because there was no chance for me to raise the subsequent event at any stage.
So we are
Because
only to
because
appreciate.
that trial is previous.
So we are, according to you, we are to appreciate the findings of the judgment.
Yes.
That's all.
Yes.
Not beyond that.
Yes, my lord. That will solve my lord. That's all. That's all.
So why it is in 391 then? Why under 391?
Otherwise, there is no scope, my lord. How can you lordship take
No,
notice of the?
you can file it. We'll refer it. It's a judgment.
I have filed it.
That is what I am saying. That this is a judgment.
Otherwise, the question would have been to me by the bench, my
No,
lord.
no, no.
What is the provision?
No, no.
So I have utilized the provision of section
This
391.
no, you cannot utilize this provision. This provision is specifically for a purpose. You see,
May I submit my lord, trial? It is stated, it is said that my lord, appeal is also the continuance of the
we
trial.
are not in
In the
dispute.
appeal, if I
sir.
draw your lordship's kind attention that this is the situation, your lordship would not allow
We
me
do
to.
not dispute on that.
Yes, ma'am.
According to us, this being a judgment can be referred. That's all. Even
Yes,
if it is not under 391. If you would have filed it as a memo also and asked us to refer, that's all.
If
It's
your
a
lordship,
judgment.
if your lordship would refer that judgment, that will serve my
We
purpose.
cannot make part of
We
this.
cannot-
We cannot make part of this
any
appeal.
observation that has been made
Yes.
in that
We are not
judgment,
bound by that.
we cannot
No, I have filed the certified copy of his statement, my lord.
We cannot
We
even
cannot
do
take that.
what that
Not because the
witness has
observation in
stated.
that judgment, my lord, I don't say, I have not read, my lord, but the observation of that judgment should be utilized here.
Then
I have
what is-
only filed.
Why this judgment will be at all looked into? If you are not,
No, I judgment, not judgment, my lord. I have, my prayer is not judgment. My prayer is not to accept the judgment, my lord. My prayer is to accept the certified copy of the witness who has stated a
Certified
quite
copy of
different thing in the subsequent.
Statement of the witness. Accordingly, that means to bring it otherwise. If not directly, otherwise.
the thing which cannot be directly prohibited, how can indirectly it be admissible and will admit it as a mark it as an exhibit? That statement, what you want, their certified copy is to be marked as an exhibit on behalf of the defense. How can it be? That is strictly prohibited under 145. Because the, you see, why it has been stated that suppose previous statement why this thing is that, in this case, let us say this PW 10 at the first trial would have said, no, I do not know anything
Yes.
about it. Subsequently, he comes up and states about whatever he has stated in the 161, states absolutely to that, stick to that. So definitely the defense counsel will put a question that, look, you are the person who was examined in the earlier trial in respect to the co-accused persons as PW10, and in that statement which was given in court, you have stated that you do not know anything about the occurrence. The witness could have got an opportunity to explain that, yes, I have stated so because at that point of time I was under threat, I was under this, that. So thereafter, so this,
But
that is the reason why the scope is there that you are to confront the previous statement so that the
But here the
witness.
situation is the reverse, my lord. In the first year they have
Simply by
implicated,
the law
but in the
does not
second trial,
permit.
my lord, they said I do not know anything.
This law
There is no
does
scope.
not
There is
subsequent
no scope, my lord.
Here
There
the
is-
evidence is complete. Here
Yes.
the evidence is complete.
Yes.
Yes. How can you confront a subsequent statement he may say?
No,
had
no,
not.
I have not prayed that. I do not want to confront my lord. As your lordship has rightly said.
No,
that
no.
I can
If
file a
you don't,
judgment
if you
or
can,
with a memo.
no, if you cannot confront, then how can you utilize it
How can we utilize it?
without
On
giving
what
an
purpose?
opportunity to the
It will
person?
just be kept on record,
Yes.
that's all.
My lord,
If you are filing it, it will be kept on record, that's all.
if
We
my lord-
cannot even look into it.
my lord,
We
if-
cannot say that she has stated like this in the subsequent trial.
Once I have brought your lordship's notice, once I have brought your lordship's notice that a witness on the basis of whose statement I have been convicted.
Please not,
This is the-
don't show us the law. We
This
do
is the
not want-
conduct, this is the conduct of the statement.
No,
This is the
show us
conduct
the
of
law,
the
Mr.
witness.
Naik, show us the law that any statement which has been made in a subsequent trial, if the witness says that he has
No
not
knowledge or
been
anything.
show us the law.
Your lordship can see 391.
391, we know 391 what it is. You show us the law, a citation that this statement, subsequent statement will be admissible and the court can look into it and can also utilize it to disbelieve the statement of PW10 as an eyewitness merely because he subsequent trial in respect of some of the co-accused persons state that I do not know anything about the case.
Your lordship may kindly 154. I'm sorry, 155. Subsection 3. By proof of a former statement.
Where is that statement? Let us see that. Where is that statement? Let us.
What is the formal statement?
He was examined as PW10
Yes,
in the subsequent trial.
yes.
Yes.
You don't look 13 minor. Chief Examiner,
This
I do not
previous
know.
statement has also been rightly confronted by the public prosecutor in
Yes.
paragraph number
Yes,
4.
yes.
That in the earlier sessions trial,
Yes,
you have stated like this.
yes,
So what is his explanation?
I do not remember.
I do not remember.
yes.
So what?
Is it open for him?
No. I do not remember what. Even if he does not remember, the record stands there.
Yes.
The record says that he was examined on oath and stated on oath that he has.
But in the chief examiner, he said, I do not know anything about this case.
No.
So after I draw this, your lordship's attention, that the witness who said, I do not know anything about this case in a former trial, my lord. In the subsequent
No,
trial.
former trial say I do not know कहूँगा subsequent trial
Yes, sorry, subsequent.
Yes.
That is what
In
it
the
was.
subsequent trial, my lord, the witness who said, I do not know anything about this case, and on the basis of his statement, my lord, 2 persons have been convicted for life.
What is the utility of a judgment which was,
We are only trying to impeach the conduct of this witness, my lord, your lordship may kindly see.
No, yours is not a former statement. No, yours is a subsequent statement. 155(3) speaks of what? By proof of former statements.
Yes,
It's a subsequent statement.
Yes,
That's
ma'am.
the whole thing.
yes, my lord.
Yes, that is why.
But at the stage of appeal, my lord, now this is firmer.
No, that you cannot say. That you
My
cannot.
lord, because
That
appeal
is how
appeal-
it is. The legislative intention is very clear. It is only in respect to a former statement that can be done, not a subsequent.
Former statement and a former statement now, my lord, at this stage of appeal.
Will be the subsequent become former here.
At this,
in-
yes,
no.
yes.
We have passed
Yes,
a
ma'am.
detailed judgment on that in a death reference.
Yes,
case.
I have gone through that, man. I have gone through that. I have gone through that one. Your lordship is very recent in the death reference case that will be.
That happened, we also remanded it to the trial court because in the previous statement.
Yes, ma'am. That is
he
death
has-
reference number
that is the
one.
reason why.
I have brought your lordship judgment, man. That is death reference number 1 of 21.
That is there.
Once I draw your lordship's attention, so law doesn't prohibit that your lordship should close the eyes, man. We should close the eyes because whatever he has stated.
No, law prohibits.
Where?
That is the whole thing. Former.
Former,
Law
former.
speaks about former.
Now, my lord, now,
At
my-
any stage.
Now, no,
At
not
any stage.
Not at any stage. Now
No.
we can say it's former.
That means we are, no.
While deciding an appeal, my lord, when deciding an appeal, if I draw your lordship's kind attention.
Sir, you are again forgetting. It is the same thing where in a suit as in original trial, according to you. We are in original trial according to you.
It's a continuance of the trial.
So it is not a former statement. The whole issue is former, not subsequent. The law accepts former, not subsequent. That is the whole.
But this
Merely because the time changes, it doesn't change.
time changes, position changes. Trial
But
over.
yes, because
appeal
the-
pending.
because the
Trial over,
position
appeal pending,
changes,
Appeal
this-
pending.
the
In the appeal,
posi-
appeal it is not prohibited.
Because
for
the
me, my lord, to draw
position
your lordship's
changes,
attention.
the statement cannot be former or subsequent. It is former means former, cannot be subsequent. Even if the position changes.
That judgment please show us, we have analyzed also in that light, that death reference case, I think.
Yes, ma'am.
Pass on. We have failed with all these matters.
Yes, I have seen that. I have read your lordship's judgment.
Recording the additional evidence of BW1 Nita Soba with the informant by way of further proceeding along with questions mentioned in the questionnaire to be put in the interest of the stated. BW1 examiner is also in the court of Orissa in this state said all the appellants were found guilty. The sentence was important. The line trial was submitted and the proceeding to the section of the there is no registered as. The appellant also different appeal against the general before the judgment. The judgment was delivered on. Matter was remanded back to the line trial to the direction. Large charges for customer value. It is stated, further stated in the petition that on 14/11/2017. It also, BW1 was examined. It is stated as examined before the principal magistrate juvenile justice court trial. As BW 12 bonds, which are in the spirit of this one, the evidence which she produced before the JJP was completely contrary to her evidence ready. So answering the trial, this one. It is further stated that in the petition that after the remand of the case, statement already exists for Lakota, a juvenile is suffering. It was tried in the court of the learned session just once in criminal test, and PW1 was recalled and examined on 2/3/2020.
Is it already there?
A statement at the and even though the Learned Defense Counsel was given opportunity to cross-examine PW1, but the contradictions which are appearing in our evidence with reference to this.
And the-
That was discussed and that. So it is very clear, Mr. This is totally different case.
Yes.
Because you see, very plain and simple
Then
thing.
it was
By the
discussed.
time this court remanded the matter again and asked this addition of the charges, PW1 was given to be further cross-examined. At that point of time, already a statement of PW1 before the principal magistrate juvenile justice board was in existence.
Even
And
during
he,
trial.
huh?
Even during the trial,
Huh.
it was there, he did not see it.
ନାଇଁ ନାଇଁ ପ୍ରଥମ ଟ୍ରାଏଲରେ ନଥିଲା ଏଇ ସେତେବେଳେ ଏକ୍ଜାମିନ ହେଇଥିଲା 31/7/2000 ପ୍ରଥମରେ
Hmm.
31/7 ତାପରେ ଡେଥ୍ ସେଣ୍ଟେନ୍ସ ହେଇଗଲା ତାପରେ ସେ ମ୍ୟାଟରଟା ରିମାଣ୍ଡ ହେଲା ଏଇ କୋର୍ଟରୁ ଯେ ତମେ ଏଇ ଚାର୍ଜ ଫ୍ରେମ୍ କର କରିକିନି ରିମାଣ୍ଡ ହେଲା ପରେ ତା ଭିତରେ କଣ ହେଇଛି
ଏଇଟା ହେଇଯାଇଛି।
ହଁ ଏଇଟା ଡେଲିଭର୍ଡ ହେଲା କେବେ ନା 5/11/2019
So by then, this has been taken subsequent trial.
ହଁ ସବସିକ୍ୱେଣ୍ଟ ଟ୍ରାଏଲ ହେଲା ବେଳକୁ ସେ ଏଇ ଯୋଉ
Previous
ଷ୍ଟେଟମେଣ୍ଟଟା
statement
ପଢିଆ
is-
ଯାଇଥିଲା ଏଇ ଯୋଉ PW1
This became a previous statement.
ସେଇଟାକୁ ଯେତେବେଳେ ମାନେ
Not
ଇଏ
a
ହେଲା
subsequent statement, it is previous.
ପ୍ରିଭିୟସ୍ ଷ୍ଟେଟମେଣ୍ଟ ହେଲା ନା
For all
ହଁ
purposes, it has-
ସେତେବେଳେ ଏକ୍ଜାମିନ ହେଲା 2/3/2020 ସେତେବେଳକୁ ଏ
17
ଷ୍ଟେଟମେଣ୍ଟ
ହେଇଗଲା।
6/17 ଏକ୍ଜିଷ୍ଟେନ୍ସ
So it's a
ତାକୁ
previous
ସେ
statement.
ପଚାରି ନଥିଲା ସେଇଥିପାଇଁ
In
ଆମେ
any case, it is a previous statement
हाँ।
and only. Fatwa statement is different, the पूरा law.
Totally different.
Concept of law is different.
if you want to cite any other decision please cite otherwise we'll dispose of this IA.
Lordship may call it.
Look, IN number 1 of 2020. This application has been filed for adducing additional evidence and to accept the statement of Prashant Kumar Behera, who was examined as PW13 in ST case number 57 of 2002. Stop. Mr. Dharanidhar Naik, land senior advocate, submitted that out of the 4 persons who faced trial, namely Lakshmidhar Swain, bracket according to appellant number 1, Subhash Rautrai, comma, Akshay Kumar Swain, and Tutu alias Deepak Kumar Mahanti, bracket according to appellant number 2. Akshay Kumar Swain and Subhash Kumar Rautrai, Subhash Chandra Rautrai, were found not guilty for the offences under section 302-2404 by 34 of the IPC, and they were acquitted. So far as the 2 appellants, namely Lakshmidhar Swain and Tutu alias Deepak Kumar Mahanti are concerned, they were found guilty under section 302 by 34 of the Indian Penal Code and sentenced to undergo imprisonment for life. It is the further contention of the land senior advocate that the conviction of the appellants is mainly based on the evidence of the solitary eyewitness PW10 Prashant Kumar Behera. Stop. He further submits that in this case, on completion of investigation, charge sheet was placed against not only the 4 persons who faced sessions trial number 375 of 1999, but also against ଆଉ ସେ ଯୋଉ absconder ଥିଲେ କିଏ ତା ନାଁ କଣ?
ବିଜୟ ପରିଡ଼ା ବିଜନ କୁମାର ପରିଡ଼ା ଆଲାଜ ଟୋନିଆ
ତା ସେ ଜଜମେଣ୍ଟଟା କାହିଁ ନା ଦେଇନାହାନ୍ତି? ହଁ
ଜଜମେଣ୍ଟ ଇଜ ୱିଥ୍
ଆଚ୍ଛା ଏ ନାଁଟା କୁହନ୍ତୁ ଖାଲି
ବିଜନ
Vijay Kumar Porida alias
ବିଜନ
Vijana Kumar Porida
Bijan
alias
Kumar Parida,
ବିଜନ କୁମାର ପରିଡ଼ା and
Naresh Kumar Ita,
Naresh Kumar
Naresh Kumar Baitharu,
Boitalu alias
ନରେଶ କୁମାର ବୈଠାରୁ
alias Diga,
ନରେଶ କୁମାର ବୈଠାରୁ
alias Liga.
Diga. ଆଉ
Alias
ସେଟା
Diga.
ହଉଛି ବିଜନ କୁମାର ପରିଡ଼ା alias Tanya.
ଆଚ୍ଛା ତାର ନାଁଟା ଲେଖିଦିଅନ୍ତୁ କାନ୍ୟ who faced ST case number 57 of 2002 were the absconders were subsequently taken into judicial custody and faced trial in ST case number 57 of 2002 and by judgment and order dated 14/3/2003 they were acquitted of the charges under section 302/404 of the Indian Penal Code. Mr. Naik further submits that the said eyewitness Prashant Kumar Behera bracketed PW10 was examined in the subsequent trial, that is ST case number 57 of 2002 as PW 13 and while giving his evidence he has stated that he did not know anything about the case. PW13, while giving his evidence as PW13 in the said case, on 3rd February 2003, he stated that he did not know anything about the case. And accordingly, he was declared hostile by the prosecution. And not only his previous statement given to the police was confronted, but also his statement given as PW10 in ST case number 375 of 1999 was confronted to him by the London public prosecutor. The evidence copy of the witness, according to Mr. Naik, of the sole eyewitness is very relevant and for the just decision of the case. And since in the subsequent trial, the witness has resigned from his previous statement and has stated that he did not know anything about the case. Therefore, such evidence be accepted as additional evidence in the interest of justice. Stop. In support of his contention, order dated 3/5/2024 passed in IN number 1036 of 2024, in DSREF number 1 of 2021, and CRLA number 750 of 2021 were placed before us. This petition has been filed under the provisions of 391 of CRPC.
And it may be given my kind of endorsement.
391 CRPC empowers the appellate court to take further evidence or direct it to be taken. The entire section is quoted here in below, code 391. Stop. On going to the order dated 3/5/2024, which was placed by Mr. Nayak and Senior Advocate, we find that we allowed the application filed by the appellants under section 391 CRPC for recording the additional evidence of PW1 Milita Savar, the informant of that case, by way of further cross-examination, and also allowed the questions mentioned in the questionnaire to be put to PW1. Since in the previous statement given by PW1 before the Principal Magistrate Juvenile Justice Board, Rayagada, in connection with a juvenile, Jamsu Savar, his statement was different than what she deposed on recall on 2/3/2020, and the learned defense counsel could not confront the statement made by that witness on 14/11/2017. Stop. In the present case, the situation is completely different, in as much as PW10 was examined on 14th June 2002 in ST case number 57 of 2009. এটা কেতে নম্বর সাক্ষী এক্সামিন হলো? PW10 কেবে এক্সামিন হয়েছে? এই কেসের PW10 কেবে এক্সামিন?
2nd August 2000.
হ্যাঁ, এটা এটা P75 of 99.
তো সেন্টার 2/8/2000 এক্সাম দিচ্ছে।
নাই সে ট্রায়াল কোর্ট রেকর্ডটা বার কর।
2000
रिटर्न हुए
তার
ডিপোজিশন
प्लीज have patience.
ট্রায়াল করে দশ করছেন।
In this case, the PW10 was examined on 2nd August
2000.
2000. Whereas in the subsequent trial in which he was examined as PW 13, the date of examination is
3rd February 2003.
See, in 2003.
In 2004. 3rd February 2003.
3rd
February 2003.
मैंने आउट के देखो PW 13 पर से एग्जामिन है ना 13 का डिवीजन
Fiction study.
PW 13 का पर पहले की
ଆଇରେ ଅଛି ଆଇ ସେଥିରେ ନାହିଁ
date.
ଆଇରେ ଅଛି
PW 13 हाँ 3rd February 2003 है ना
Which is subsequent.
that is which is a subsequent statement. Section 145 of the Evidence Act clearly states about the cross-examination as to the previous statements in writing. And it states that a witness may be cross-examined as to the previous statement made by him in writing or reduced to writing, and the relevant to the matters in question, without such writing being shown to him or being proved. But if it is intended to be contradict him by the writing, his attention must, before the writing can be proved, be called to those parts of it which are to be used for the purpose of contradicting him. Stop. Section 155 of the Evidence Act, which deals with impeaching the credit of the witness, it also states that the credit of the witness may be impeached inter alia by proof of the former statement inconsistent with any part of his evidence which is liable to be contradicted. Stop. Therefore, the prayer that has been made in this interim application to accept a subsequent statement of the sole eyewitness which was given on 3rd February 2003 as PW 13, in which the witness has not supported the prosecution case, is very in our considered opinion cannot be allowed. Accordingly, we are not inclined to accept the prayer made in this application. The interim application stands rejected. Yes, next. The matter be placed, yes, come for ready for hearing. When you want, Mr. Nayak, place this matter next week for hearing. Yes. Item number 15.
Item 15.
Yes, what modification, Mr. Jena, you want? कौन देखছেন modification कौन लिखছেন? Modify the order letter and direct the petitioner to approach the learned additional assistant commissioner under section 41 of the Swan Suit. आगुरु कौन थिला जिला?
The commissioner of endowment. Whether the DT
ये कौन determine करी पारी वो ये जो question था whether DT is a
No,
Uh,
but wait,
41 করবে।
For the
Additional.
Sumit Bosco's case that
No, no, additional letter. That is the
দেখি,
only,
commissioner
ইয়েটা দেখি
that is
ওড়িশা ହିନ୍ଦୁ ରିଲିଜିୟସ୍ ଏଣ୍ଡାମେଣ୍ଟ
the,
ସେ ଆମେ ଡାଇରେକ୍ସନ ଦେଇଥିଲୁ ସେତେବେଳେ ଏଣ୍ଡାମେଣ୍ଟ କମିଶନରକୁ ସେ କହୁଛନ୍ତି ଯେ ଆଡିସନାଲ ବୋଧେ
with regard to the privacy, he has the only power.
assistant commissioner বলছি
Additional assistant, additional assistant, with assistant additional. Any other.
আচ্ছা this was one is a public and so on and so on. That's really the
as the commission is not made a party, that's why the paragraph 3 of the IA that mentioned that the commission of endowment was neither made a party nor a copy of the writ served to the council was usually returned with the commission of the endowment. Because the order dated 5.
No, no, commissioner of endowment with the party no.
No, party not, no, second.
The key to party na. Endowment is not at all a party. Okay. Other than this, you let him
If the
make a party.
ଆମେ କ'ଣ କହୁଛୁ without
ଆମେ
expressing any
ହଁ।
opinion on merit, it is observed that in case the petitioners approach this so and so,
No, we are independently we are giving this.
we are ଆମେ କହୁଛୁ ଯେ
ठीक ଅଛି, why modify?
So that not
The endowment commissioner can give it to the assistant endowment.
ହଁ,
I'm
we
not
can
doing that.
refer it the case. IA number so and so, this is an application for modification of the order dated 5/8/2024 and for a direction to the petitioners to approach an additional assistant commissioner of endowment better under section 41 of Orissa Hindu Religious Endowment Act. None appears for the petitioner after going through the averments taken in the interim application. We don't find any merit in the interim application. Accordingly, the same stands dismissed. Yeah. Content application out actually, set up one. Postal tracking report showing the item delivered to the sole opposite party.
My lord, item 16, in fact, it has been delivered. Your lordship may kindly permit it to appear me through virtual mode. In fact, the postal receipt has been delivered. Postal copy of the order of this Hon'Ble Court has been delivered. There has been a meeting with the petitioner. In the meantime, day before yesterday. Now that report is awaiting, and I am also awaiting the Vakalatnama, your lordship, to appear in this case. And it has been already been sent to me by postal. And I have instruction to appear.
You are supposed to enter appearance for the
Indian oil.
No, contemner.
Yes, lordship. Yes, lordship.
So when you will file
Contemner.
your appearance memo or Vakalatnama?
I will file my Vakalatnama within 7 days, lordship. There has also been a personal meeting with the petitioner.
So, okay, you will file. When we will place the case?
10 days after, lordship.
10 days after.
Lordship.
No,
SS Kashyap, Satya Kashyap, lordship.
Mr.
Satya Sindhu
Kashyap, Land Council, appearing in the original mode submits that he has instruction to appear for the contemner opposite party. I would a line like pay you the postal tracking report showing that the items delivered to the sole opposite party at flag B. Stop. And he will file Vakalatnama by next week. He further submits that what is going on in negotiation or what?
Yes, personal hearing. Personal hearing is already been given to
hearing,
the content.
Is going on in the matter as per the order of this court, and the matter may be placed after 10 days so that he will apprise about the development in the case. Mr. Vibhuti Kesari Biswal, Land Council for the petitioner is present. Put up this matter. We are placing this matter on 30th of October.
Obliged, lordship. I'll take instruction in the meantime.
30th of October 2025. The name of the Land Council for the opposite party is reflected in the cause list. Yes, so what about these two items? Item number 3, H.S. Mishra. Mr.
My item is item number 2.
Yes, Mr. Dhwan.
Nice.
23 years after your associate is seeking for an adjournment.
No, man. I think they are not responding. Whatever it may be, my lord.
They are now alive,
They are alive, my lord, as per the report.
right? So with
My lord, I was going through.
they are
my
on
lord.
bail.
I have not gone through in the real. I do the appeal. However, my lord, I was going through the judgment
Yes.
delivered by the Law and Trial Court.
Yes.
If my lord will see paragraph 8 and 9 of the judgment, it will be seen that Law and Trial Court has best conviction on recovery and extrajudicial confession.
Paper looked at one.
Internal fees file.
Sole appellant.
Sole appellant. Other appellant has been acquitted. Sorry, other accused who
As it appears from the impugned judgment, two
Madam.
persons face trial.
Madam, two
They are Jataram Ho and Sitaram Ho,
Madam,
and under section 302/34.
Madam.
ठीक है. And the order was passed, accused. So far also on. So what is that acquittal part?
That is paragraph 10, melodies.
सीताराम जो हो acquittal वाला
Madam.
वो लिखा है जी. अच्छा last one. Paragraph 10.
10.
The accused Pagal alias Sitaram Ho is not found guilty and is acquitted of the charge under section 302 and set at liberty. So ये हला 302 रे हला. Yes. Just place the FR and we'll go to it. Page number 23.
Paperwork is not with me, my lord.
अबे paperwork दियो.
Sit, whatever.
What paper दियो. अपन पर अच्छी तो paper.
I have got a certified copy of the
No, you just on the right to get the paper. Please come to page number 23.
my lord. That Musri
Manglar Singh.
Manglar Singh PW कहते हैं.
PW6. PW 1. Page 32. My lord, ମୁଁ ବ୍ରାହ୍ମଣୀପାଳ ଗ୍ରାମର ୱାର୍ଡ ମେମ୍ବର ଅଟେ। ଗତକାଲି ପଦ୍ମ ପୋଖରୀରେ ମାଛ ମରା ଯାଉଥିବାରୁ ମାଛ ଆଣିବା ପାଇଁ ଯାଇଥିଲି। ପ୍ରାୟ 3:30 ବେଳକୁ ଫେରିଲା ବେଳେ ବାଟରେ ମୋର ଆମ ଗାଁର ଭାଇଧର ମୋ ସହିତ ଦେଖା ହେଲା ଓ ସେ କହିଲା ଯେ ପ୍ରାୟ ଅଧଘଣ୍ଟା ପୂର୍ବରୁ ପଦ୍ମ ପୋଖରୀରୁ
ନାଁ କଣ?
ଗଜେନ୍ଦ୍ର।
ଗଜେନ୍ଦ୍ର ଅଛି। ଭାଇଧର ସହିତ ଦେଖା ହେଲା।
କହିଲା ଯେ ପ୍ରାୟ ଅଧଘଣ୍ଟା ପୂର୍ବରୁ ପଦ୍ମ ପୋଖରୀକୁ
ଟିକେ ଭାଇଧର ହେଲା PW5। ତା ସହିତ ଦେଖା ହେଲା।
ସେ କହିଲା ଯେ ପ୍ରାୟ ଅଧଘଣ୍ଟା ପୂର୍ବରୁ ପଦ୍ମ ପୋଖରୀକୁ ଫେରି ଦେଖିଲା ଯେ ତା ଘରକୁ ଲାଗିଥିବା ଖଳାରେ ବେତେଇର ଗଜେନ୍ଦ୍ର ମରି ପଡିଛି ଓ ତାର ଗୋଡ ହାତ ଇତ୍ୟାଦିର ଅନେକ ରକ୍ତାକ୍ତ କ୍ଷତ ଅଛି। ତେଣୁ ମୁଁ ତା ସହିତ ସେଠାକୁ ଗଲି ଓ ଦେଖିଲି ଯେ ଗଜେନ୍ଦ୍ର ଭାଇଧର ଖଳାରେ ମରି ପଡିଛି। ତାର 2 ଗୋଡ ଡାହାଣ ବାହୁରେ ଅନେକ ହଣା ହୋଇ ରକ୍ତ ବାହାରୁଛି। ସେ ସ୍ଥାନରେ ବହୁତ ରକ୍ତ ପଡିଛି। ଭାଇଧରର ସ୍ତ୍ରୀ ଠାରୁ ଜାଣିଲି ଯେ ଗଜେନ୍ଦ୍ରର
ସ୍ତ୍ରୀ କିଏ?
ଭାଇଧର ସ୍ତ୍ରୀ I think we're PW3. Can it be taken up day after tomorrow? madam?
ନାଇଁ ନାଇଁ ପଢନ୍ତୁ ପଢିବ ସାଙ୍ଗ ହେଇ ପଢିବ
ଓହୋ ବାଇଦର ହେଲା ଚମ୍ପା
by the
PW3
PW3
Three.
PW
Page 36.
ପେଜ 30
ବାଇଦର ସ୍ତ୍ରୀ ମାନେ PW3 ହଉ ହଁ ଜାଣିଲି ଯେ ପଢନ୍ତୁ ବାଇଦର ସ୍ତ୍ରୀ ଜାଣିଲି PW3 ଟୁ ଜାଣିଲି
ଆଜ୍ଞା
ଗଜେନ୍ଦ୍ର ଗଜେନ୍ଦ୍ର ର
ଜାଣିଲି ଯେ ଗଜେନ୍ଦ୍ର ଜଟାରାମ ହୋ ସୀତାରାମ ହୋର ଝଗଡା ହେବାରୁ
ହଁ
ଜଟାରାମ ଓ ସୀତାରାମ ବୁଢିଆରେ ଗଜେନ୍ଦ୍ରକୁ ହାଣି ମାରିଛନ୍ତି।
ଆଚ୍ଛା
ତାପରେ ଆମେ ଆମ ଗ୍ରାମ ରକ୍ଷୀକୁ ଯାଇ ଖବର ଦେଲୁ। ସେ ମଧ୍ୟ ଆସି ଦେଖିଲା ରାତି ହୋଇଥିବାରୁ କାଲି ରିପୋର୍ଟ ଦେଇପାରିଲୁ ନାହିଁ, ଆଜି ଆସି ରିପୋର୍ଟ ଦେଉଛୁ।
ଆଚ୍ଛା ତ ବର୍ତ୍ତମାନ ସିଧା ପଳେଇ ଆସନ୍ତୁ PW3 ର ଏଭିଡେନ୍ସ
He has been. I know both the accused persons. This occurrence took place during last Makar festival time. I was not present at the time and I cannot say about the occurrence.
ଷ୍ଟେଟ୍ ହେଇଗଲା
My lord.
ଆଚ୍ଛା ତାପରେ ପଳେଇ ଆସନ୍ତୁ ଏକରୁ ଗୋଟେ ଗୋଟେ ସାକ୍ଷୀ ଓଲଟେଇ ଯାଆନ୍ତୁ
Ek has also been disbelieved by the trial court.
ନାଇଁ ଟିକେ ପଢିଯାଆନ୍ତୁ ତାପରେ ଦେଖିବା
Know all the accused persons. This occurrence took place 1.5 years back. I am the ward member of my village. When Gajendra died at our village, I had been Padmapokari to purchase fish. One buyer of my village told me that Gajendra had already died the threshing floor. He called me to that place. I went to the threshing floor. I saw the dead body of Gajendra and Mark's injury on the leg. I had also observed blood in that threshing floor. We went to Gramarakhi and told him about the death of Gajendra. Durga Bagal and Gramarakhi came and saw the dead body. Next day we went to PS. I verbally reported the matter and it was reduced into writing. I have signed in that report on the advice of police. I signed on it. Exhibit 1 is the FIR, Exhibit 1 is my signature. This one.
so in this statement also he has not stated to have
No.
heard from PW3 about the occurrence
Court has taken note of by the recovery, statement of the accused pertaining and accordingly acts has been recovered.
from PW3 okay now you come to PW2
Two. I know both the accused persons and the Gramarakhi of that village. This occurrence took place last year during Bakar festival. PW1 told me about a murder which took place at his village. I came to the village of PW1 and found the dead body of Gajendra at the threshing floor of Vaidara. The deceased Gajendra was not known to me previously. I saw the injury marks on the leg of the deceased. I also found
so nothing relevant nothing relevant third
I went to PS with PW1.
third
He lost the affair. The dead body was lying at the spot. I have not ascertained the cause of death.
come to PW4
fourth people
I have not seen the seizure of
I have not
I
seen the
think
seizure.
top person
Five.
just so that a wife of
I have not seen the deceased.
Huh?
I have not seen the seizure of blood. I have not seen the seizure.
Yes.
I do not know these accused persons.
Gajendra K, it was the wife of the deceased.
I had went to the forest and on my return I
Sat on the veranda on my house. Please read it up, PW6.
I do not know these accused persons. This occurrence took place during the last Makar festival time. I had been to the forest and on my return I sat in the veranda of my house. Yoda and Robbie arrived near me and used to kill the language. They gave threat to kill me and they told that they had already killed my husband. I came to village Brahmanipalli. I saw my husband in the house of Vaidara in dead condition. His body was lying in a threshing floor of Vaidara. He had the injury on hand and leg. The drops of blood were also found near the dead body.
So who are these Joda and Rabi?
they are the Joda Rabi hela praye accused.
No, he said that I do not know the accused person.
He doesn't know. She doesn't know.
So one Joda and Rabi told.
Yes.
Not the accused.
Not the
because he is not identifying the accused.
Yes. But trial court has relied upon this PW6.
Okay, we'll see that. Then
Then IO, my lord.
Huh?
I-
PW
PW seven is the
I-
IO.
My lord.
took
part
charge of
IO.
the
I
investigation.
examine the witness for so and so.
SFSL ଖାଲି ପଠେଇଲା
ତାପରେ next PW
ADM
My seizure of
postmortem
my lord, हाँ.
postmortem ଛାଡନ୍ତୁ ଏଇଟା
ନାଇଁ
ତ-
there is one lacerated for ସେତିକି କେବଳ
Oh, this is not disputed that it's a homicidal death.
My-
Fracture of one
Married,
to
married,
one,
married.
okay.
then PW
Then PW 9
9.
is the main
I
IO.
was OIC, yes. On that day, I registered the case and the report lodged by Mangalal Singh of Brahmanipal. During investigation, I examined the informant. Exhibit 1 is the affair. Exhibit 1/2 is by endorsement with signature. I examined other witnesses. I visited the spot and held inquest over the dead body of Gajendra Dhadai. Exhibit 5 is the inquest report and Exhibit 5/1 is my signature. I dispatched the dead body for postmortem examination through constable number 278. Exhibit 6 is the dead body challenge. I searched for the accused persons, but they were found absconding. On 16/1/2000, 2000, I arrested accused Jataram Ho and Sitaram Ho. I examined accused Jataram Ho, made disclosure statement. Exhibit 7 is the disclosure statement made before me. Exhibit 7/1 is the
Exhibit
Exhibit 2/1 is the seizure of seizure list. Exhibit 2/2 is my signature. MO1 is the act seized by me under Exhibit 2/1. I also seized earring clothes of Sitaram Ho. So Exhibit 3/1 is the seizure list. Exhibit 3/2 is my signature. MO2 is the brown color napkin. On 17/1/2000, I forwarded the accused. On 12/2/2000, I examined witnesses. On 26/4/2000, I made overcharge of the investigation to SI Mahapatra due to my transfer. On 15/1/2000, I visited the spot and prepared spot map. Exhibit 8 is the spot map. Exhibit 1/1 is the signature. I seized sample earth and blood stain.
So this evidence is only that leading to discovery
Leading
of
to
that act.
discovery, madam. That is
And
the,
as it appears from the C report that Tangia was a blood group, human blood A group मिलेला.
madam.
Page number 50 is the
Madam.
C report
Madam.
and that has been marked as an exhibit. এটা कितने number
Yeah.
exhibit marked हुई है?
এটা उत्तर লেখা এটা 10
Just wait.
Exhibit 10. Report of this. Yes, Mr. State Counsel.
Madam.
What is the evidence that suppose let us say one Tangia was recovered at the instance of this appellant.
Madam.
So, and it was found to be containing a group of blood.
Madam.
But how do you correlate with unless you prove that the deceased was having a group of blood and that this acts has got some link with the offense committed, then merely by seizure of the Tangia, how can you convict a person under 302? What is the other evidence?
No.
both the independent witnesses to leading to discovery have not stated out.
Not.
Where is the
Nothing is there. How can a conviction under 302 will be maintained on this? Who is the trial court? And for this matter, you are seeking for an adjournment.
No, I had not seen the
No.
I was in court number 15 and
11. Criminal appeal number 20 of 2002. The appellant, along with Sitaram Ho, faced trial in the Court of Law and Session Judge Noidun Jarikoda in Sessions trial number 212 of 2000. For offense punishable under section 302(34) of the Indian Penal Code on the accusation that on 14/1/2000 at about 3 p.m. in furtherance of their common intention, they committed murder of Rajendra. he committed murder of Gajendra Dalsi. So, the London Trial Court, by the improved judgment and order dated 2/5/2002, though acquitted the co-accused Sitaram Pope of the charge under section 302/34 of the Indian Penal Code, but found the appellant guilty under section 302 IPC and sentenced him to undergo imprisonment for life. The prosecution case, as per the first information report lodged by PW1, Mangalal Singh on 15/1/2000 before the officer in charge of Sarat police station. In short, is that he had been to
Is the word member?
he was the ward member. He had been to
Padma
pond,
Pokhari. Padma Pokhari.
locally known as Padma Pokhari, to catch fish. And at about on 14/1/2000, at about 3:30 p.m. while he was returning home, on the way, PW5 Biger home and told him that the dead body of the deceased was lying
Facing field of
on the thrashing
field.
field of door
Bettei.
of the house of the deceased. No? Dar ghorku lagithiba. Mane kar ghorku lagithiba.
Bettei.
Huh?
Tar-
Mane PW5
Gora, by the
the house of PW5 with injuries, bleeding injuries on the leg and hand. Getting such information from PW5, PW1 rushed to the place and found the dead body of the deceased with injuries
lying on the seat.
lying in the threshing floor and on his legs and hands. He got the information from PW3 Champa Himbram, the wife of the wife of PW5, that both the appellant, both the accused persons, namely Jataram Ho and Sitaram Ho, quarreled
With the
with the deceased and also assaulted the deceased by means of a budia
axe.
and killed him. PW1 intimated the matter to the grammar Rakhi and who also came to the spot and stopped and saw the dead body. On the basis of the report furnished submitted by PW1, Sarat PS case number 3 dated 15/1/2000 was registered under section 302/34 of the Indian Penal Code against the appellant Jataram Ho and the co-accused Sitaram Ho. Stop. PW9 Bono Bihari Mahanti, the officer in charge of the Sarat police station, after registering the case, took up investigation of the case, examined the informant bracket PW1 and other witnesses, he visited with held inquest over the dead body of the deceased, and prepared the inquest report Exhibit 5, dispatched the dead body for post-mortem examination through constable, searched for the accused persons but found them absconding. On 16/1/2000, he arrested the appellant, so also the co-accused Sitaram Ho. And while in police custody, the appellant stated to have given a statement regarding concealing the weapon of offense, that is axe, and accordingly his disclosure statement under Section 27 of the Evidence Act was recorded via Exhibit 7, and ultimately at the instance of the appellant, the axe was recovered, axe bracketed on the M1 was recovered as per seizure list Exhibit 2/1. The wearing apparels of the co-accused Sitaram Ho was seized as per the seizure list Exhibit 3/1, and on 17/1/2000, both the appellant as well as the co-accused were forwarded to court. Some more witnesses were examined by the IO, and on 26/4/2000, he made over the charge of investigation to PW8, PW7, Damodar Mahapatra, the successor, who on completion of investigation, who during course of investigation sent the seized article to SFSL Bhubaneswar for chemical examination, and on completion of investigation submitted charge sheet under Section 302/34 of the Indian Penal Code against the appellant, to also be co-accused Sitaram. Stop. But after submission of charge sheet, the case was committed to the Court of Session after complying the due procedure, where the Learned and Trial Court framed the charge as aforesaid, since both the accused persons pleaded not guilty and claimed to be tried. Accordingly, the sentence trial procedure was resorted to establish their guilt. Stop. In order to prove its case, the prosecution examined nine witnesses. The prosecution also exhibited 11 documents, and it also proved two material objects. MO1 is this and MO2 is this. The defense plea of the appellant is one of denial, and it is stated that on account of political hostility, he has been falsely implicated in the case. The Learning Trial Court, after
Believing on extrajudicial concussion coupled with the
recovery of Learning Trial Court, after analyzing the evidence of the doctor, came to hold that the prosecution has proved that the deceased died a homicidal death, and relying on the evidence of extrajudicial confession made report PW6 and the medical evidence adduced by PW8 and the recovery of MO1 at the instance of the appellant as stated by the IO bracket with PW9, though acquitted the co-accused of found the appellant guilty under Section 302 of the Indian Penal Code. Stop. the Mr. D.P. Dhol and senior advocate appearing for the appellant submitted that the conclusion arrived at by the London trial court is erroneous and there is no legal evidence on record to sustain a conviction under section 302 IPC against the appellant. It is stated that it is argued that though in the first information report it is stated that the informant came to know from PW3 that the appellant and the co-accused assaulted the deceased during the trial, but PW3 has been declared hostile by the prosecution. And even in the PW1, the informant has not stated in his evidence to have got any information from PW3 that she is an eyewitness to the occurrence. So the Land Council submits that the PW6, who is stated to be witness to the extrajudicial confession, has simply stated that one Judah and Robbie told him that they have killed PW6 Jasuda Dalai, the widow of the deceased, has stated that one Judah and Robbie disclosed before how to have killed the deceased, have killed her husband. However, she has stated that he did not know the accused persons. Therefore, it cannot be said that the appellant came before him, her, and makes the extrajudicial confession. Stop. The Mr. further argued that even though it is accepted that one axe was seized at the instance of the appellant, as per the evidence of PW9, the IO, and the C report also indicates that human blood of group A was found in the said weapon, will be evident from the C report exhibit 10. But since the prosecution has failed to establish any link between the said weapon with the crime in question, mere recovery has got no importance in this case. And even though it can be said that the prosecution has proved the homicidal death of the deceased, but in absence of any other evidence to establish the complicity of the appellant in the crime in the murder of the deceased, the conviction of the appellant is not sustainable in the eye of law. Mr. Sarat Chandra Pradhan, and Additional Standing Counsel, on the other hand, supported the judgment. Stop. Adverting to the contention raised by the Land Council for the respective parties, let us first see whether the prosecution has successfully established that the deceased died a homicidal death or not. Apart from the inquest report, Exhibit 5, the evidence of the doctor bracket PW8 who conducted postmortem examination is very relevant on this aspect. PW8 was the surgery specialist attached to SD Hospital, Udara, and he conducted postmortem examination over the dead body of the deceased on 16/1/2000, and he noticed the following injuries. Quote kar degan, so and so. And he opined that there was so and so, and he proved the report, Exhibit 4, and further opined that the cause of death was due to severe bleeding and shock. Nothing has been brought out in the cross-examination of PW8 to challenge the evidence regarding the homicidal death of the deceased. Mr. Dawes also has not challenged this aspect. Therefore, we are of the view that on the basis of the evidence of the Dr. PW8 and the inquest report, the London trial court has rightly arrived at the conclusion that the prosecution has successfully established that the deceased has died a homicidal death. Coming to the other evidence on record, though it appears that the informant has mentioned in the FIR that he came to know from the wife of PW3 that both the appellants assaulted, both the appellant as well as the co-accused assaulted the deceased by means of a budia during course of quarrel. But in the evidence, PW1 is completely silent that any such information has been received by him from PW3. Moreover, PW3 has stated that he was not present when the occurrence took place during Mocker Festival, and he could not say anything about the occurrence. The prosecution has declared him horse as hostile. Therefore, the evidence of PW3 is no way relevant for the purpose of finding the complicity of the appellant in the crime in question. PW1 and PW2 are the post-occurrence witnesses, and they have simply stated to have come to the spot and found the dead body of the deceased lying with some injuries. Stop. The PW6 Josoda Dolai, who is the widow of the deceased, stated that he did not know the accused persons. However, she has stated that the occurrence took place during Mocker Festival time, and he had been to the forest, and on her return he sat on the veranda of her house, and at that point of time one Joda and Ravi arrived near her and used filthy language, and they also gave threat to her and told her to have killed her husband, bracketed deceased. And she further stated that she saw the deceased was lying in the house of Baidar in the thrashing floor, thrashing floor of the Baidar, bracketed going to PW5. Stop. In view of the evidence of PW6, it doesn't appear that the persons who disclosed or who made extrajudicial confession before her are the accused persons, in as much as not only the witness has stated that she did not know the accused persons, the prosecution has not also brought on record that the two persons who made disclosure before her are the accused persons standing in the dock. Therefore, we are of the view that it cannot be said that the appellant made any extrajudicial confession before PW6, and the London trial court has committed error in placing reliance on the evidence of PW6 and holding her to be a witness to the extrajudicial confession of the appellant before her. The evidence of PW9, the IO only indicates that after his arrest of the appellant, he made a disclosure statement which was recorded under Exhibit 7 and at the instance of the Exhibit 7. The IO further stated that one axe, that is MO1, was seized by her. The evidence is completely silent that after giving the making the accused disclosure statement, the appellant led the police party and the witnesses to the place where the axe was derived, and at his instance, the axe was seized. Therefore, in terms of this evidence of PW9, it does not, the recovery, the seizure of MO1 does not clearly comes within the purview of Section 27 of the Evidence Act. Even though the chemical examination report indicates that the Tangia, which was seized at the instance of the appellant, was seized as per seizure list, Exhibit 2/1 was found to be containing human blood of group A, but nothing has been established to connect this particular weapon with the offense in question. And moreover, it has not been proved that the deceased was having the blood group of A. Therefore, on the basis of the recovery of MO1 as per seizure list Exhibit 2/1, it cannot be said that the prosecution has proved the charge under Section 302 of IPC against the appellant. In view of the foregoing discussions, we find that the Lennon trial court was not justified on relying on the so-called extrajudicial confession stated to have been made before PW6, as well as the recovery of MO1 for convicting the appellant under Section 302 IPC. We are of the view that the conviction of the appellant under Section 302 IPC is not legally sustainable in the eye of law, and the same is therefore set aside. The appellant is acquitted of the charge under Section 302 IPC. The appellant is on bail. His bail bond stands cancelled. The surety bond is discharged from his bail bond, and the surety bond also stands cancelled. The rest of the matter will come after lunch.
The report number 17, if it will be not taken up,
Item 17.
No, it has not yet. Even in
you
report.
have also last time directed the Home Secretary to file an
There's
it
the
come?
letters of sitting for more time because they're sending the letter.
Item number 17.
17.
You want some more time?
More, letter 29.
17 order please.
last time you also
Yeah,
directed the
just-
Home Secretary to file an appeal.
Please. Okay, the operating main part of the order, you say. The care of the order.
Detail.
Without bail ରହିଛନ୍ତି।
whereabouts ଟା ଯୋଉ ଅଛନ୍ତି କିନ୍ତୁ ଜଣା ପଡୁନି।
The Land and Council for the state seeks some more time to obtain instruction as per the order dated
16/9.
16/9/2025. Mr. A.K. Acharya, Land Council for the appellants is present. Put up this matter. Keep it up your
29
put up this matter. No,
29?
29. Mangalwar or Guruvar.
30th.
Place this matter on 30th of October 2025. Number 3, Mr. H.S. Misra.
I pray for an adjournment on behalf of Mr. H.S. Misra. We have no instruction from the appellant.
No instruction gone. It's a jail criminal appeal, no instruction gone. He is alive. If the Mr. Misra is not interested, then we can engage somebody else.
No, he is interested, but he is out of station for today.
Oh, no instruction gone. Jail criminal appeal 2002 मसीहार. First of all, why will adjourn? Number 2, instruction आधेर कौन दरकार? आमे तो मागिलु instruction आसिला से बंचिची. Argument करिवे 302 रे life or हेजी. I don't know, private brief is na kon apon koibe no instruction. If you are not interested, tell us, we can engage somebody else because the panel list is with us. Huh?
Time now.
No time, no. We cannot write in 2002. We cannot mention in the order sheet. This is special bench constituted by as per the order of the Honorable Supreme Court. And in 2002 matter will jail criminal appeal. Will grant adjournment to why we will write it that we are adjourning the matter. It is at your instance you are mentioning, or have you talked with Mr. Misra?
Talk with Mr. Misra.
He is not available in Qatar.
Out of station.
When he will return?
Today evening.
I will take up with this on Thursday. Ask him to get ready. We are not writing. Kichi lekhon. Out of matter silabra. Mr. Gopinath Padhinkaro, item number 6. कौन है ला? खबर दी थी ले?
खबर दे
कोटा कौन है? कोटा मिस्टर ओ कोटा ही पास हो रही है हाँ जो मिस्टर रगड़ को कुआ इतला सी तिले तीजों फाइन आउ कोटे
कस्तूरी
हाँ सी कस्तूरी ताकू भी कुआ इतला रगड़ थिले तीजों फाइन ना कौन अपना सी कस्तूरी थिले तीजों फाइन एंटी कौन थिला से बेल ऑर्डर मेंशन 1, 2, 3. 1 and 3 थिले रगड़ आउ कस्तूरी थिले कस्तूरी मैडम थिले अपना नंबर 2 फाइन What about those compliance report? हम जो order टा करथिलु
सबुटा चिट्ठी दिया ହେଇଥିଲା ସବୁ ଚିଠି ହେଇଥିଲା ମୁଁ କାଲି ଗତକାଲି ରାତିରେ ସୁପରିଟେଣ୍ଡେଣ୍ଟ କ୍ରିମିନାଲ ସେକ୍ସନ କୁ ଆମ ଏଜି ଅଫିସର କହିଦେଇଛି ସେମାନେ କମ୍ପ୍ଲାଇ କରି ଆମକୁ ଦେବେ
ଆପଣ ଆମ order ଟା ବୋଧେ ଇଏ ହେଇଥିଲା ଯେ 2005 ମସିହା ପର୍ଯ୍ୟନ୍ତ ଯେତିକ କ୍ରିମିନାଲ ଅପିଲ ହଉ ବା ଜେଲ କ୍ରିମିନାଲ ଅପିଲ ହଉ ଯଦି ବେଲ ହେଇନି ତାହେଲେ ତାଙ୍କର ଷ୍ଟାଟସ ଆଣିବେ ସେ ଅଛନ୍ତି କି ନାହିଁ ଜେଲରେ ବଞ୍ଚିଛନ୍ତି କି ନାହିଁ ମୋ ୱେଲବିଂ ଯୋଉଟା କୁହନ୍ତି ବା ଯଦି ପ୍ରିମ୍ୟାଚୁଅର ରିଲିଜ ଯୋଉଟାକ ବେଲ ହେଇଯାଇଛନ୍ତି ତାଙ୍କର ୱେଲବିଂ ଏଇ ଟାଇପର ଗୋଟେ କମନ ଅର୍ଡର ହେଇଥିଲା ତ hundreds and hundreds of matters are there ଯୋଉଟାକ ସବୁ ଗୋଟେ ଅଧେ କଣ ଆସୁଛି କୁଆଡେ ଗଲା ସେ କେବେଠୁ ଅର୍ଡର ହେଲାଣି ସେଟା ଆପଣ ପଠେଇ ନାହାନ୍ତି ନା କଣ
ଚିଠି ସବୁ ହେଇଯାଇଛି କେସ୍ ଗୁଡା ଲିଷ୍ଟ କରେଇଦେଲେ ଯୋଉଟା ଚିଠି ହେଇଛି ଆମ
ଆରେ ଆପଣ ସିନା ଆମେ କାହିଁ ଲିଷ୍ଟ କରିବୁ ଶହ ଶହ ମ୍ୟାଟର ଆପଣ ଯୋଉଥିରେ ଇନଷ୍ଟ୍ରକ୍ସନ ପାଇଗଲେଣି ସେଇ ମ୍ୟାଟର ଗୁଡାକ ମୁଁ କୁହାଉଥିଲା ଯେ ଆମର ଯୋଉ ତା ନମ୍ବର ଦେଇଦେଲେ ଆମେ କଣ ଆପଣ ଭାବୁଛନ୍ତି ଲେଟେଷ୍ଟ ସେ 1996 ମସିହାରୁ ଆଜ୍ଞା ଆମେ ଲିଷ୍ଟ କରିବୁ ଆଜ୍ଞା 2000 ମ୍ୟାଟର ଥିବ ମାନେ କ୍ରିମିନାଲ ଅପିଲ ଆଉ ଆମେ 2000 ଟାକୁ ଲିଷ୍ଟ କରିବୁ ତା ଦେହରେ ଦେଖିବେ ଆପଣ କୋଉଥିରେ ଯାଇଛି ନ ଯାଇଛି ଆପଣ ଯଦି କହୁଛନ୍ତି ଯେ ସବୁ ମ୍ୟାଟର ଗୁଡାକ
ମୁଁ ଟିକେ ଡକେଇ ଦଉଛି ସୁପରିଟେଣ୍ଡେଣ୍ଟକୁ ଟିକେ ଆପଣ ତାଗିଦ କରି
ସେ ଅଲରେଡି ବେଲ ଯାଇକି ରିଲିଜ ହେଇଗଲାଣି ଆଉ ଅନ୍ୟମାନଙ୍କ ପାଖରେ ରେଜିଷ୍ଟ୍ରି ଚିଠି ଗଲେ କିଛି ରିପ୍ଲାଏ ପାଉନି ସିଏ ଖାଲି କହିଲା ମୁଁ ଆଜ୍ଞା ମୁଁ ଅନ୍ୟ ଜାଗାରେ ଅଛି ତା ଭିତରୁ ଗୋଟେ କିଏ ମରିଯାଇଛି ବୋଲି ମୁଁ ଶୁଣିଛି ତାକୁ ବହୁତ କଷ୍ଟରେ ଫୋନ କରି ପାଇଲି କହିଲା ମୁଁ ଆଜ୍ଞା ବେଲ ହେଇନଥିଲା ମୁଁ ରିଲିଜ ହେଇଗଲି
ସିଏ ସମସ୍ତ ସେଇଥିପାଇଁ କୁହାହେଇଥିଲା ଏଗୁଡା ସବୁ ଲିଷ୍ଟ ହଉଛି ସେଇଥିପାଇଁ as we find there are three appellants and you are appearing for appellant number 1 and 3. And Madam Kasturi is appearing for appellant number 2. We have taken the instruction that all the three appellants are alive, they are staying in the village. So now this is a 2005 appeal and it is to be.
I'll obtain the paperwork and the next date. Next year.
প্রকাশ প্রধান, ছবিলা ইলিয়াস গৌতিয়া প্রধান এবং মুন্সি প্রধান।
I will also inform to Madam Kasturi.
ये पेपर बुक नहीं ना दी
नहीं
ये
ट्रांसफर उठे पहले
ଆଜ୍ଞା ନାଇଁ ନାଇଁ ଆପଣ ତ କେବେଠୁ ଅଛନ୍ତି ଆମ ବେଲ୍ ଫେଲ୍ ମୁଭ୍ କରିଲେ ଟ୍ରାନ୍ସଫର
पेपर उठा
ବେଲ୍ ମୁଭ୍ କରିସାରିଲେଣି ସବୁ କଲେ
I will obtain the paperwork.
you get it today it must be
today
there
नहीं
hard copy ଥିବ ଆମର
नहीं
paper book
We cannot show that we are adjourning this matter. Hey,
एकदम 8 रे आ गया
এটা হলো ଆମର 16 ତାରିଖ ମାସ 16 এইটা ବି ଆସିବ ଆଉ ଏଇଟା ବି ଆସିବ ଯୋଉ HS ମିଶ୍ର 16/10 ଏଇଟା ତ ଏଇଟା ଲଗ୍ ହେଇଗଲା ନେକ୍ସଟ ହଉଛି ଏଇଟା 6 ନମ୍ବର ମିଷ୍ଟର ଦାସ ଆଉ ଗୋଟେ ମ୍ୟାଟର ଅଛି ମୁଁ ଅଛି ହଁ କଣ ହେଲା ଗୋପୀନାଥ ପାଢୀଙ୍କର କଣ ହେଲା
ଗୋପୀନାଥ ପାଢୀ ଯେ ଟ୍ୟାକ୍ସ ରେ ତାଙ୍କୁ ଖବର ଦେଇଛି ନାହାନ୍ତି ଆଭେଲେବୁଲ
tax ର
ତାଙ୍କୁ ଖବର ଦେଇ ତାଙ୍କ ଜଣେ ଆସୋସିଏଟ ଇଣ୍ଟିମେଟ୍
ये he is an associate of BJM senior advocate so
he is not regularly not
ସେଇ ପଟର ହେଇଥିବ ବୋଧେ ସେ ରାୟଗଡା ଫାୟଗଡା କେସ୍ ହେଇଥିବ ମାନେ କାଶୀପୁର ରାୟଗଡା କି ତାଙ୍କ ଘର ରାୟଗଡା ତ ହଁ ସେ ରାୟଗଡା କେସ୍ so once a tax practitioner is getting a brief of criminal appeal life imprisonment that presupposes that it belongs to his own area. So
I have intimated to his one of his friends that he will communicate him and today evening I also contact him. Phone करते लीजिए कहीं phone पिक अप करेंगे
रखो एटा उसे पर दिन को रखो किछि ऑर्डर लिखिबनी ओटा को हां हां सेति खाली रखिबो ये सब अछंदी एटा अछि रहू तापरे ये ऑर्डर सरला यस मिस्टर दास कोटा कोन कहू
आइटम 18 रे आ गया
हां
अपील नंबर 1 से बेल रिफ्यूज ହେଇଥିଲା
item number state to obtain instruction eta bola
21 order have intimated they have not received 21 order अनुଯାयी
तारा बेल रिफ्यूज ହେଇଥିଲା he already undergone sentence and has been released ଆଉ ତିନି ଜଣଙ୍କ ଭିତରୁ ସେ ଯାହା କହୁଥିଲା ମତେ ଜଣା ନା କଣ ମରି ଯାଇଛି
ନା ନା appellant number 3 Ghasiram was absconding his whereabouts is not known one of the appellant Ghasiram Jarai
but appellant number 1 has already undergone his sentence and has been released
acha
sentence no
sentence মানে এটা লাইফ পিলা
তার কোন পদ্ধতি কইলা তো যাই
তাহলে প্রিমেচুর রিলিজ হইতো
প্রিমেচুর রিলিজ হইতো
দ্যাট কুড বি
খবর
রূপা জরাই
আজ্ঞা কেহি রিপ্লাই দউনাহাନ୍ତି আଜିକାଲି
the appellant number 1 Rupa Jarai has been released from jail and he is presently in his house. Appellant number 2 Bharat Elias Krishna Jarai and appellant number 4 Jagamohan are present in their respective houses at Kotha Baharai. Appellant number 3 Ghasiram is absconded since 2003. His whereabouts is not known. This we have
चिट्ठी देले किछि रिप्लाई रजिस्ट्री चिट्ठी इथर देले किछि रिप्लाई ना जा करियो आर्गुमेंट बोलो जा
he was instruction that it some time to obtain instruction to the consent but आपण पई थिला
now we have intimated that next week today also over telephone I have contacted
appellant number 1 को जा रूपा जरी
तारी
he is in bail মানে who order bail?
No, rejecting from the order.
So bail was rejected ସେଇଥିପାଇଁ ସିଏ
ଆଜ୍ଞା
କହିଲେ ବାହାରେ ଯାଇକିନି ବାହାରେ ଅଛି ମାନେ ପ୍ରିମ୍ୟାଚୁର ରିଲିଜ ନହେଲେ ଯିବ କେମିତି?
ସେଥିପାଇଁ I will contact with you again and
ବାକି ଯୋଉ ଦିଟା ରହିଲେ ଆଉ ତିନିଟା
ଜଣେ ମରିଗଲାଣି ବୋଲି କଣ
ମରିଗଲାଣି କି ମଲା?
ନାଇଁ ମୋର ଏଥିରେ ରିପୋର୍ଟ ନାହିଁ ଆଇସିର ଯୋଉ ରିପୋର୍ଟ ଆଇଛି 14/8 ନାହିଁ
ଆମେ ଅର୍ଡର ବି ଲେଖିନୁ ନା ଆବେଟ କରିଥାନ୍ତୁ ନହେଲେ
ଗୋଟେ ଜୁନିୟର ଲୟରକୁ ଚେଷ୍ଟା କରି ପଠେଇକି ସେ ଗାଁକୁ ଖବର ଯେତିକି ପାଇଲେ ଆଉ କେହି ଆସୁନାହାନ୍ତି ହୋଲ ଡିଫିକଲ୍ଟି ହଉଛି ପୁରୁଣା ଆପିଲ କେହି ଆସୁନାହାନ୍ତି
but Mr. We granted you time on
21/8
21/8 ମାନେ 2 ମାସ ହେଇଗଲାଣି
Today I have
ସେଇଥିରେ ଆମେ 14/8 ର order ଟା ଯୋଉ ଆସିଲା,
next week so that I will endeavor to collect all those updated next week how today I have talked with the IAC concerned again
ସେ ଅର୍ଡରଟି ଅଛି ତ 21/8 ର ଅର୍ଡର
ଆଜ୍ଞା ଆଜ୍ଞା
ସେ ଚାରିଟା ଆପେଲାଣ୍ଟଙ୍କ ବିଷୟରେ ଖବର ନେଇକି ଆସନ୍ତି
ଆଜ୍ଞା
ଗୋଟାକୁ 1 ନମ୍ବରଟାକୁ ଆମେ ବେଲ ହେଇନି ସେ ଯାଇ ବୁଲୁଛି କୁଆଡେ ଗାଁରେ ଅଛି ଆଉ whether he has been released prematurely or not ବାକି 2 ଆଉ 4
ଅଛନ୍ତି
ସେମାନେ ତାଙ୍କ ଗାଁରେ ଅଛନ୍ତି 3 ର କୁଆଡେ ପତାକତା ନାହିଁ ତେଣୁ ଆମେ
ମୁମୁଜା ସାର୍ ଖବର ପାଇଲେ ସେ କଣ ମରିଯାଇଛି ବୋଲି କହୁଛି ସେ
ଏଇ ତିନିଟା।
ଗାଁକୁ ଡକେଇ ଲୋକକୁ ପଠେଇ
2 ଆଉ 4 କୁ ଆମେ ବେଲ ଦେଇଛୁ
ଆଜ୍ଞା
order dated 6/12/2002 ଅନୁଯାୟୀ ବେଲ ହେଇଛନ୍ତି ବାକି ଏଇ ଯୋଉ ତିନିଟା ଯଦି କିଛି ଅର୍ଡର ନାହିଁ ତାହେଲେ ତିନିଟା ଗଲା କୁଆଡେ ଆବସେଣ୍ଟ କଲା ମାନେ ବାହାରକୁ ଯାଇକିନି ଫେରାର ହେଇଛି ତ ବାହାରକୁ ଗଲା କେମିତି କୋଉ ଅର୍ଡର ବଳରେ ଗଲା ସେ କାଶୀରାମ ଜରାଇକୁ ଆମେ ବେଲ ଦେଇନି ମାନେ there is no court bail କୋର୍ଟ କେବଳ ବେଲ ହେଇଛି କେବଳ 2 ଜଣ ପାଇଁ
ଆଜ୍ଞା
ତେଣୁ ସେ 3 ନମ୍ବର ବାହାରକୁ ଗଲା କେମିତି ଆଉ ତାର ଯୋଉ
16/12/2002 ଅର୍ଡରରେ 1 rejected 2 3 4 released
ହଁ 4 ପାଇଁ କିଛି ନାହିଁ ସେ ଅର୍ଡର ନାହିଁ
ନାଇଁ ସେଟା ଆମ
ଏଇ ଯୋଉ ସରି
3 ପାଇଁ
ଓହୋ 3 ଆଚ୍ଛା 1 2 3 4 ଆଚ୍ଛା
1 2
2 to 4 not 2 and 4 ଆଚ୍ଛା ଓକେ 2 to 4 ଆଚ୍ଛା
3 ଜଣ ବେଲ ପାଇଥିଲେ ଜଣେ ବେଲ ପାଇ ନଥିଲା
ଠିକ ଅଛି
ସେ ଜେଲରେ
ୱାନଟା ଯେହେତୁ main allegation against one that's why
ଠିକ ଅଛି
2 to 4
he has as for his
ତେଣୁ ବର୍ତ୍ତମାନ ଶୁଣନ୍ତୁ ଆପଣଙ୍କର 2 ଆଉ 4 ଆପଣଙ୍କର ଗାଁରେ ଅଛନ୍ତି
ଆଜ୍ଞା
କେମିତି ଗଲା ପ୍ରିମାଚୁର ରିଲିଜ ଯଦି ହେଇଯାଇଛି ସେ ଗଲା ତାର ବାକି ଆମେ ଆଉ ଯୋଉ 3 ଜଣକୁ ଖାଲି ଆପଣ ଆଣିବେ 3 ନମ୍ବରଟା ବଞ୍ଚିଛି କି ନାହିଁ
ଆଜ୍ଞା ହଁ ସେଟା ମରିଗଲା ବୋଲି ସେ କହୁଛି
ହଁ ଆଉ 1 ନମ୍ବରଟା ଯୋଉଟା ବାହାରୁ ଅଛି ସେ ଗଲା କେମିତି ତାର ତ ବେଲ ରିଜେକ୍ଟ ହେଲା ତେଣୁ ପ୍ରିମାଚୁର ରିଲିଜ ହେଇଛି କଣ ଏତିକି ଆପଣ ଆଣିବେ
ଆଜ୍ଞା
ତ ଆଣନ୍ତୁ ନେକ୍ସଟ ୱିକ୍
ଏଇଟା ଆମେ ଦେଲୁ 20ଟା ଆମେ ଦେଲୁ ଇଏ ନିଳମ୍ବ ଜମା 20ଟା
ଏଇଟା ଲେଖି ଦିଅନ୍ତୁ ଏଇଟା ହଉଛି ଆଇଟମ ନମ୍ବର 18 Mr. S.D. Das, Land Senior Advocate, is present. Land Counsel for the state, Mr. Mahanti, submits that as for the order dated 21/8/2025, instruction has been sought for, and the matter may be taken up next week. Place this matter on 23rd of October 2023. ହଁ ବାକି ତାପରେ ଆସିଲା 19 ନମ୍ବରଟା କଣ ହେଲା ଏଇଟା 19ଟା 21ଟା ପାଖରେ ଥିଲା
21 ରାୟଗଡ଼ ରାୟଗଡ଼ ଆସିନା not seen or further the top of the
ଗ୍ରୁପ ମେସେଜ କରିଛନ୍ତି ପାସ୍ ଓଭର କରିବା ପାଇଁ ସେ ଆଉ ଗୋଟେ କୋର୍ଟରେ।
ବାଇଶ 23 ବର୍ଷ ପରେ କେସ୍ ପଡିଲା ବେଳକୁ ସେମାନେ ଭାବୁଛନ୍ତି 20 ବର୍ଷ ହେଲାଣି ବେଲ୍ ଅଛନ୍ତି, ସେ ଭାବୁଛନ୍ତି ଆମର କେସ୍ ସରିଗଲା। ତେଣୁ ଆଡଭୋକେଟ ମାନେ ଚିଠି ଲେଖିଲେ ବି ରେସ୍ପଣ୍ଡ କରୁନାହାନ୍ତି, ତେଣୁ ଓବିୟସଲି ସେମାନେ ବି ଇଣ୍ଟରେଷ୍ଟ ଇଏ କରୁନାହାନ୍ତି। ଇଏ ହେଉଛି ରେଗୁଲାର ଅପିଲ କଥା, ଜେଲ୍ କ୍ରିମିନାଲ ଅପିଲ ତ ସହଜେ ଅଲଗା ଇଏ ରହୁଛି। These are all criminal appeals of 2001 and 2. ये जो पेज रे जा अच्छी, हाँ Mention the matter. Rai group है.
ରାୟଗରୁ ଓଭର
Yes,
ମ୍ୟାସେଜ
but ତା ଦେହରେ ଯୋଉ ସେକେଣ୍ଡ ମ୍ୟାଟର ଟା ଯୋଉ ଅଛନ୍ତି ଯୋଉ ନା ତାଙ୍କୁ ଦିଆହେଇଛି ଆମ ଚାର୍ଜ କରୁଛି.
ରାୟଗରୁ ଦିଅ କାରଣ ସେକେଣ୍ଡ ମ୍ୟାଟରରେ କଣ୍ଟାକ୍ଟେଡ ୱିଥ ମିଷ୍ଟର ଜାଲି ସେ ଆସିଲେନି.
ଇଏ କିଛି ନାହିଁ, ଇଏ ଯଦି କରିଦେବେ କଭର ଅପ୍ କରିଦେବେ ତା ଦେହରେ
arising out of one
ଆମେ ତାଙ୍କୁ amicus କରିଛୁ 238
ହଁ ହେଇଯାଇଛି ନା, ଆଉ କିଛି ନାହିଁ.
to argue the appeal on behalf of the appellant କରିଦେଇଛୁ. The name of B Panda is
So what is the other counsel? ଦେବାଶିଷ ଷଡ଼ଙ୍ଗୀ ସେ ନଥିଲେ ଲାଷ୍ଟ ଟାଇମ୍, ତାଙ୍କର ଅଛି ଆଇଟମ ନମ୍ବର 23 ଟା.
ଡାକି ଦଉଛି.
He told that I am ready, I will do it, and it will take small time. So these are the political. 22 ଟା କାର?
ବାଇଶଟା ସେ ଆରଥରକ ଟାଇମ୍ ନେଇଥିଲା ଆଜି କରିବେ. ଗଲା ଥରକ
କିଏ?
ଗୋପାଳ କୃଷ୍ଣ ନାୟକ.
ହଁ ଗୋପାଳ କୃଷ୍ଣ ନାୟକ.
In item 20,
କାଲି ମୁଁ ପ୍ରପୋଜାଲ ପାଇଛି.
yesterday received the
20 Mr. Jena.
date fix ହେଇଗଲେ ଆପଣ କରିବେ.
yesterday you have
Yes,
received.
I have received yesterday.
So get prepared. କେତେ ଜଣ appellant ଅଛନ୍ତି?
5%. 5% charge.
You will argue for all.
Amen.
I don't have.
Amicus curiae.
Amicus.
ବଡ ପେପର ବୁକ୍ ନା ଛୋଟଟା?
Board of Appeal.
ବଡ ବୁକ୍ ଏତିକି ତ ଆଉ.
17ଟା ସେକିବା. 17 witnesses.
17 ଗୋଟେ ହୋଷ୍ଟେଲ ଥିବେ ନା ସବୁଗୁଡା?
1 to 4 hostile.
ଆଉ ତାହେଲେ
ନା I have not gone through. ମୁଁ କାଲି ପାଇଲି, କାଲି ନେଇକି ଏତି ବେଳକୁ ଗଲି. ଖାଲି ଟିକେ ଜଷ୍ଟ.
କେତେ ଦେଖି ଦେଇଛନ୍ତି? ଜଜମେଣ୍ଟ ପଢି ଦେଇଛନ୍ତି ତ?
ନା ନା ଜଜମେଣ୍ଟ ବି ପୁରା ବସି.
ସେ ପର୍ଯ୍ୟନ୍ତ ଗଲେନି?
1 2 କିଛି ତ ନାହିଁ. 3ଟା କଣ କଣ୍ଡକ୍ଟେଡ ପୋଷ୍ଟମର୍ଟମ ଛାଡ଼ନ୍ତୁ.
ସେ ଡକ୍ଟର.
ତ କିଛି ନାହିଁ, ଡୁ ନଟ୍ ନୋ. 5 କିଛି ନାହିଁ.
8 9 10 11 12 ଏଇମାନଙ୍କ ଉପରେ କନଭିକ୍ସନ ହେଇଛି.
10 11 12
8 9 10 11 12 ଯେତିକି ମୁଁ ଖାଲି ପୁରା ପଢିନି, ମାନେ there are lot of developments at the state of trial, exaggerations in the evidence of 8 9 10
8 9 10 ଉପରେ କେସ୍ ବେସ୍ କରୁଛି ନା କଣ?
ନାଇଁ
ଦେଖନ୍ତୁ ଏଇଟା ପରଦିନ ରହିବ ଆଉ କଣ?
ଗୋଟେ ୱିକ୍.
ନାଇଁ ନାଇଁ ନାଇଁ, ଅର୍ଡରଟା ପୁରୁଣା ଜମା. We will not write for adjournment. କିଛି ଲେଖୁନୁ, ତା ଖାଲି ପହର ଦିନକୁ ନେଇ ଆସୁଛୁ.
you start on
Start, ହଁ.
day after you start
Yes.
FIR charge judgment to चल चल.
Yes, Mr. Naidu. The last hearing ହେଇଥିଲା 9-10 ରେ. ଗୁରୁବାର ଦିନ.
Yeah, I am placing the deposition of PW2 madam. Who happens to be the brother of the paternal brother of the deceased man.
Navakutra.
Yes, sir. Navakutra Chowdhury. Is para 3 ରେ କହିଲେ on
ଏଇ ଯୋଉ ଦିଟା କ୍ରିମିନାଲ ଅପିଲ ଗୋଟେକରେ ଦିଟା ଯାକରେ କଣ ଜଣେ ଜଣେ ଆପେଲାଣ୍ଟ?
ଏଥିରେ ସଚିଦାନନ୍ଦ ହଉଛି 280.
CR ଏ ପ୍ରଥମଟା ହଉଛି CR 238/2001.
ଜଣେ
ଆଲିଆସ ସଚିଦାନନ୍ଦ ଖୁଣ୍ଟିଆ.
yes
ତାପରେ ଆରଟା ହଉଛି ନିଖିଳ ମହାନ୍ତି ସିଙ୍ଗିଲ
ହଁ ଇଏ ଜଣେ
କିନ୍ତୁ ଜଜମେଣ୍ଟ ହେଇଛି କମନ ଜଜମେଣ୍ଟ
ୟେସ୍ କମନ୍ out of 4 accused 2 accused faced trial
ଆର ଦିଟା କଣ ଚାର୍ଜସିଟ୍
ନା
ହେଲାନି
ସେମାନେ abscond
ଓ abscond।
ଆଜି ବି ହେଇନି
ସେଇଟା ଜଣା ପଡୁନି
ଓ ଡିସିଜ୍ଡ
ଯୋଉ ଯାଉଥିଲା ସାଙ୍ଗ
ଯାଇଥିଲା ମୋର ସାନ ଭାଇ ବିରଞ୍ଚି ତାର ସାଙ୍ଗ ବାପି ମହାନ୍ତି ଆଉ ସଞ୍ଜୟ ମହାପାତ୍ର ଦେ ଆର PW4 and 8 ତାଙ୍କ ସହିତ ବୁଲେଟରେ ଗଲା ନାଟ ଦେଖିବା ପାଇଁ ତାପରେ ସକାଳେ ତାର ସେମାନେ ଖବର ପାଇଲେ ଯେ ତା ଡେଡ୍ ବଡି ପଡିଛି ବାଦାମ ବିଲରେ ତାପରେ ଯାଇ ଦେଖିଲେ ହଣା ହେଇଛି ପାଖରେ ଚପଲ ମନି ପର୍ସ ପଡିଛି ଆଚ୍ଛା ସେ ଦି ଜଣ କିନ୍ତୁ ଆସିକିନି କିଛି ଖବର ଦେଇନାହାନ୍ତି
ନା
ସେଇ 4 ଆଉ 8 ମାନେ ସେଇ ଦିନ ଯୋଉ ଦିନ ଇଏ ତାପରେ ସେମାନେ
କେତେବେଳେ ଦେଲେ କେଜାଣି କିନ୍ତୁ ଦେଇକିରି ପଳେଇଲେ ଦେଇକିରି ପଳେଇଲେ ରାଉରକେଲା
ନା
ଜଣେ
15
ଜଣେ
ତାରିଖ
ପଳେଇଲା ରାଉରକେଲା
ଜଣେ ପଳେଇଲା
ଭୁବନେଶ୍ୱର
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 4 ଦିନ ପରେ ନା 5 ଦିନ ପରେ ଏକ୍ସାମ
ଭୁବନେଶ୍ୱର ଯିଏ ଗଲା ସେ 15 ତାରିଖ ତା 161 ଷ୍ଟେଟମେଣ୍ଟ ରେକର୍ଡ କଲା ଆଉ
15 ତାରିଖ ମାନେ କୋଉ ଦିନ
ନା ନା 15 ଦିନରେ ହେଇଛି ଯେ ରାଉରକେଲା ବି ଯିଏ ଆସିଲା ସେ ଫେରିକି
ନା ତାର ରାଉରକେଲା ଯିଏ ଆସି 20 କୋଡ଼ିଏ ହେଇଛି
20 ଦିନ ନାହିଁ
ହଁ ଇଏ ଘଟଣା ହେଇଛି
ତାର ହେଇଛି ତାର 164 କଲେ 25 ଦିନ
ନାଇଁ ଘଟଣା ହେଇଛି 12 ଆଉ 13 ରାତିରେ ଦିଟା ସାକ୍ଷୀ ଯୋଉ ଆପଣଙ୍କର ଷ୍ଟାର ୱିଟନେସ୍ PW4 ଆଉ PW8 PW4 ଟା କେବେ
PW4 ଏକ୍ସାମିନ ହେଲା 20 ତାରିଖ
161 just a minute PW4 161 20 3/6 এটা হলো 161 164
25 ଦିନ 6
25 3/6 ଆଉ ଗୋଟେ ରହିଲା PW8
PW8 ଏକ୍ସାମ
161 ଟା କେତେ କଣ
PW ହେଲା 15/3/6
15/3
164 ହଉଛି 18/3/6
164 ହେଲା 18/3
ଆଜ୍ଞା
ଡେଟ୍ ଅଫ୍ ଅକରେନ୍ସ ହେଲା 12 13
ନାଇଟ୍
ନାଇଟ୍
10 AM ରେ ସେ ଯାଇଛନ୍ତି ଇନସିଡେଣ୍ଟ ତାପରେ
ନାଇଟ୍ ତ ଆଚ୍ଛା ଇଏ ଦି ଜଣ ଯାକ ଦେ ଆର୍ well known to the family and they also belong to the same village
yes
କାରଣ ଏଇ ଯୋଉ ଆପଣଙ୍କର
ସେ କୁସୁପୁର ଆଉ
ଇଏ ଗ୍ରାମ ହଉଛି କୁସୁମପୁର ହଉଛି ଡିସିଜ ର ଘର ହଉଛି କୁସୁମପୁର କାରଣ ତା ଭାଇ ହରେକୃଷ୍ଣ ଚୌଧୁରୀ କହୁଛି ନା ମୋ ଘର ହଉଛି କୁସୁମପୁର ପୋଷ୍ଟ ନବା ଆଚ୍ଛା PW4 ଘର କୋଉଠି
PW4 ଆଲିଙ୍ଗ
ଆଲିଙ୍ଗ ଛକ ନା ଆଲିଙ୍ଗ
ନାଇଁ 2 କିଲୋମିଟର ଡିଷ୍ଟାନ୍ସ ତାର ଅଛି ଏଭିଡେନ୍ସ ଅଛି ମାଇ ହାଉସ ଇଜ 2 କିଲୋମିଟର ଡିଷ୍ଟାନ୍ସ
ଥାନା କିନ୍ତୁ ସମାନ ଗୋବିନ୍ଦପୁର ଥାନା ସବୁ
ଗୋବିନ୍ଦପୁର
ଆଉ 8 ନମ୍ବରର
କୁସୁନପୁର
ସେଇ ଗାଁର ସେଇ ଗାଁର ଗୋବିନ୍ଦପୁର ସମାନ ଆଚ୍ଛା
ସେ ଏକ୍ସପ୍ଲେନ କରିଛନ୍ତି କାହିଁକି ତାକୁ ଯେମିତି ଟେରରାଇଜ କଲେ ଅଛି ଏଭିଡେନ୍ସରେ ଅଛି ଏଠୁ ଛାଡ଼ିକି ପଳେଇ ଯା 15 ଦିନ ପର୍ଯ୍ୟନ୍ତ କୁଆଡ଼େ ଆସିବନି।
ନାଇଁ ମୁଁ
ହଁ ଅଛି, ଷ୍ଟେଟମେଣ୍ଟରେ ଅଛି।
ସେ ପୁରା ଆସିଲା ଦି ଜଣକରୁ you come to PW4
PW4 ର ତାର ସେ କହିଛି, କିନ୍ତୁ PW8
PW4 ର ଯୋଉଟା 20 ତାରିଖରେ ଯାଇକି ପଳେଇଲା କୁଆଡେ 20 ତାରିଖରେ ଷ୍ଟେଟମେଣ୍ଟ ଦେଲା because the evidence as we have read on that day immediately after the lodging of the FIR the police came to the village started investigation
161 ରେ PW4 କହିଛି ମାଧ କହିଲା ସ୍ଲାଙ୍ଗ ଲାଙ୍ଗୁଏଜ ଦୌଡ଼ି ପଳେଇ ଯା, ଯଦି 15 ଦିନ ଭିତରେ ଦେଖାଦବ ତମକୁ ମାରିଦେବି।
ये कौन कोई एठी कोर्ट रे आसुनांदी
କୋର୍ଟରେ
PW4 एक्सप्लेनेशन कौन दी ना 161 को देखियो
ନାଇଁ ସେଠି
you come to PW4 evidence page number जो नहीं घटना माडटा कथा कहला कोडी पैराग्राफ 9 रे कोठी हला पैराग्राफ 9 ने सरला गिव एंड सो एंड सो ब्लोज गला तापरे इंजुरी रहला तापरे थ्रेट कथा को जी पारा 11 ने
यस
accused Madhav Kuntia threatened me as well as Baban to kill us if we disclose about the occurrence. He also threatened to destroy the restaurant. By that time, we could notice a light of the vehicle coming from Alingchok. There was Halla coming out so and so. On hearing, we all ran away. I could not trace out Baban who left Gola. You explanation as right. Paragraph number 13. I left motorcycle at this spot
while
running towards Govindpur. Govindpur माने से ही गाँव को
मामू घर को
अरे बाबू ये परा गोविंदपुर गाँटा माने ता घरटा डिमिरी रही थाई पारे लेखु देखुना दी तार फर्स्ट टाइटल थाना होची गोविंदपुर ता निजो घर होची गोविंदपुर हला तनु से कहूची आई लेफ्ट द मोटरसाइकिल एट दिस स्पॉट एंड व्हाइल रनिंग टुवर्ड्स away towards Govindpur. On the next day, I told about the occurrence to PW2, Navakrishna and Prakash not examined. Prakash Uchi, the brother of the deceased
at
Kusunpur village. Thereafter, I went away to Raurkala. I told about the occurrence to paternal uncle Trilochan Mahathi not examined. After 3 to 4 days thereafter, I came from Raurkala along with so and so and told about the occurrence to and so.
This fact was not stated by the PW4 in his 161.
Even also at page 90, the PW8 has stated the fact in the night at about 4
चारी रो एक्सप्लेनेशन कौन देइछि हमें देखुछु 8 को पढ़ी जाउछंदी you come to paragraph 16 cross examination on page 55 on the night of
occurrence I did not say
did not take any side
in my house
in any other house on the night of occurrence I did not stay in my house. I had been to the house of my paternal uncle so and so at Govindpur. Hala, Govindpur PS is 400 meters away from the house of Brajakishore. Brajakishore Mahathi को examine नहीं की?
ना, ये राउरकेला रहे.
ना त्रिलोचन Mahathi.
Yes, sorry.
Brajakishore Mahathi को अपन examine करना है.
ना Braja is not.
तेणु ये लोकटा जो कहूची मु घटना दिन जाइकिनी रातिरे रहिली ब्रजकिशोर महांती को घर
गोविंदपुर
हला मो घर रहिलिनी से माने लिंक तार एविडेंस नाही माने कनेक्टिंग कोरोबोरेटिंग एविडेंस नाही सेड ब्रजकिशोर महांती रिजाइड्स इन सुंदरगढ़ व्हाइल हिज अदर फैमिली मेंबर्स वांट्स तो आपण ता फैमिली रु का एग्जामिन करना दी गला तापरे
ब्रजकिशोर महांती किंतु तार दादा होची त्रिलोचन महांती
के Kuda?
It is Brajakishore Mahanti in the house of Brajakishore Mahanti, but in the 161 statement it is mentioned as Trilochan Mahanti.
एइतियो तार के आउ अन्य दादा थिबे कोन गेला ब्रजकिशोर महांती और त्रिलोचन महांती वे तो दी भाई थिबे ते छाड़ो तापरे 17 आसंदु there is a separate road leading to Govindpur PS from the house of Brajkishore Mahanti. Govindpur PS is about half kilometer away from the public road. I did not try to proceed to PS as I was in a complexed brain. Hala? On the next day morning mane 13 तारीख दिन 10टा बेलू I was relieved from the mentally. ହେଲା तो जो दादा घरे थिला रातिरे रहिला बेलू गोविंदपुर थाना होची 400 मीटर दूर रे जाइकिनी रिपोर्ट देलानी एक्सप्लेनेशन होची मो मुंडो परप्लेक्स माइंड रे थिला तापरे 10टा बेलू मो मुंडो ठीक हे गेला आई एम रिलीव तापरे कोन हला सेठू मध्य थाना को गलानी तापरे आसिला कोठी की हाँ he came to the house of this PW2 से कहूची ने हला जो
paragraph 19 paragraph 19 दे
9 ने कहूची
19
हां 19
yes
चीफ रे भी कहूची ना paragraph 13 ने देखना कि on next day I told about the occurrence to PW2 and Prakash not examined the brother of the deceased और 19 ने कौन कहला अपन
टाइम टा कहला I went to Kusunpur from the house of my uncle on 13/3/96 after 10 a.m. and I reached the house of deceased at about 2 to 3 p.m.
By then 161 of मनकर सॉरी इतलानी ये जो इन्फॉर्मेंट रा हो
ना सॉरी ना कारण इन्फॉर्मेंट स्टेटमेंट रेकॉर्ड हेची आफ्टर 4 p.m.
पेया तो हमें कुछ
हां किंतु PW8 रा स्टेटमेंट काई हैव ग्लास टू PW8
PW2 statement को आसन PW2 what he has stated about to have received any
से तो डायरेक्ट कहा तो पाई चोली को ना सो तो देखिला आ जाई छी सुनी कर जाई
से PW2 कोची पैराग्राफ नंबर 6 को पढ़े आसन पेज 47 My brother Hare Krishna Chaudhary rushed to the police station, lodged the FIR. I was told about the occurrence by PW4 and PW8 on the next day of the occurrence. है next day occurrence माने 13 तारीख दिन है तो वर्तमान तारो ये कहूची हमें जो 4 नंबर साक्षी कहूची जे मु जाइकिनी PW2 को डिस्क्लोज कली
दिन 2 टा हां 13 तारीख दिन 2 टा 3 टा भीतर
3 टा आरो रेकॉर्डिंग हिची हमें देखथुलु से दिन स्टेटमेंट जो PW2 रो स्टेटमेंट रेकॉर्ड हिची 4 टा ना 4:30 टा पूर्व पड़बो सेते बेले मध्य से तार स्टेटमेंट इज साइलेंट जे ताकू PW4 कोनोसी डिस्क्लोजर कला एवं एमानकर ना कहिला बोली रादर ता स्टेटमेंट होची जे की गोटा मारिन पके दी हमें किसी जानी पारनु देखुन
मैं सुन पांती at para 10 PW stated that at 9 a.m. police was already arrived man
रुंद से
PW नंबर पूरा स्टेटमेंट रिकॉर्ड हिची at 4 p.m.
कोडा
PW2 रो स्टेटमेंट रिकॉर्ड हिची at 4 p.m.
PW2 रो हम देखथुल तो केस डायरी
किंतु केस डायरी आल्सो रिवील्स दैट on this same date at 5:20 p.m. the house of the PW4 was searched.
PW2 रो स्टेटमेंट को आसन 161 नवकृष्ण चौधरी तार स्टेटमेंट का
मो नवकिशोर चौधरी আজি দেবা মৌখিক বয়ান এই যে গতকালি রাতে মোর বউ কামিনী চৌধুরীঙ্কর পড়ি যাই মো রিলেভেন্ট पर्सन को जाउची
स्टेटमेंट अछि पेज नंबर 406 से जो ये
406 रे नवकिशोर
आपण नवकिशोर पढ़ एटा 4टा वाले स्टेटमेंट रेकॉर्ड हेजी ता पूर्वरु ता 4 नंबर साखी ऑलरेडी कहूची कहि देइछि बोली वर्तमान पढ़न स्टेटमेंट पढ़न
मो बो कामिनी चौधुरींकर पड़ी जाई गोड़ हाड़ भांगी हाड़ खसीगला एणु आमे बिरंचु को कहलु जाई तिमिरिया साहिर हरी ड्राइवर को गाड़ी नबाकू
रेडी हवा पे कहि देई आसीबु
बिरंची बापी और बाबन मिसी बुलेट रे बसी चली गले ହରିକୁ କହିଲେ ଦେଇ ସିଆଡ଼େ ଦୀପଟି ମେଲଣକୁ ନାଚ ଦେଖି ଯିବେ ବୋଲି କହିଥିଲେ। ପ୍ରାୟ ଅଧଘଣ୍ଟା ପରେ ମୁଁ ଅନ୍ୟମାନେ ବୋଉକୁ ଟ୍ରେକରରେ ଲଦି ଅଡ଼ଶପୁର ହସ୍ପିଟାଲକୁ ବାହାରିଲୁ। ପ୍ରକାଶ ଗାଡ଼ି ଚଲାଉଥିଲେ। ଏଇ ଘଟଣାସ୍ଥଳ ଦେଇ ଯାଇଛୁ ଏଇ ଘଟଣାସ୍ଥଳ ଦେଇକି ଯାଇଛୁ। ବାଟରେ ଆଲିଙ୍ଗଟା ପଡୁଛି, କିନ୍ତୁ ପାଟିତୁଣ୍ଡ ଶୁଣିନୁ କି କାହାକୁ ଦେଖିନୁ। ବାଲିସାହି ଛକରେ ପହଞ୍ଚି ହରି ଡ୍ରାଇଭରକୁ ଡାକିଲୁ, ସେ ଆସିଲା। ରବା ବେହେରା ମଧ୍ୟ ସେ ଛକରେ ଥିଲା। 4-5ଟା କୁକୁର ଭୁକାଭୁକି କାହାକୁ 2-4 ଜଣ ଲୋକଙ୍କୁ ଗୋଡ଼ାଉଥିଲେ। ରବା ଟର୍ଚ୍ଚ ପକେଇ ଦେଲାବେଳେ ମୁଁ ବି ଦେଖିଛି। ସେମାନେ ଟ୍ରେକରକୁ ଦେଖି ଦୌଡ଼ା ଦୌଡ଼ି ହୋଇ ସେ ଅନ୍ଧାରିଆରେ କୁଆଡ଼େ ପଳେଇଲେ। ମୁଁ କାହାକୁ ଚିହ୍ନି ପାରିନି। ତାପରେ ଆମେ ଟ୍ରେକର ନେଇ ଅଡ଼ଶପୁରକୁ ପଳେଇଲୁ। ଆଜି ସକାଳେ ବିରଞ୍ଚି ମର୍ଡର କଥା ଶୁଣି ଆସି ଦେଖିଲୁ ଯେ ହଣା ହୋଇ ମରି ପଡ଼ିଛି। ମୁଁ ଜାଣିବାରେ ଡିମିରିର ବିଜୁ ମହାନ୍ତି ସଙ୍ଗେ ତାର ଗଣ୍ଡଗୋଳିଆ ଥିଲା। ସବୁବେଳେ ପାଟିତୁଣ୍ଡ ହୁଅନ୍ତି, କିନ୍ତୁ ଏବେ ତାକୁ କିଏ ହାଣିଛି କ'ଣ କରିଛି ମୁଁ କହିପାରିବି ଦେଖିନି କି ଜାଣିନି। ବାପି ଓ ବାବନ PW4 and 8
ଆମେ ଖୋଜି ଖୋଜି ପାଉନୁ।
ବି ଆମେ ଖୋଜି ଖୋଜି ପାଉନୁ।
କୋଉଠି ଅଛି disclosure statement?
ଏଠି କହିଲା ନାହିଁ, କିନ୍ତୁ PW8 କାହିଁକି ହ୍ୟାଭ୍ ଲାଷ୍ଟ ଟୁ PW8?
ଆରେ ଆମେ ଯିବୁ ଆଗେ ଗୋଟେ ସାକ୍ଷୀ ଧରୁଛୁ, ଆପଣ ଅନ୍ୟ ନେଇ ଯାଉଛନ୍ତି। ଆମେ ବର୍ତ୍ତମାନ ନମ୍ବର 4 ର
ସେମାନେ ଏସବୁ ଜାଣିଥିବେ ବୋଲି ମୋର ବିଶ୍ୱାସ,
ଯେହେତୁ ସାଙ୍ଗରେ
ଯାଇଥିଲେ।
So what we want to say that almost 7 to 8 days after the occurrence, this man gave his statement under section 161. 4 number साक्षी कथा हम कम और 8 number बर्तमान भूली जान। We will come to that. तारो explanation होची आउ थरे देखिवा से sequence घटना छाड़ दियंतु। घटना परे से कहूची मो दादा घर को गली। दादा घरे दादा फैमिली रहउछन सेठी की कोडी
राउरकेला दादा रहउची, फैमिली एठी रहउछन।
किछि लोक एठी रहउछन। सेठी मु राति रे रहिली, मो निज घर को आसिलिनी। दादा घर पाखरु गोविंदपुर थानाटा होची 400 मीटर दूर। किंतु मो मानसिक अवस्था ठीक नथिला, परप्लेक्स माइंड थिली, तेणु मु थाना को जाइनी। तापर दिन मोर मति गति ठीक हला एवं तापर मध्य मु थाना को गलिनी। आसिली आसिकिनी
दिन 10टा बेले गोविंदपुर छाड़ी,
दिन 10टा बेले गोविंदपुर छाड़ली।
2टा ରୁ 3ଟା ଭିତରେ
आसिकी पहुंचली। आसी पहुंची 2 जन को से कहूची डिस्क्लोज कला।
PW2 प्रकाश,
PW2 प्रकाश गोटे आ गोटे होची ता भाई को जी के एग्जामिन नहीं।
PW2 नवकिशोर आरठ
PW2 होची नवकिशोर ना आउ बाकीटा होची प्रकाश बेली जोटा भाई एग्जामिन नहीं। से टाइम होची 3टा बेले। सेही लोकर जहा पाखरे डिस्क्लोज हला अर्थात नवकिशोर सीडी अनुଯାয়ী तार स्टेटमेंट रेकॉर्ड होईची 4टा बेले। स्टेटमेंट होची एया। स्टेटमेंट रे टोटली साइलेंट जे ये लोक आसिकिला एवं आसिकिनी तांकू देखा करिकिनी ताकू देखा करी घटना विषय रे कहिछि। टोटली किए मारला मुझे स्टेटमेंट रो अपन तो देखिले ना, दैट हैज बीन कन्फ्रंटेड एंड प्रूव्ड जे टोटली अर्थात स्टेटमेंट दवा पर्यंत सी ता ना तो डायरेक्ट नॉलेज नाही ना आउ को सोर्स रु माने किए असेलेंट ऑफ द डिसीज्ड देखिले स्टेटमेंट अछि नाही तो
ना।
So then this man vanishes. PW4 vanishes to Raurkela. ता कथा अनुଯାयी राउरकेला रहीकिन जाइकिन गोटा दादा घरे रहिला। से जो 8 दिन कहूची से दादा घरु भी केही कोनोसी कॉरोबोरेटिंग एविडेंस ना। इनफैक्ट से जाइतला राउरकेला सेठी रहितला 7-8 दिन। कोन पई भी सेठी रहिला से कथा किछि नाही। अच्छा वर्तमान आपण जो आनिचंती जे धर कहा जीव जे आक्यूज माने थ्रेटन कले आ भय करथिला। हां हेई थांदा आक्यूज माने ता भीतर अरेस्ट हे गले से राउरकेला रु आसिकिनी स्टेटमेंट देला। ए केस एमती नुहे कारण एमानकर अरेस्ट हेची परे बहुत माने 97 मसिया रे अरेस्ट हेचन। गोटे अरेस्ट हेची निखिल अरेस्ट हेची हमें देखथुल से दिन 10/9/97
सदानंद खुंटिया अरेस्ट हैला 31/10/97 ଆଉ ଗୋଟେ କେସ୍ ରିମାଣ୍ଡ ରେ ଆସିଲେ
বা ଇଏ ହଉଛି ସବୁ 97 ଆରେଷ୍ଟ ହେଇଛନ୍ତି। ନିଖିଳ ଆରେଷ୍ଟ ହେଇଛି 10/9/97
10/9/97
ରାଇଟ୍। ତେଣୁ what is the why he changed or ultimately how is if say that I was under a threat perception ମତେ ଧମକ ଦେଲେ ସେଇଥିପାଇଁ ମୁଁ ଗାଁ ଛାଡିକିନି ପଳେଇଲି, ଗାଁ ଛାଡି ଗୋବିନ୍ଦପୁର ପଳେଇଲି ପୁରା ରାଉରକେଲା। ତ ରାଉରକେଲାରେ ରହୁଥିଲା ବୋଲି କିଛି ଏଭିଡେନ୍ସ ନାହିଁ, ମାନେ କିଛି କରବୋରେଟିଂ ଏଭିଡେନ୍ସ ନାହିଁ। ତାପରେ ସେତେବେଳେ ଯଦି ଡିସକ୍ଲୋଜ ନ କଲା ଆକ୍ୟୁଜଡ ମାନେ ଆରେଷ୍ଟ ହେଇନାହାନ୍ତି, ତାର ଏଇ ଯୋଉ ଥ୍ରେଟ୍ ଯୋଉ ଭୟ ମନରେ ଯଦି ଭୟ ଥିଲା ସେଇଟା କେମିତି ପଳେଇଲା, ସେ କେମିତି ପୁଣି ବ୍ୟାକ୍ କରିକିନା ଆସିକିନି ପୁଣି ଭଲ୍ୟୁଣ୍ଟାରୀ ପହଞ୍ଚିଗଲା ଗାଁରେ ଆଉ ଷ୍ଟେଟମେଣ୍ଟ ଦେଲା। ତେଣୁ ଏଇ ଯୋଉ ଡିଲେଡ୍ ଡିସକ୍ଲୋଜର ଯୋଉ ଏକ୍ସପ୍ଲାନେସନ ଏ ସାକ୍ଷୀ ଦେଇଛି PW4, how far it is to be acceptable? We are discussing on only one witness, PW4. Then we'll go to PW8.
ତାପରେ PW5 ହଉଛି PW4 ର ଫାଦର। PW4 ର ଫାଦର ତାର ବି ମଧ୍ୟ ଏଭିଡେନ୍ସ ରେ that was recorded on 13/3/96 at 5:20 PM and please ଛୋଟ statement ଆଜି ଦେବା ବୟାନ ନେଇକି ଯେ ଏଇ ଜୋତା ହଳ ହେଉଛି ମୋ ପୁଅ ବାପିର, ସ୍ପଟରେ ଜୋତା ପଡିଥିଲା। ସେ ବିରଞ୍ଚିର ସାଙ୍ଗ ଓ ଦୁହେଁ ମିଶି କଣ୍ଟ୍ରାକ୍ଟ କାମ କରନ୍ତି। ଗତକାଲି ଉପରଓଳି ପ୍ରାୟ 4ଟାରୁ 5ଟା ବେଳେ ସେ ଓ ବିରଞ୍ଚି ଆମ ଘରେ ଖାଇସାରି ବୁଲେଟରେ ବସି ଦୀପଟି ନାଚ ଦେଖି ଯାଉଛନ୍ତି ବୋଲି କହିକି ଗଲେ। ଏଯାଏଁ ବାପି ଘରକୁ ଫେରିନି। PW4 5:20 ରେକର୍ଡ ହେଲା ବେଳକୁ ଘରକୁ ଫେରିନି। ଗଲାବେଳେ ସେ ଏଇ ଜୋତା ହଳ ପିନ୍ଧି ଯାଇଥିଲା। ଆଜି ସକାଳେ ବିରଞ୍ଚକୁ କେହି ହାଣି ମାରି ଦେଇଥିବାର ଶୁଣି ମୁଁ ବଡ଼ ଚିନ୍ତିତ। ମୋ ପୁଅ କୁଆଡ଼େ ଅଛି କି ତାକୁ ବି କିଏ ମର୍ଡର କଲାଣି ମୁଁ କିଛି ଜାଣିପାରୁନି। ସେ କିନ୍ତୁ ଏଯାଏଁ ଘରକୁ ଫେରିନି। ବିଜୁ ଓ ବିରଞ୍ଚିର ଭାରି ଗଣ୍ଡଗୋଳିଆ ସମ୍ପର୍କ। ଏବେ ବିରଞ୍ଚକୁ କିଏ ମାରିଛି, କ'ଣ କରିଛି ମୁଁ କିଛି ଜାଣିପାରୁନି। ମୋ ପୁଅ ବାପିକୁ ମୁଁ ବି ଖୋଜୁଛି, କିନ୍ତୁ ଖବର ପାଇଲେ ସଙ୍ଗେ ସଙ୍ଗେ ଆପଣଙ୍କ ପାଖରେ ପହଞ୍ଚାଇବି।
So that means this man who is the father of PW4 has no information with him that his son had been to Raurkela.
5:20 ପର୍ଯ୍ୟନ୍ତ ସନ୍ଧ୍ୟା 5:20 ପର୍ଯ୍ୟନ୍ତ ତ statement of my humble submission is there is some omission in the part of the PW4.
ନାଇଁ ଆପଣଙ୍କର as PW5 whether he has stated that my son had been to Raurkela?
ନା ସେ ତ ଜାଣିପାରୁନି, ଯେତେବେଳେ ରେକର୍ଡ ହେଲା ବେଳକୁ ସେ ବି ଜାଣିପାରୁନି ତା ପୁଅ
ସେତେବେଳୁ ଛାଡି ଦିଅନ୍ତୁ, ପରେ ବି ଜାଣିଲା। ସେ ଷ୍ଟେଟମେଣ୍ଟ ରେକର୍ଡ ଡିପୋଜିସନ ଦେଲା ବେଳକୁ ପର୍ଯ୍ୟନ୍ତ ଡିପୋଜିସନ ଦେଲା ବେଳକୁ ତ ଡିପୋଜିସନ ଦେଲାଣି 2001ରେ ନା, ତ ଘଟଣା ହେଇଛି 96 ମସିହାରେ। ତ 5 ବର୍ଷ ପରେ ଯେତେବେଳେ ଡିପୋଜିସନ ଦଉଛି କହୁଛି କି ମୋ ପୁଅ ଘଟଣା ପରେ ପଳେଇ ଯାଇଥିଲା ରାଉରକେଲା, ଆପଣ ଗୋଟେ ଏକ୍ସପ୍ଲାନେସନ ଦେବେ ପରା ଡିଲେଡ୍ ଏକ୍ସାମିନେସନ ର। କାରଣ ଦେयर ଇଜ ସ୍କୋପ X and Y ସାଙ୍ଗରେ ଯାଇଥିଲା, so there is every possibility of X and Y also committing murder of the deceased. ଆପଣ X and Y ର ଷ୍ଟେଟମେଣ୍ଟ ବେସିସ ରେ A and B କୁ ଆକ୍ୟୁଜ କରୁଛନ୍ତି ହେଲା। X ର ଷ୍ଟେଟମେଣ୍ଟ ହଉଛି ମୁଁ ଏମିତି ହେଲା A and B ତାକୁ ମର୍ଡର କରିଦେଲେ, ତାପରେ ମୁଁ ଆଉ କାହାକୁ ଇଏ କରି ଜଣକୁ କହିଦେଲି ମୁଁ ପଳେଇଲି ଏଠିକି ମାନେ ରାଉରକେଲା ପଳେଇ। ସୋ ରାଉରକେଲା ଗଲା ବୋଲି କିଛି ଏଭିଡେନ୍ସ ନାହିଁ, ତା ଘର ଲୋକ ହିଁ କହୁନାହାନ୍ତି ସେ ରାଉରକେଲା ଗଲା।
ରାଦର ଘର ଲୋକ କହୁଛନ୍ତି ତାକୁ ମୁଁ ଦେଖିଲି ତ୍ରିଲୋଚନ ସହିତ ଥାନାରେ, ମାନେ PW5 କହୁଛି।
The deceased Biranchi Swanso, PW told me that he wanted to accompany Gala. They both left for witnessing Jatra. On 14th, I had been to Govindpur police station.
About 4 to 5 days after the occurrence, I went to police station hearing that PW
14th ଟା କେମିତି 4 to 5 days after occurrence no? ଘଟଣାଟା କେବେ ଲାଗି 12 ତାରିଖ, ଏଟା ତ ନେକ୍ସଟ ଡେ ହେଲା।
ହଁ ସେ ଭୁଲ।
About 4 to 5 days after occurrence, I went to police station hearing that
PW was at the said police station.
I saw my son PW4
along with my younger
brother Tilochan
ସେ ଡାଇରେକ୍ଟ ଆସିକି ରାଉରକେଲାରୁ ଏଠି ପହଞ୍ଚିଛି ପୋଲିସ ଷ୍ଟେସନ।
ଏଠି 14 କହୁଛି ସେଠି ସିଏ କହୁଛି ଯେ
There is some
64
minor
ରେ ମୁଁ
discrepancy.
ଆସିଛି 18।
There is some minor discrepancy, but
when the statement of this witness was examined, recorded by police.
police on 13/3
13 ମାନେ ଘଟଣା ଦିନ
ଘଟଣା ଯୋଉ ତା 12 ତାରିଖ ଘଟଣା 13 ତାରିଖ ଦିନ
13
ସକାଳୁ 5:20 PM ରେ
ହଁ
କେସ୍
5:20
କେସ୍
ମାନେ
ଡେରୁ ମୁଁ
ଅପରାହ୍ନ 5:20 ରେ ହଁ ସେତେବେଳେ ସେ କଣ କହୁଛି
ସେ କହୁଛି ଯେ ମୋ ପୁଅ କୁଆଡେ ଯାଇଛି, ମୁଁ ତାପରଠୁ ତାର କିଛି ଖୋଜ ଖବର ମିଳୁନାହିଁ।
କ୍ରସ ରେ ବି ସିଏ କହିଛନ୍ତି ଯେ ଆମକୁ ସେ କହିନାହାନ୍ତି ଆମେ ଯାଉଛୁ ଯାତ୍ରା ଦେଖିବୁ ବୋଲି। କ୍ରସ ରେ ବି ଆଡମିଟ କରିଛି ସେ।
ଆରେ ଯାତ୍ରାଟା ବେଶୀ ରେଲେଭେଣ୍ଟ ହଉଛି ରାଉରକେଲା।
There is some minor discrepancy, but fact that after occurrence, the PW4 absconded from the that locality and he arrived at the police station along with his uncle Trilochan.
Why? What is the reason that why he will abscond? If you say that threat perception was there, in spite of that threat, he is coming to the village.
ତା ଦାଦା ସହିତ ଆସିଛି।
In spite, he alone came and disclosed before PW2. अरे आपण केस देखिले परा सी गांव को आसी कहला परा मु PW2 को कहली आ ता भाई को कहली डीसी रो भाई को कहली पैराग्राफ 6 टा आपण देखिले नी की?
Yes, but 161 स्टेटमेंट
161 बोलन मो ओ
हां सेतरे कहछि
PW4 रा निजे कोनी मु आसीली गांव को आइली गांव को आसी कि दी जण को
प्रकाश आ PW2 को
पड़ेला पड़
नवकृष्ण और प्रकाश को कहले
याकू धमक दिया होची तमे जदी ये करिवो हमें मारी दबु से लोक ता परदिन 10टा बेलू तार मानसिक अवस्था ठीक हो गला परे से पुणी गाँ को फेरुची घटना विषय रे अन्य मान को कहूची हाँ दी जन को एटलिस्ट कहूची दी जन रू जने एग्जामिन हेनी आउ जने होची ये PW2
PW4 is not fully reliable.
कहीं ना देखो धमकटा कौन दिया इतला माधव खुंटिया पैराग्राफ 11 ने पाउली माधव खुंटिया threatened me as well as Baban means PW8 to kill us if we disclose about the occurrence before anybody एभलिया धमक सत्वे एवं ताको आउ धमक दिया इतला जदी काहा को डिस्क्लोज करिवु ताले तो रेसिडेंशियल will destroy your residential house by making bombardment एभलिया थ्रेटनिंग दबा सत्वे जदि से थ्रेटनिंग को माने भय न करी ताको आसिकिनी ता निज स्टेटमेंट अनुଯାयी PW2 को डिस्क्लोज करूची आ प्रकाश को डिस्क्लोज करूची that shows that this threatening has no effect on him जार इफेक्ट नहीं जदि करा जीवो से लोगडा केमती डरी किनी आपण कहउचंदी पळेबो राउरकेला एवं डरी किनी पळेला पुणी निजे निजे पळे आसला पुणी आसी थाना को देला दिस थिंग ऑल दिस थिंग्स
This is
7-8 days रो डिफरेंस लानी ना every likelihood of being set up as a eyewitness to the occurrence कारण जार थ्रेट जहा ऊपर इफेक्ट पकोनी सी जदि गोटे एमितिया जगार रही से राति रे जोठू थानाटा हूँ जमा 400 मीटर दूर ये तो पड़े था थाना रे बाबू मु देखी घटना हाँ थाना को गलानी तापर पळेला आंकु डिस्क्लोज कला प्रकाश को डिस्क्लोज करी पळेला राउरकेला को पाटनाल अंकल पाकू बाकी PW8 आपण जो कहउछन you come to
Yes.
the next witness PW8.
My nickname is Baban. I know both the accused person. I also know absconding accused Biju Rai and the absconding accused Satrunna Malik. The deceased Biranchi is the younger brother of my friend Radhakrishna Chaudhary. I also know Bapi alias Jyotiranjan Pidolkor. On 12/3/96 at about 10:15 p.m. the occurrence took place. On that date, prior to the occurrence, at about 6 p.m., myself, along with Bapi, Pidolkor, and the deceased Biranchi, decided to witness the Jatra, Draupadi Melana Jatra, at village Kasarta. After we decided to witness the Jatra, in the meantime, the mother of the deceased Biranchi received injury on her leg, for which Navakrishna, PW2, Navakrishna Chaudhary, the elder brother of Biranchi, asked the deceased Biranchi to take his injured mother to hospital for her treatment in their tracker. The said Navakrishna Chaudhary asked deceased to call for the driver of the tracker while proceeding to Kasarta village to witness Jatra, so that the injured mother could be taken to hospital by their tracker. Myself, the deceased Biranchi and Bapi Pidolkor, while going to call for the driver of the vehicle in a bullet motorcycle driven by Pidolkor, at that time on the way at Alingchak, the accused to Madha Khuntia was standing near a heap of chips. The accused Madha Khuntia raised his hand to stop the motorcycle. Pidolkor stopped the motorcycle. The said accused Madha Khuntia asked us as to where our destination to go. On being replied by Pidolkor that we are going to call for the driver to take the injured mother to the hospital. At that time, accused Madha Khuntia asked deceased Biranchi to be detained there and asked PW4 to proceed alone to call for the driver. Myself and the deceased Biranchi remained there while PW4 went to call for the driver. The deceased Biranchi was taken by the accused Madhav to a nearby canal and I followed them. The deceased was called by accused Madhav to the canal side Badam Kiari to have their formal talk. We went there. The accused Madhav asked deceased to sit. I was also asked to sit. We, myself and the deceased, sat on the ridge of the land. The accused Madhav shouted in a calling voice as Gona, Gona. The absconding accused Gona alias Saturna Malik came there roughly being armed with a sword. The said absconding accused Gona asked the identity of myself and the deceased Biranchi to the accused Madhav. The said accused Madhav gave our identity to the accused Gona. The said absconding accused Gona blamed the deceased to have abused accused Madhav Khuntia, to which deceased Biranchi replied showing his innocence and denied to have abused accused Madhav Khuntia. By that time, the accused Nikhil Mahanti arrived there. The accused Gona, pointing out at the deceased Biranchi, identified him before the accused Nikhil. The accused Nikhil thereafter gave a fist blow on the person of the deceased Biranchi, for which the deceased...
এইটু just এইটির pause দিଅନ୍ତୁ ବର୍ତ୍ତମାନ simultaneously ଆପଣ PW4 ର ସେଇ assault part କୁ ପଳେଇ ଆସନ୍ତୁ ମାନେ ୟାକୁ ପଢନ୍ତୁ ତାକୁ ପଢନ୍ତୁ ଦେଖିବେ ଆପଣ କୋଉ ଟାଇପ ର ଦି ଜଣ ଯାକ ଘଟଣା ଯେ ଅଛନ୍ତି ଦି ଜଣ ଯାକ ଦେଖୁଛନ୍ତି. Now you see that in what way start ହେଲା ଯୋଉଟା assault. Assault start ହେଇଛି ସେଠି page number 53 para 9.
By that time accused to Biju Rai.
ବର୍ତ୍ତମାନ ସେଟାକୁ ନଜର ରଖି ପଢନ୍ତୁ.
ନା paragraph 7 ରୁ 7 ରେ ନିଖିଲ ଆସିଗଲାଣି।
ନାଇଁ ନାଇଁ 7 ମାଡ଼ କଥା କିଛି କହିନି।
The deceased
Madam,
Biranchi
but
along
you-
with Pavan and other person arrived there after being called by the accused Madhav.
କିଛି ନାଇଁ ନାଇଁ ଆରମ୍ଭ ହେଇଛି 9 ରୁ PW4 ରୁ ଆଉ ଆର PW8 ରୁ ଆରମ୍ଭ ହେଇଛି ପାରାଗ୍ରାଫ ନମ୍ବର 7 ରୁ ବାକି ତା ପୂର୍ବରୁ ଛାଡି ଦିଅ।
ମାନେ one is saying about Biju Rai, another is saying about Nikhil.
East ଟା ଦେଲା ନିଖିଲ PW8 କହୁଛି। Accused Biju Rai came there armed with sword. State accused Biju Rai dead blow on the
ନାଇଁ 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 ବିଜୁ ରାୟ ହଁ ଏଇ ଯୋଉ ପଢୁଛନ୍ତି ଆପଣ
ସେ sword ରେ
ବିଜୁ ରାୟ came there ବିଜୁ ରାୟ ମାନେ ଯେ absconding he came there with a sword and dealt a blow by a sword on the head of Biranchi for which
PW8 ଏଇ ଯୋଉ କଥାଟା କହୁଛି ସେତେବେଳେ PW4 ପହଞ୍ଚି ନଥିଲା। ମୋଟରସାଇକେଲ ରେ ଆସିକି ପହଞ୍ଚି
ଫେରି ନଥିଲା ଯୋଉ ଟ୍ରେକର ଡାକିକି ସେ ଫେରି
ନଥିଲା। ତାପରେ ସେ କହୁଛି ଫେରିଲା ପରେ
ସେ କେତେବେଳେ ପହଞ୍ଚିଲା
ଏଇଥିରେ ଷ୍ଟେଟମେଣ୍ଟ ରେ ଅଛି।
ହଁ
The accused Nikhil PW8
para 6
The accused Nikhil thereafter gave a fist blow on the person of the deceased Biranchi for which the deceased Biranchi fell down on the ground with face upward. The accused Madhav protested.
ଏଗୁଡାକ ଏଇ ଯୋଉ ଷ୍ଟେଟମେଣ୍ଟ ଆଇଛି ଯେତେବେଳେ PW4 ନଥିଲା
ନା ସେ ଯାଇଥିଲା ମୋଟରସାଇକେଲ ଡାକିବା ପାଇଁ।
ଆଚ୍ଛା
ତା ଏଥିରେ ଅଛି PW8 ର ଷ୍ଟେଟମେଣ୍ଟ ସେଟା ଅଛି।
ବଟ୍ ଇଏ କୋଉଠି କହୁଛି ଯାଇଛ ଗଲି ବୋଲି ମୁଁ PW4
ସେ କହୁଛି ସେ ମୋଟରସାଇକେଲ ମତେ ଅଟକେଇଲା ମାଧବ ମତେ କହିଲା ତୁ ଦା ଆଉ ବିରଞ୍ଚି ଏକ ଅଟକେଇ ଦେଲା
PW4 ଗଲା।
ତାପରେ ସେ ଆସି ପହଞ୍ଚିଲା ତାକୁ ଡାକି ଦେଇ ଟ୍ରେକର ସେଠି ଅଛି।
PW4 paragraph 4 page 52 the deceased told the accused Madhav Khuntia that he was in hurry to go for calling for the tracker driver. The deceased Biranchi as well as our associate Baban remained there while I went in the motorcycle to call for the tracker driver. I came back to this same place after calling the tracker driver. I found that the accused to Madhav Khuntia was alone standing there. Nobody except Madhav Khuntia was present. PW8 କହୁଛି ଯେତେବେଳେ ଲାଇଟ୍ ପଡିଛି ଯାଇଛି ମାଧବ ଖୁଣ୍ଟିଆ ତାକୁ ଫୋନ ଡାକିବା ପାଇଁ।
ତାପରେ କଣ ଏଇ ଯୋଉ ଇଏ ଆସି ପୁଣି ତ ପହଞ୍ଚି ଗଲା ନା 4 ନମ୍ବର ସାକି
ସେ ପହଞ୍ଚିଲା ପରେ PW8 ର ଷ୍ଟେଟମେଣ୍ଟ ରେ ଅଛି।
ହଁ କଣ ସେଗୁଡା କୁହନ୍ତୁ।
The accused Madhav protested accused Nikhil saying as to why he assaulted deceased Biranchi.
Koodi.
Paragraph 6 PW8 page 68. The accused Madhav protested accused Nikhil saying as to why he assaulted deceased Biranchi. The accused Madhav came to the deceased Biranchi and took him to the side with sympathetic attitude. Accused Madhav Khuntia took deceased Biranchi to a little distance ahead up to 5 to 7 cubits. The absconding accused Gonna and the accused Madhav also followed them. Accused Nikhil was with me. The absconding accused Gonna forcibly placed.
There is something, some recording of evidence is not clear. The accused Madhav Khuntia took the deceased Biranchi to a little distance ahead up to 5 to 7 cubits.
Yes.
Puni kohuchi, the absconding accused Gonna and the accused Madhav also followed them. So the recording is not correct. The recording is not correct. In the entire case, the recording is not correct. The court has perceived something and has expressed in a different way. That is how there is a
matching ho nahi.
Absolutely.
ଯୋଉ ମାନେ ଯେତିକି ଘଟଣା ମାଡଟା ଦି ଜଣଙ୍କ ପ୍ରେଜେନ୍ସ ରେ ହେଇଛି ତାକୁ ବି ଆପଣ ପଢନ୍ତୁ ଆପଣ ଦେଖିବେ ଡିସ୍କ୍ରିପାନ୍ସିଜ ରହୁଛି ଯୋଉ ଆପଣ ଗୋଟେ ପଏଣ୍ଟ ଅଫ ଟାଇମ ରେ
ଦି ଜଣ ଆସିଲେ
ନା ସେଇଠୁ ପଢନ୍ତୁ
para 7 ରୁ ଚାଲୁ
para 7 ରୁ ପଢନ୍ତୁ.
The absconding accused Gonna forcibly pressed the shoulder of the deceased Biranchi and made him to sit. The accused to Gonna
absconding accused Gonna
instructed the deceased Biranchi not to become the following
of Juga Kanun,
Juga Kanun को
or not
and-
to be a follower of Juga Kanun.
Yes.
And to adopt
adopt the accused Madhav
Madhav
Kuntia
Kuntia, acha.
by becoming his follower.
Right.
The deceased Biranchi denied the above proposal and told to the above accused person that he is the follower of none. By that time, Bapi, ei samara asila. By that time, Bapi, PW4, was coming in his motorcycle, and the accused Madhav Kuntia went towards Bapi by seeing the light focus of the motorcycle. The accused Madhav Kuntia came there along with Bapi by walk, keeping the motorcycle at a distance. Bapi, alias PW4, was asked to sit by my side.
तो दी जन जगह आसी गला बर्तन देखिए
हाँ.
तापर पढ़ो
The absconding accused Biju Rai came
String my presence.
The absconding accused Biju came rushing to our place. এই সময় সেই মধ্যে কହୁଛି PW4 বিজু ଆସିଲା. The absconding accused Biju, seeing my presence, abused me saying slang language and proceeded to the deceased Biranchi. The accused Biju Rai took the sword from the hand of the absconding Ganna and said absconding Biju dealt a blow with the said sword at the back of the neck of deceased Biranchi. एक समान कथा मध्य PW4 कहिछि.
नहीं नहीं सोड 8 मारला बोल तो किसी कोई नहीं.
The accused Biju took the sword from the hand of absconding Ganna.
Now you just stop, pause for a moment. Come to paragraph number 9, page 53, PW4.
Yes. By that time, accused Biju came there, being armed with a sword. The said accused Biju Rai dealt a blow with the sword on the head of.
এইটা দেখুন ବିଜୁ ରାୟ କାହାଠୁ ସୋର୍ଡ ନବା କଥା PW9 କହିନି ଯୋଉଟା କି କହୁଛି ଇଏ ହେଲା. ତାପରେ ମାଡ ପ୍ଲେସ୍ ଦେଖନ୍ତୁ ଅଲଗା ରହୁଛି. ଜଷ୍ଟ ଗୋଟେ ଗୋଟେ ଆସନ୍ତୁ. ମାଡ ପ୍ଲେସ୍ ହଉଛି ଇଏ ହେଲା
ନେକ୍, ସେଠି କହୁଛି ହେଡ୍.
ତାପରେ ଦେଖନ୍ତୁ
ବ୍ୟାକ୍ ଅଫ୍ ନେକ୍.
ଠିକ ଅଛି ତାପରେ ପଢନ୍ତୁ.
Who laid down on the ground with bleeding injuries. The said absconding accused Biju dealt 5 to 7 blows with the sword on the person of the deceased. The accused Nikhil snatched the sword from the hand of absconding accused Biju, and he also dealt sword blows on the person of the deceased. The accused Nikhil also gave 4 to 5 blows on the person of the deceased Biranchi. The absconding accused Ganna also dealt 4 to 5 blows by means of sword on the person of the deceased Biranchi. By taking the sword from the hand of the accused Nikhil, the accused Madhav was insisting to assault on the head of the deceased and no other else.
Sir, insisting na inflicting ke?
Insisting. The absconding accused Ganna also dealt 4 to 5 blows by means of sword on the person of the deceased Biranchi by taking the sword from the hand of the accused Nikhil.
ବିଷୟରେ କଣ କହିଲା ଏଇ PW8
ସେ କହିଲା ସେ blow ଦେଇଛି ବୋଲି 2 to 4, କିନ୍ତୁ that is not the statement of PW4. PW8 କହିଛି 2 to 4 blows ଦେଲା ବୋଲି.
The accused Madhav Kuntia threatened me and Papi not to disclose about the offense to anybody. Otherwise, he would
be receiving the same consequence.
କହିଛି paragraph 10 ରେ କହିଛି ମାଧବ ଦିଟା ଦେଇଛି. By that time, we noticed a tracker being passing on the road by seeing the focus of the light of the said vehicle. The accused Madhav Kuntia held the hand of Bapi and directed him to leave the place along with him. In the meantime, the absconding accused Ganna focused his torchlight at the deceased Biranchi. The accused Madhav Kuntia took the sword from absconding accused Ganna, saying as slang language, the accused Madhav Khuntia gave 2 blows on the person of the deceased with the said sword.
अच्छा बर्तमान ये रखिले तामाने दी जन जाको कहउछन कि 4 आ 8 जे माधव खुंटिया मध्य sword रे ब्लो देला. You just come to page number 82. आईओ स्टेटमेंट जोटा कन्फ्रंट हेकिन प्रूव हेछि एवं 161 हम मध्य देखितु. पेज गोटे होछि पैराग्राफ 25 पेज 82 आ गोटे होछि पैराग्राफ 26.
Pidulford did not stated before me that he can identify the culprit. If
पेज
he-
82 क्वेश्चन तो
yes,
हां
page 82
पैराग्राफ
25.
नंबर 25 ठीक है
Pid-
just 25
Pidulford did not stated before me
did not state
State
before me
that
regarding हाँ पढ़ो that
me
he can
that he can identify
identify
the culprit.
हाँ तापर
If
लाइन
he sees them, Pidulford did not state before me regarding the assault by accused Madhav Khuntia
on the
on the
deceased
deceased.
ये गोटे तापरे PW8 ର ମଧ୍ୟ ଦେଖନ୍ତୁ
and
paragraph
PW8 to the accused Madhav Khuntia being asked by
Pidulford did not state before me that the deceased
26 number
Ah,
paragraph
gave out the identification
and
of
that is
Pidul-
true also.
ଆମେ
161 and
161 ଭେରିଫାଏ କରିଥିଲୁ ମଧ୍ୟ ସେଦିନ ମାଧ ଖୁଣ୍ଟିଆ କୌଣସି ମାନେ
Assault କଥା କହିନାହିଁ।
ଡିସିସ୍ଡ କୁ ମାରିଲା ये ଜିନିଷ ନାହିଁ it is
No.
rightly confronted and proved to the
Yes.
Madhav Khuntia's role altogether are different. He is the person, he is the head of one gang as it is appearing. He obstructed the motorcycle, asked one person to go and call for the tracker, PW4. Other 2 persons were there and he was monitoring other things without.
And Madhav Khuntia called the gunner.
Yes, called
He first
Ganna.
called and it was pre-planned
Yes.
because Ganna come there with a sword.
Yes. So Biju, Ganna
Nikhil.
and Nikhil have assaulted. And Ganna is the this man is the person who was coordinating.
Yes.
That is. एमाने एका संगे आछंती ये ताको डाकिछि याको अटकेला परे समान तापर आछंती मैडम आछंती मिसिगिर पळैछंती ए दी जन को से छाडी दिछि काको जे मोटरसाइकिल
PW4 and PW8.
What about this explanation regarding PW8 ର it assault तो लागो
Assault କଥା होला तापरे
गले घटना पर कोन हला
the accused Madhav Khuntia threatened me and Bapi not to disclose about the occurrence to anybody.
हां गला फिर कोन करा
Anybody, otherwise gala. By the time we noticed a tracker being passing on the road, by seeing the focus of the light of the said vehicle, the accused Madhav Khuntia held the hand of Bapi and directed him to leave the place along with him. In the meantime, the absconding accused Ganna focused his torchlight at the deceased Biranchi. The accused Madhav Khuntia took the sword from the myself, Pidulford and all the accused persons left this spot, leaving the deceased Biranchi there. I went away to a different direction while accused person and Pidulford proceeded ahead, leaving the spot. While going through a cremation ground, I fell down, but no injury was received. I lie down after covering some distance from the spot with confused brain. Out of fear, it was about 4 a.m. night. Later on, I proceeded ahead and went into the house of one Ramachandra Parida through his bari land and told everything about the occurrence to the said Rama Parida.
Yes, Ramachandra Parida.
Not examined.
Yes, not examined.
Not examined.
I was examined by IO on the
One day
after the occurrence of this case. My statement under section 164 CRPC was also recorded by the magistrate in connection with the occurrence of this case.
अच्छा तामाने ये देखंतु 4टा भोर 4टा रो आसिकिनी कहिला कहूची रामचंद्र परिडा को ता बारीपटा आसिकिनी ता कहिदला सब घटना रामचंद्र परिडा को आपण एग्जामिन कलेनी तापरे क्रॉस एग्जामिनेशन को पड़े आछन
Cross exam paragraph 14.
हां नहीं 13 को
13. My house is about half kilometer away.
Just see the distance.
From the house of deceased Biranchi. There are two villages intervened from my house till Alingchak, which is about 2 kilometers away from my house. I have visiting terms to the family of the deceased since my childhood. The elder brother of the deceased is Radhakrishna Chaudhary, who is my friend. I undertake contract work. It is not a fact that Radhakrishna Chaudhary is also a contractor or a co-partner of mine. It is not a fact that I get financial assistance from Radhakrishna. I voluntarily meet the police alone. On 14/3/96 at about 8:30 or 9 am, I went to police station and I left the PS after 24 hours. I was detained by police to bring me to court. Soon after my arrival at PS, my statement was recorded by IO, which was about 10 to 15 minutes.
तो 14 तारीख दिन तामाने दिन 8:30 रु 9टा भितर से थाना को गला
24टा से डिटेन ହେଇଛି
तार रेकॉर्ड स्टेटमेंट होची ता पर दिन अर्थात 15 तारीख दिन 161 दउची नॉट ऑन 14 तारीख दिन
The detained
he was detained. I was not issued any summon from the magistrate. On 15/3/96, I was produced before the magistrate by the police. Police introduced me before the magistrate and thereafter left the said place. Police was not present when my statement was recorded by the magistrate. At 11 am, my statement was recorded by magistrate. It was took half an hour. I left the court at 11:30 am. It is not a fact that I have not stated before the magistrate that the accused Madhav assaulted the deceased, so also before IO. I have met Ramachandra Parida before going to PS, so also Amiya Biswala. I have not stated before IO regarding my expression before above person, namely Ramachandra Ramaparida, relating to my helplessness to rescue the deceased from the dacoit.
from the dacoits.
It is not a fact that I have stated before the IO that the accused Madhav was identified to me by deceased Bidanji. It is not a fact that I had not gone to the house of the deceased and that I had not accompanied him and that I have been set up as a witness being friend of the brother of the deceased and that no occurrence had taken place.
So the evidence of the IO, I was just going through it. That evidence is also silent that on 14/3/1996, in the morning hours at about 8:39 am, PW8 voluntarily came to the police station and he was detained there by police till his statement was recorded on the next day. Rather, the police saying that on 15th, the statement was recorded. And if at all he is an eyewitness to the occurrence, in spite of all threat not to disclose before anyone, and he's being closely known to the family, whose house is just situated at half a kilometer away from and he was having visiting terms also to the house of the deceased since the childhood. In spite of all the threat, if he has disclosed before one man and going to the police station on the next day of the occurrence, the statement would have been recorded on the next day. Police has not stated that he was there detained for 20. Why police will detain? If an eyewitness comes to the police station, there is no statement.
They all have criminal background.
They all
are criminal
all
background.
are dacoits. All are dacoits.
So that is the reason why we say that these persons are not, they are all having criminal background.
The
So
person
they three left the place together.
since the person having criminal background,
No.
Even the involvement of PW4 and 8 cannot be ruled out.
Cannot be ruled out. That is the main.
And that is how whole the statement is coming like this. They are trying to save themselves also to some extent, somewhere. That is how different kind of statements are done.
Since the P2 4 and 8 have criminal background,
Yes.
they apprehending the danger, their involvement in this
Yes.
case absconded. from
Yes,
this,
yes, that is how they are counted.
Question is
Because the
confidential
report, the confidential inquiry report reveals that the deceased as having not good reputation, having
Of course.
criminal activity.
ଏମାନେ କଥା କହୁଛନ୍ତି ବା ତୁ ତା ଗ୍ରୁପ କୁ ନ ଯିବୁ ମୋ ଗ୍ରୁପ କୁ ଫଲୋ
ହଁ।
ହବ that is how it all going on because at some point of
ये
time
ଦି ଜଣ ଯିଏ ଡିସିଜ କୁ ନେଇକି ଯାଇ
ଇଏ
ଗଲେ
ବି ନେଇଛନ୍ତି
ये ଦି
କୋଉଥିରେ?
ଜଣ ଯାଇକିନି ଯେ
ହଁ।
एकदम ପୁରା एकदम ସତ କହୁଛନ୍ତି
So
ପୁରା
that is also not there.
that is it's very doubtful. Question is that we have to see that how truthful.
P8 in his 162 statement, you placing just.
This character of these witnesses and ତାଙ୍କର previous conduct ଏଗୁଡାକ ମଧ୍ୟ chance of false implication leaving themselves ତା ନିଜକୁ ଇଏ କରିବା ପାଇଁ ଅନ୍ୟକୁ ଫସେଇବା ପାଇଁ ଗୋଟେ ସୁବର୍ଣ୍ଣ ସୁଯୋଗ ବି ତାଙ୍କ ପାଖରେ ରହିଛି ନିଜେ କରିକି କ୍ରାଇମ ଟା ଅନ୍ୟକୁ ମୁଣ୍ଡରେ ଅଠା ବୋଳିବା ପାଇଁ because they belong to the other group.
No,
ସେଟା
the witness are belongs to the group of the deceased.
Deceased belongs to
Deceased,
group.
କାରଣ ସେମାନେ ତାଙ୍କ ସହିତ
Who are the follower
ଏମାନେ
of
ତାଙ୍କୁ
other?
ଚିହ୍ନି ନାହାନ୍ତି। P8 ମାଧ ଖୁଣ୍ଟିଆକୁ ଚିହ୍ନି ନାହିଁ କାରଣ ତା 161 ଷ୍ଟେଟମେଣ୍ଟ ଆଉ 150 ପରେ ତା ନାଁ କହିନାହିଁ।
ନା କହିନେ।
ସେ କହିଛି ଯେ ବନ୍ଧୁକ ଧରିଥିବା ଲୋକ। ତ ମାଧ ଖୁଣ୍ଟିଆକୁ P8 ଆଦୌ ଚିହ୍ନି ନାହିଁ।
You see, say doubtful. He says something different. PW4 ଯଦି ଆପଣଙ୍କର କେସ୍ ରହୁଛି ତା ନିଜ ଷ୍ଟେଟମେଣ୍ଟ ଆଉ ଦେଖନ୍ତୁ 14 ତାରିଖ ତାର ବ୍ୟାକଗ୍ରାଉଣ୍ଡ ଟା ହଉଛି କ୍ରିମିନାଲ ଆଣ୍ଟିସିଡେଣ୍ଟ ତ ଅଛି he is a person very close to the family of the deceased.
Both are close to the family of the କାରଣ ସେଦିନ ସେମାନେ କହୁଛନ୍ତି ଯେ ଅରୁଆ ଭାତ ଡାଲମା ଖାଇକି ଆମେ
ଘରୁ ବାହାରିଲୁ।
କ୍ଲୋଜ ଟୁ ଦି ହାଉସ ଅଫ ଦି ଡିସିଜ ଥିଲେ ସେ ତ ଭୟ ମାନେ ଥ୍ରେଟ୍ କୁ ବେଖାତିର କରି ଆସି ଜଣଙ୍କ ପାଖରେ ଡିସକ୍ଲୋଜ କରୁଛି ତା ଘରଠୁ ଜଷ୍ଟ 1/2 କିଲୋମିଟର ଦୂର ଯେମିତି ସିଏ ଯୋଉଠି ରହିଥିଲା ତାଠୁ 400 ମିଟର ଦୂରରେ ଥାନା ତାପରେ ଚାଲିଗଲା ଥାନାକୁ ଥାନାରେ ଯାଇ ପହଞ୍ଚିଗଲା ଥାନାରେ ତ ପୋଲିସ କୁ କହିବା କଥା ଯେ ମୁଁ ଆଟଲିଷ୍ଟ
ଏଠି କିନ୍ତୁ 161 ରେ କହୁଛି ଯେ ସେଦିନ ସେ ଯୋଉ ପରିଡ଼ା ଘରେ ଚନ୍ଦ୍ରପୁର
161 PW8 ର
8 ର
କଣ କହୁଛି ତାପରେ କୁଆଡେ ଗଲା 15 ତାରିଖ ରେକର୍ଡ ହେଇଛି ନା
15 ତାରିଖ ଭୋରୁ ଯାଇ ରାମଚନ୍ଦ୍ର ପରିଡ଼ାଙ୍କ ଘର ପଛପଟୁ ପଶିଲି ସେ ପଚାରିଲେ ତାଙ୍କୁ କହିଲି ଡକାୟତ ମାନେ ବିରଞ୍ଚିକୁ ହାଣି ମାରିଦେଲେ ଆମେ କିନ୍ତୁ କିଛି ସାହାଯ୍ୟ କରିପାରିଲୁ ନାହିଁ ମତେ ବି ଗୋଡାଉଥିଲେ
You see the statement this statement ଟା ଡକାୟତ ମାନେ ମାରିଦେଲେ just
ମାନେ they also term the other group to be dacoits.
In fact all are dacoits.
All are dacoits.
ନା କାହାର କହୁନି ସେ ପର୍ଯ୍ୟନ୍ତ ଇଏ ମାନେ ଆ ପାଖରେ କହୁନି ଯେ ଏଇ ଯୋଉ ଦି ଜଣ ମାରିଛନ୍ତି ବୋଲି ଡକାୟତ ମାନେ ମାରିଦେଲେ
ସକାଳ 8ଟା ଯାଏ ସେଠି ରେଷ୍ଟ କଲି ସେ ଯାଇ ସକାଳୁ ଏସବୁ କଥା ବୁଝିକରି ରାମଚନ୍ଦ୍ର ପରିଡ଼ା ବୁଝିକରି ଆସିଲା ପରେ ମତେ ଘରୁ ବାହାର କରିଦେଲେ ଦେଲେ ମୁଁ ଲୁଚି ଲୁଚି ଭୁବନେଶ୍ୱର ପଳେଇଲି
13 ତାରିଖ ଘଟଣା ସେ କହୁଛି
13 ତାରିଖ ସକାଳ ମୁଁ ଲୁଚି ଲୁଚି ଭୁବନେଶ୍ୱର ପଳେଇଲି ରାତିରେ ସିଆରପି ଛକ ରାସ୍ତା ଉପରେ ଶୋଇଗଲି ସକାଳୁ ବୋର୍ଡ କଲୋନୀ ଆସି ମୋ ସାଙ୍ଗ ଅମ୍ୟ ବିଶ୍ୱାଳକୁ ଏସବୁ କଥା ଗୋଟି ଗୋଟି କରି କହିଲି ସେ ମୋ ଉପରେ ବିରକ୍ତି ହେଲା କହିଲା ଶୀଘ୍ର ଘରକୁ ଯା ମୁଁ ବହୁ କଷ୍ଟରେ ଘର ଯାଏ ଆସିଛି ମୋ ସଙ୍ଗେ ଗଲେ ମୋର ଜୋତା ବି ମୁଁ ଚିହ୍ନାଇ ବାହାର କରିଦେବି
ତ 14 ତାରିଖ ଦିନ ଥାନାରେ ଗଲା ତାକୁ ଡିଟେନ ରଖିଦେଲା ଯୋଉ ଷ୍ଟେଟମେଣ୍ଟ କ୍ରସ୍ ଏକ୍ସାମିନେସନ ସେ ବିଷୟରେ ବି କିଛି ନାହିଁ ମାନେ ସେ ପଳେଇଲା ଭୁବନେଶ୍ୱର ଏଠିକା
13 ତାରିଖରେ ଗଲା ଭୁବନେଶ୍ୱର 14 ତାରିଖରେ ଫେରି ଆସିଲା ଭୁବନେଶ୍ୱରରୁ
ଥାନାକୁ
ଗାଁକୁ
ତାପରେ 15 ତାରିଖ ଷ୍ଟେଟମେଣ୍ଟ ଏଠି ହଉଛି
ଯେ ମତେ 14 ତାରିଖରୁ
ରାମଚନ୍ଦ୍ରକୁ ଗଲି ରାମଚନ୍ଦ୍ରକୁ ଗଲା ପରେ 14 ତାରିଖ ଦିନ ପଳେଇଲି ଥାନାକୁ ଥାନାରେ ମତେ 24 ଘଣ୍ଟା ଡିଟେନ କରି ରଖିଲେ 15 तारीख दिन मो स्टेटमेंट रेकर्ड हबो कारण माइंड रे निश्चय थिबो आमे आसीचु बहुत
आमे
लोक
implicate
देखिचंदी जानिचंदी तेणु आमरी मुंडरे आसीबो जे से लोकटा मर्डर ହେଇଛି हाँ तेणु तापरे एई जो डिले टा करा होची डिले रो इफेक्ट बहुत अच्छी माने टू मेक आउट अनदर केस आ पाई PW4 पाई 6-7 दिन या पाई हुए तो 2 दिन ही पारे बट ये जो संदेहटा आसुची जे इफ यू कम एंड एक्सप्लेनेशन भुवनेश्वर पढ़ेली एटी गोटे टाइप रो एक्सप्लेनेशन होची सेठी गोटे टाइप रो एक्सप्लेनेशन माने दिया है क्रॉस एग्जामिनेशन completely contradictory anything stated in the trial court in the evidence that I had been to Bhubaneswar seri kono nothing is there rather रामचंद्र को कहली तापर पळाइली थाना को सेठी 24 घंटा रहिली 15 तारिख न मु स्टेटमेंट देली आ पुलिस मते डिटेन कर रखला एथि पय जे मते कोर्ट को नै जियो बोली
हां 164 टा तार 15th रही ने
नहीं 164 करे 164 PW8 रही छी 18 तारिख दिन
हां
स्टेटमेंट रिकॉर्ड है 15 रे 164 है 18 रे तार है 20 स्टेटमेंट आ 25
even if there is some discrepancy, but the doctor's evidence, the injury.
No, आपण तो सेमी देखिले डॉक्टर्स एविडेंस तो कंसिस्टेंट आसीबो असॉल्ट हे कि मरिची हला दी जण साकिंग कर एविडेंस रहउची बट दी जण कर तो हबो जेतु जदी से माने टाइम गैप पाई गले हमें कंडक्टटा देखिबे जे टाइम गैपटा कोन रा तार तो कंसिस्टेंट आसीबो दी जण जाको डिसाइड कले हमें निजु केमती सेव करिवु हला ना दिस इज द वे
ना सेमा जी गोटे टाइम रे तांका स्टेटमेंट रिकॉर्ड ही थांता निखिल ना PW4 और PW8 रो ताले दैट एप्रिहेंशन मस्ट बी दिस वन कथा कहि आसी करले जने
आपण यदि यू आर ए पर्सन हु नोज द नेम्स ऑफ द असेलेंट आपण आसिकिनी डिस्क्लोज करछंदी बिफोर PW2 PW4 एटलीस्ट PW2 कोली से स्टेटमेंट रे देखछंदी किछि ना फा अछि आउ जण को डिस्क्लोज करछंदी रामचंद्र किए तापर को जे डकायत माने चाली गले कोनसी
PW4 स्टेटमेंट नॉट रिलायबल तार
आपण PW8 रो आपण रामचंद्र पाखरे कोन तार डिस्क्लोजर आसिला डकायत माने मार देले यदि देखि छी जे ई दी जण मारले नोन पर्सन ना कोई थांदे माने दी जण मारले आउ गोटे गोटे जो पसिला सी काई डकायत माने ता कोन मार दी
सेटा त कहिछि से मारिचंत बोली कहिछि डकायत भी कहछि बने ही इज गिविंग अनदर नेम because in his examination in chief PW8 has categorically stated about the name and the
group they are dacoit they have criminal background of
he is
dacoit
giving a name of dacoits that means
Madhav Kuntia is criminal antecedent
is dacoit
so also the deceased
he could have told what we say that he could have told that Madhav Kuntia marla
so nahi sir ye to examination chief रे तो से कहिछि
कोटा
specific
नहीं रामो खुंटिया को जो डिस्क्लोज कला 161
सेते बेले रखो
हां 161 ने यूज करनी की डकायत माने मार दे 161 ने कोनोसी ना नहीं छी आइदर ए दी जण को ना ए जो निखिल रो ना बा माधव कुंटिया रो ना ता 161 नहीं राम कुंटिया आपन को पहुंचन
ना ना राम कुंटिया को कहिला
राम कुंटिया को कोन कहला सेई गुडा काम
चल राम
पढिलो अबिका
एटा
161
स्टेटमेंट PW8 ର statement
ହଁ ସେଇ
PW8 ର
PW8
161
161 ସେ
161
କହିଲା
ହଁ
ରାମଚନ୍ଦ୍ର ପରିଡ଼ାଙ୍କ ଘର ପଛପଟୁ ପଶିଲି
ବାସ୍
ସେ ପଚାରିଲେ
ହଁ
ତାକୁ କହିଲି
ହଁ
ଡକାୟତ ମାନେ ବିରଞ୍ଚୁକୁ ହାଣି ମାରିଦେଲେ
ହୁଁ।
ହଁ
ଆମେ ତାକୁ ସାହାଯ୍ୟ କରିପାରିଲୁ ନାହିଁ
ହୁଁ।
ମତେ ବି ଗୋଡାଉଥିଲେ
ହଁ ତ
ଆଧ ଗନ ନିଖିଲ ବିଜୁ ମିଶି
ହୁଁ।
ବିରଞ୍ଚୁକୁ ହାଣି ସାରି
ସେ କହିଛି
ବାପିକୁ ବି ସାଙ୍ଗରେ ନେଇଛନ୍ତି।
ହୁଁ
ନାଇଁ ଉପରେ ବି କହିଛି ତଳେ ବି କହିଛି ତାକୁ କହିଲା ବେଳକୁ ସେଟା ଡକାୟତ ବୋଲି କହିଛି but he has given the vivid description of the name and
PW ଇଏର କେତେ ନମ୍ବର ପେଜ ରେ ଅଛି
ପେଜ ହଉଛି 412 ତାର
412
ଆରମ୍ଭ ହଉଛି PW8 ର 161 statement ଟା ଆରମ୍ଭ ହଉଛି 409
ସଞ୍ଜୟ ମହାପାତ୍ର
ହୁଁ।
ଘଟଣା ପରିସରକୁ ଆରମ୍ଭ ହେଲା ସେଟା କୋଉଠି ଗଲା
ସେ କହୁଛି ସେ ହାତ ଦେଖେଇ ଗାଡି ଅଟକେଇଲା ତାପରେ
ଘଟଣା ପରେ ସେ ଯୋଉ ଜାଗାରୁ ପଳେଇଲା
ଆଚ୍ଛା ପଳେଇଲା
ପଳେଇଲା ସେଟା ଆରମ୍ଭ ହଉଛି 412
12
ହୁଁ। ସେମାନେ ଅଣନିଶ୍ୱାସୀ ହୋଇ ଦୌଡୁଛନ୍ତି ମୁଁ
ଆଚ୍ଛା ହଁ ଗୋଡ଼ ହାତ ଶ୍ୱାଂଶ ଯାଇପାରୁନି ଭୋରୁ ଯାଇ ରାମଚନ୍ଦ୍ର ପରିଡ଼ାଙ୍କ ଘର ପଛପଟୁ ପଶିଲୁ ସେ ପଛାରୁ ପାଞ୍ଚଟି ଡକାୟତ ମାନେ ବିରଞ୍ଚିକୁ ମାରିଦେଲେ ଆମେ କିନ୍ତୁ ସାହାଯ୍ୟ କରିପାରିଲୁ ନାହିଁ ମତେ ମଧ୍ୟ ଗୋଡ଼ାଉଥିଲେ ମାଦକ ଭନ ଶ୍ୱାଂଶ ମିଶି ବିରଞ୍ଚି ପାଇଁ ସାରି ବାପିକି ସାଙ୍ଗରେ ନେଇଛନ୍ତି ମୋର ଜୋତା ଖୋଲି ତାଙ୍କ ଖଟ ତଳେ ରଖିଦେଲି ସକାଳ 8ଟା ଯାଏ ସେଠୁ ରେଷ୍ଟ ନେଲି ସେ ଯାଏ ସକାଳୁ ଏକଥା ବୁଝାବୁଝି କରି ଆସିଲା ପରେ ମତେ କହିପାରିଲ ମୁଁ ରହୁଛି ଭୁବନେଶ୍ୱର ପଳାଇଲି ରାତିରେ ସିଆର୍ପି ଛକ ରାସ୍ତାରେ ଶୋଇଲି ସକାଳୁ ରୋଡ ଫୋରମ୍ରେ ମୋ ସାଙ୍ଗ ଅମୟ ସାହୁ ସବୁ କଥା ଗୋଟି ଗୋଟି କରି କହିଲି ସେ ମୋ ବିରକ୍ତ ହେଲା କହିଲା ଶୀଘ୍ର ଘରକୁ ଯାଅ ମୁଁ ବହୁତ କଷ୍ଟରେ ରହିକି ଆସିଲି ମୋ ସାଙ୍ଗ କହିଲେ ମୋ ଜୋତା କରିକି ଆମେ ଆସିଲୁ ଭୁବନେଶ୍ୱର ପାର୍ଟଟା ନାହିଁ ଏଥିରେ ନା ଏ ଯୋଉ ଏକ୍ସପ୍ଲାନେସନ ଫର୍ଦର ଦଉଛି
ଏଠି
ସିଏ ଘରୁ ବାହାର କରିଦେଲା ରାମଚନ୍ଦ୍ର
ଇଏ ପଳେଇ
ରାମଚନ୍ଦ୍ର ବାହାର କରିଦେଲାଠୁ ପଳେଇଲା ଭୁବନେଶ୍ୱର ଗୋଟେ ସାଙ୍ଗ ତାକୁ ବିରକ୍ତ ହେଲା
ଅମୀୟ ବିଶ୍ୱାଳ
ଅମୀୟ ବିଶ୍ୱାଳ
164 ବି ମାଲର ତା ନାଁ କହି 164 ବି ରେକର୍ଡ ହେଇଛି ସେଥିରେ ବି କହିନି
ଏଠି ରାଦର କହୁଛି ଯେ ସେ ଯୋଉ ରାମଚନ୍ଦ୍ର ପରେ
161 ରେ କହିଛି କିନ୍ତୁ 164 ରେ ନାହିଁ 164 no, page 99 of the brief.
ରାମଚନ୍ଦ୍ର ପରିଡ଼ା ଘରେ ମୁଁ ତାଙ୍କ ଘରେ ରେଷ୍ଟ ନେଲି ସିଏ କାହାକୁ ଖବର ଦେଲେ କି ନଦେଲେ ମୁଁ କହିପାରିବି ନାହିଁ କିଛି ସମୟ ପରେ ସେ ମତେ କହିଲେ ତୁରନ୍ତ ମୋ ଘର ଛାଡି କରି ପଳାଇ ଯା ତାପରେ ମୁଁ ଭୁବନେଶ୍ୱରକୁ ମୋ ସାଙ୍ଗ ପାଖକୁ ପଳାଇ ଗଲି ମୋ ସାଙ୍ଗ ମୋ ଉପରେ ଭୀଷଣ ବିରକ୍ତି ହେଲା ଏବଂ କହିଲା କି ତୁ ଶୀଘ୍ର ଗାଁକୁ ଫେରିଯା ଏସବୁ କଥା ଖୋଲିକରି
ଯୋଉ 161 କଥା ଯେ
ମିଶିକି ରାମଚନ୍ଦ୍ର କଥାଟା ରହିଛି ରାମଚନ୍ଦ୍ର ପରେ ଯୋଉ ଭୁବନେଶ୍ୱର କଥାଟା
ସାଙ୍ଗର ନାଁଟା କହିନି
ହଁ ନାଇଁ ଭୁବନେଶ୍ୱର କଥାଟା ଏଭିଡେନ୍ସରେ ନାହିଁ
ନା
ଏଭିଡେନ୍ସ
ସେଗୁଡାକରେ ଅଛି ସେ
ଏଭିଡେନ୍ସ
କାରଣ ଏଭିଡେନ୍ସ ହେଲା ବେଳକୁ 14 ତାରିଖ ଦିନ ଷ୍ଟ୍ରେଟ୍
ଆସିଲା ଥାନାକୁ ରିଟର୍ନ ହେଲା ଷ୍ଟେଟମେଣ୍ଟ ଦେଲା ଗଲା
ହଁ ବାସ୍ if that particular line is accepted, let us say the PW8 ର ସେ ଯୋଉ line ଟା ରହୁଛି paragraph 14 ରେ page 71 ରେ ଯେ ସିଏ 14 ତାରିଖ ଦିନ 8:30 9ଟା ବେଳ ସକାଳ ପହଞ୍ଚିଗଲା ଥାନାରେ ତାକୁ डिटेन करी पुलिस 24 घंटा रखिला और ता परदिन स्टेटमेंट तार रेकॉर्ड है एडमिटेडली 15 रे रेकॉर्ड है तार इंपैक्ट कोन हे पारे
impact police also suspected that the PW8 is also a accused in this case. That's why they
or
detained.
that gave this witness time to think of a story if he was retained there. Police was suspecting तापन जाटा कहउछन police was suspecting that ये जाइतला deceased आरो involvement हुए तो थाई पर कारण सेते बेल पर्यंत के जानि नाती कोन हेछि
फर्स्ट टाइम पे PW8 नहीं पहुंची छी आउ पुलिस ताको संदेह रे जेतु ता सहित
24 घंटा रखिला तनु संदेह करूची सेठी ताको गोटे टाइम मिलुनी गोटे अपन जदी ता परदिन स्टेटमेंट रेकॉर्ड कराउची तेणु सीए जड़े लोक डिटेन करी रखिबे नॉर्मल साक्षी अलगा कथा गोटे एंड गोटे क्रिमिनल बैकग्राउंड लोकटा को ताकू रखिले डिटेन करी तापर संदेह ला कारण से जाइतिला पुलिस से जो आक्यू डिसी सांगेरे आर लोकटार पता कथा नाही किछि तेणु लाइकली टू स्पिन आउट ए स्टोरी
सेटा
he is having that 24 hours time with him and he is apprehending that if I'll not tell against somebody else, I will be made an accused and I will be forwarded. What she use करछि मते detain करी रखी चंदी 24
सेटा हे थांदा जति PW4 असला आउट 4 दिन परे तार PW4 रो स्टेटमेंट जदी को डिफरेंट ही थांता ताहले एक कथा
आपण डिफरेंट कोन कहउछंदी स्टेटमेंट तो जोना पड़िगला ना स्टेटमेंट आरो आसी गला ए स्टेटमेंट 15 तारिख न ये कोन स्टेटमेंट देला सेटा तो आपण रेकॉर्ड कर देला ना एमन को इम्प्लिकेट कर देला and by that time also 164 has also been recorded. So who light statement आसी गला that is known to everyone, not only the police statement but also the 164 statement known to the police at least. अन्य माने कथा छाड़ंतु
देन व्हाई देखो तापर क्वेश्चन है पुलिस काहे की मिछरे अन्य माने को रखी के आकू इम्प्लिकेट करउछि
कोडा
आसीबो क्वेश्चन ताले पुलिस काहे की आकू
no that is not relevant is that when you are detaining a person for 24 hours and recording his statement thereafter whether that person is who has having a criminal background is not likely to spin out a story during that he got the opportunity.
He got the opportunity, but PW4 he directly came from
PW4 you said we also he cannot be acted upon totally explanation is whatever explanation has been
what I am trying to say my lord to answer my lord
either you believe a witness or not believe.
Yes.
Once you say that it is not believable, just throw him out. Now you confine to that means you have only a solitary witness.
Only PW8.
PW8. PW8 is a person who you have seen that what sort of prevaricating statement he is given. Ramachandra is consistent. Ramachandra pakhre koila boli se kohuchi tinta ko statement. Right? Ramachandra pore jo statement guda ko deich kuade gala Bhubaneswar in 161 164 but in court it is not Bhubaneswar, it is in the police station. Positive statement elicited in the cross examination 14 तारिख सकाळ 8:30 9टा भितरे पुलिस स्टेशन ने पहुंची गली थाना रे ता स्टेटमेंट रेकॉर्ड कोनी रादर पुलिस ताको डिटेन करी रखि देला स्टेटमेंट रेकॉर्ड होची 15 तारिख दिन जेटा आपन केस डायरी रिवील्स करची एडमिटेडली तार मध्य रेकॉर्ड है 15 तारिख डेट
सेटा आयोग को पत्र है कि समय 14 तारिख दिन से आस्तला तुम डिटेन करतो पत्र है
डिफेंस हैज नॉट
नहीं डिफेंस कोन एटा पर आपन को अगेंस्ट रे गला ना you should have brought the clarification why defense has brought out a material from the evidence आपन सी काई पहुंचे कि ता डिस्ट्रॉयड करिवे it was the duty of the prosecution प्रोसिक्यूशन जदि पचारि था डिफेन्स तो पचारे से मना कर दो नाई सी आसीनी कि 14 तारीख दिन आपण क्लारिफिकेशन आनिया कथा आपण काई आपण
ଆସିଲା କି ଏଟା ଆସିନି
आपण
ନା ଖାଲି ଜେନେରାଲ ୱେରେ ତା କେସ୍ ଡାଏରୀ ଅନୁସାରେ ସେ କହିଛନ୍ତି।
आपण केस डायरी मध्य देखंतु केस डायरी कोठी रिफ्लेक्ट हेइनी जे 14 तारीख दिन सी आसिकिनी डिटेन ही रहिछि तेणु सी तो सीधा पुलिस मना करथांदा जे नाई सी आसिला 15 तारीख दिन फॉर द फर्स्ट टाइम मते स्टेटमेंट देला एवं ता स्टेटमेंट को मु फॉरवर्ड कर देली बा कली तापरे रिक्वेशन देली प्रेयर कली 164 रेकॉर्ड कला प्रोसिक्यूशन रो ड्यूटी आछि कारण क्रॉस एग्जामिनेशन से गोटे वैल्यूएबल पॉइंट गोटे तांको फेवर रे आनी सी की कहीं पचारिबो पुणी आउ से क्वेश्चन जहाटा आनिचंदी सेटा नष्ट होई जीवो ना एति जो जिंसडा आनिचंदी तारो कोन हेई पारे तारे हमें लेट अस एक्सेप्ट दैट हां ए विटनेस टा कारण आपण ताको डिनाय करना दी बाय ब्रिंगिंग एनीथिंग कॉन्ट्राडिक्टरी टू दैट थ्रू द आई
केस डायरी मध्ये मेंशन किछि नाही
ता माने से विटनेस को हम धरा जीवो 14 तारीख को से विटनेस जाई थाना रे पहुंची ताकू डिटेन करी रखा है 24 घंटा पर 24 घंटा पर से स्टेटमेंट टा देई
so whether this should give rise to a suspicion that he has सेति केवल
जे से जो पीरियड टा मिलिला से विटनेस whether there is any scope and opportunity on his part माने मेजो को बंचई कि नहीं आउ गोटे स्टोरी करी कि नहीं आउ से स्टेटमेंट टा डाउटफुल हबो कि एति तो
याकु बंचेबा माने यार निजर बंचेबार लई किछि अछि कि मटेरियल जदि अछि ताहले फेर हम कहयाने बंचेबाटा
हां
PW8 has no enmity with the accused person. They have no enmity. Even PW8 has not known name of Madhav Kuntia. Because in his 164 statement, he is consistently saying that the person who was holding a gun, he has not named the Madhav Kuntia.
So there was no animosity.
No enmity. In that circumstances,
to implicate. That is one circumstance.
से वर्तमान यदि आपण सिंगल विटनेस को रिलाय ई करिवे अपार्ट फ्रॉम दिस स्टेटमेंट व्हाट अबाउट दैट एडिशन इम्प्लिकेटिंग दैट पार्ट माधव खुंटिया को डायरेक्ट एसेलेंट हिसाब राणीवार जो स्टेटमेंट की ना 161 अछि ना 164 अछि ताकू जो 4-5 टा ब्लो एट्रिब्यूट कैन ही सेड टू बी एन एब्सोल्युटली रिलायबल विटनेस आपण पुनी से कैटेगरी आनिया पड़िबो सिंगल विटनेस को आपण रिलाय करिवे he must be absolutely reliable और यदि आपण partly reliable और partly unreliable भितरे ताकू आनिबे in view of this contradiction and then आपण को गोटे corroboration आनिबा को पड़िबो in view of that well settled principle जो 3 categories of witness कहउछंती absolutely unreliable discard it absolutely reliable believe it और जो partly reliable
here one thing is that the other witness who is there picking on this same is we are not believing him suppose because PW4 is a prevaricating because his explanation is requested.
He is also not fully unreliable.
He is not fully unreliable.
He is partly PW4 is partly unreliable because he is saying that on the 13 at 10 AM he returned from Govindpur, came to the village of the house of the deceased at in between 2 to 3 PM and disclosing everything before PW2 and PW.
That is again you see
that neither of these two people.
But
you see
the part consistent part is
he comes to the house of the deceased at 2 o'clock on 13th.
Yes,
by that time investigation has already commenced.
But the consistent part assault part. That is
assault part आपण सेठी जानतु आपण सेही भली परिस्थिति रे जोठी काहाकू जणा नाही जे असेलेंट किए सेठी गोटे आई विटनेस आसीकिनी डिसीज्ड घरे पहुंचुची 2-3 बळे से कहउची ना PW4 मु पहुंचली बेली ताकू से माने पुलिस को भी कहि नांती खबर देई नांती काहाकू भी कहलेनी ताकू छाड़ देले से पळेला राउरकेला को एवं इन्फॉर्मेशन किसी नाही से विटनेस केही भी कहू नांती जे ये आसीथिला एमती खबर देई चली गला एवं आसीथिले जो कंडक्ट हबा कथा पुलिस को କହିବା କଥା ନା ଯେ ନାଇଁ ଏମିତି ଇଏ ଦେଖିଛନ୍ତି
That
କାରଣ
part
ସମସ୍ତେ
is not
ଜାଣିବାକୁ ଚାହୁଁଛନ୍ତି କିଏ ଏ କାମ କରିଛି ସେ ଯୋଉଟା
No, they had expectation from these two people,
ହୁଁ
those who had accompanied
Yes.
Biranchi. So these two people were very important.
Yes.
So keeping in view the fact that these two people had accompanied Biranchi
Hmm.
while leaving the house, obviously these are the two persons who could have known about the
The
incident. So that way it is obvious that these are the two witnesses. They are not chance witnesses or they are not planted witnesses. These two witnesses were the witnesses who had accompanied.
Hmm.
Now subsequent thereto the question arises, the conduct. Now if we say that the conduct of P4 is not consistent to the manner in which he has deposed to in the court vis-a-vis his time of examination. ଏଇଟାରେ ଡିସ୍କ୍ରିପେନ୍ସି ଟିକେ ରହୁଛି। ସେ କହୁଛି ମୁଁ ଘଟଣା ପରେ ଡରେଇଲେ ମୁଁ ଡରିକିରି ପଳେଇଲି, କିନ୍ତୁ ଡରେଇଲା ଭିତରେ ସେ ପୁଣି 2-3ଟା ବେଳେ ଆସିକିରି ୟାଙ୍କ ଘରେ କହିକିରି ପଳେଇ ଯାଇଛି। This is one conduct. And the other conduct is that after 4-5 days he is coming and that we are not getting any link.
କୋଉଠି ଯାଇ ରହିଥିଲା
So
କଣ
this may not be very important link, may not be, it is only because the delay in explanation why he has been examined belated. So that we are not getting a link. Had Trilochan or Brajabandhu could have been examined, ତାହେଲେ ଆମେ ପାଇଥାନ୍ତେ ସେ ରାଉରକେଲା ପଳେଇଲା। ସେଟା ଯଦି ନାହିଁ ତାହେଲେ ଆମେ ତାର delay examination ର ପାଉନାହିଁ ବୋଲିକି ବର୍ତ୍ତମାନ ଆମେ ସେ witness ଟାକୁ rely କରିବାକୁ difficult ଭାବୁଛୁ। Reason being, even if he has stated on the material particular with respect to the factum of incident, but the entire examination seems to be not very cogent in absence of this delay in examination. ଆଉ ଯଦି otherwise ଆମେ ଧରିବା, yes, because of the threat both of them have left, and that is how one is coming on 14th, the other is coming on 15th or 18th. That way,
that is coming
on
20 ତାରିଖ
20 ରେ ଆସୁଛି, ଗୋଟେ 20 ରେ ଆସୁଛି, ଗୋଟେ 14 ରେ ଆସୁଛି, 15 ରେ ଦେଇକିରି 18 ରେ ପୁଣି ଦଉଛି। So କିନ୍ତୁ by then it was expected that the persons who were examined by the police, because the investigation had already commenced, these two persons would have subsequently also been examined. That we heard it from these two people who disclosed before us. ଯଦି ଏଇଟା ବି ଥାନ୍ତା ତାହେଲେ ସେ 2 ଜଣକଟା ବି ଆସିଥାନ୍ତା ପରେ ଆସିଥିଲେ ବି। So to this extent
କେହି କହୁନାହାନ୍ତି ଆପଣ କୌଣସି ଷ୍ଟେଟମେଣ୍ଟ ତା ଭିତରେ ଯେତିକି ରେକର୍ଡ ହେଇଛି କେହି କହିଛନ୍ତି କି ଯେ ଆମ ପାଖରେ ଆସି ଇଏ ଏମାନେ କହିଲେ ଏମିତି ଇମ୍ପ୍ଲିକେଟ କରିକି ଯୋଉ ସେ ରାମଚନ୍ଦ୍ର ହଉ ତା ତ
କୋର୍ଟରେ କହିଲେ କି, କୋର୍ଟରେ କହିଲେ କି, ସପୋଜ 161 ରେ ସ୍କୋପ ନଥିଲା, କୋର୍ଟରେ କହିଲେ କି ଏ ନବକୃଷ୍ଣ ହୁଏ ଆସିକି କହିଛନ୍ତି ବୋଲିକି କହିଲେନି ନା, because that statement has come, suppose by then they had been examined, so they could have stated it in the court.
P2 କହିବା କଥା।
ହଁ, P2 କହିବା କଥା ଯେ ଆସିକି ସେ କହିକିରି ଗଲା, ନବକୃଷ୍ଣ କହିବା କଥା। He is silent about it, huh?
P2 no, P2 has stated P2 ର
ଏମାନେ କହିଛନ୍ତି ନା ଏମାନେ କହିଛନ୍ତି I heard about the death of deceased unnecessary.
P2 କହିଛି, I told about the occurrence by Bapi and Baban on the next day of the occurrence. ସେ କହିଦେଇଛନ୍ତି next date of the occurrence.
next day of the occurrence ତା ପରେ ତାର ଷ୍ଟେଟମେଣ୍ଟ ରେକର୍ଡ ହେଇଛି, ସେ ଷ୍ଟେଟମେଣ୍ଟ ରେ କିନ୍ତୁ କିଛି ନାହିଁ।
ସେ ଯୋଉ ନେକ୍ସଟ ଡେ ରେ ମାନେ ନେକ୍ସଟ ଡେ ଅଫ ଦ ଇନସିଡେଣ୍ଟ
ନା ଷ୍ଟେଟମେଣ୍ଟ ରେକର୍ଡ ହେଇଛି 13 ରେ, ନେକ୍ସଟ ଡେ କହିଲେ 14 ତାରିଖ। ବାପିର P2 ର ଷ୍ଟେଟମେଣ୍ଟ ରେକର୍ଡ ହେଇଛି 13 ତାରିଖରେ।
ହଁ,
ସେ ଡିପୋଜିସନ ଲେଖୁଛି I was told about the occurrence by Bapi and Baban on the next date of the occurrence.
ହଁ ନେକ୍ସଟ ଡେ ମାନେ 13 ତାରିଖ, 14 ତାରିଖ ତ ସେ ପଳେଇଲାଣି ସିଆଡେ।
ଏଠି ଧରୁଛନ୍ତି ଯେହେତୁ
14 ତାରିଖ ପୁରା ସିଏ ନିଜେ ନାହିଁ କହିବ କେମିତି? ରାଉରକେଲା ପଳେଇଲା
କହିକିରି ଗଲା।
ନା P2 ର ଷ୍ଟେଟମେଣ୍ଟ ଟା ରେକର୍ଡ ହେଇଛି 13 ତାରିଖ ଦିନ।
ହଁ
161 ଷ୍ଟେଟମେଣ୍ଟ
obviously 4ଟା ବେଳେ ରେକର୍ଡ ହେଇଛି, 4ଟା ବେଳକୁ ତାମାନେ ସେତେବେଳକୁ ସିଏ କହୁଛି ମତେ କହିଦେଲାଣି ଅଲରେଡି, କାରଣ ଇଏ ଆସିଛି କେତେବେଳେ।
ସେଇଟା ଡିସ୍କ୍ରିପେନ୍ସି ସେଟା ବି ରହିଯାଇଛି, କିନ୍ତୁ କୋଉ ଜାଗାରେ ଗୋଟେ ସେ କହିଛି ଯେ ଏଟା
କିନ୍ତୁ ଆପଣ ଯୋଉ 14 ତାରିଖ ଦିନ ହେଇଛି ବୋଲି କହୁଛନ୍ତି, 14 ତାରିଖ ଦିନ ଡିସକ୍ଲୋଜ କରିଛି ବୋଲି, that cannot be accepted because Chaudhary
Kehi nathile.
PW4 ही नहीं, PW4 Portland Raurkela.
PW8 আসছে চৌধুরী,
হ্যাঁ।
4 না।
4 কথা we are on 4.
On the next day means we have to take it on 13th.
13.
And if it is on 13th between 2 to 3, time koti koiche 2 to 3.
2
Se
to 3
koiche
koiche,
4
PW4 koiche.
4 koiche.
ମାନେ ଆଉ ଗୋଟେ ଡିଫରେନ୍ସ ହଉଛି ପାରାଗ୍ରାଫ
ଟିକେ ରୁହନ୍ତୁ। ତେଣୁ ଆମେ ଏଇ ଲାଇନ ଟାକୁ ପଢିବା PW2 ର ଏଇ ପର୍ଟିକୁଲାର ଲାଇନ ଯେ I was told about the occurrence by ବାପି ମାନେ PW4. ବାପିର ଷ୍ଟେଟମେଣ୍ଟ ଅନୁଯାୟୀ he disclosed it at about 2 to 3. ତାପରେ PW2 ର 161 ରେକର୍ଡ ହେଇଛି 4ଟା ବେଳେ ଆମେ ଦେଖିଲୁ ନା 4ଟା ବେଳେ ସେ ଷ୍ଟେଟମେଣ୍ଟରେ there is no whisper that either
ବାପି or ବାପନ
ବାପି disclose କରିଛି but he is also at least aware about the name of the assailant. କୌଣସି
ବାବନ କହି ନାହିଁ ସେ PW2 କୁ କହିଛି ବୋଲି। ବାବନ PW8
ବାବନ କଥା ନ 4 କନଫାଇନ୍ କରନ୍ତୁ ଆପଣ 4 କଣ ଆପଣ ଦିଟା ସାକ୍ଷୀ କହୁଛି ନା ସେ କହୁଛନ୍ତି 2 ଜଣ ଯାକ ମତେ ଆସି କହିଲେ ହେଲା ବାବନ ତ ଟୋଟାଲି ମନା କରୁଛି ମୁଁ ତାକୁ କହିନି ବାବନ କହୁଛି ସେଗୁଡା ରାମଚନ୍ଦ୍ରକୁ କହିଲା ତାପରେ ପଳେଇଲା ଭୁବନେଶ୍ୱର ଆଇଲା ସିଧା ପହଞ୍ଚିଲା ଥାନାରେ ରହିଲା 24 ଘଣ୍ଟା ଡିଟେନ୍ ନେଇକିନି ତାପରେ ଷ୍ଟେଟମେଣ୍ଟ ଦେଲା ତେଣୁ PW2 କୁ ଡିସକ୍ଲୋଜ କରିବାର କିଛି ନାହିଁ ଏଇ ଆର ଲିଙ୍କ ଆସୁଛି because PW4 himself has stated that I disclosed before PW2 କହୁନି କି ଏବଂ ସେ ଟାଇମଟା ହଉଛି କେତେବେଳେ ନା 3ଟା ବେଳେ ତାପରେ ତାର 161 ରେକର୍ଡ ହେଇଛି କାରଣ ନା ଏଇ PW2 ସେଇଟା ବେଳେ ହଉଛି 4ଟା ବେଳେ କେସ୍ ଡାଏରୀ ଷ୍ଟେଟମେଣ୍ଟ
PW2 ର ପାରାଗ୍ରାଫ 4 ରେ ଏଠି ସେ ଚିଫ ରେ ଯେତେବେଳେ ସେ ଟ୍ରେକରରେ ଆସିଥିଲେ ରବ ବେହେରା ଗୋଟେ ଲୋକ ଡ୍ୟାସ୍ ଧକ୍କା ହେଲା ସିଏ ବି କହିଲା ଯେ ସେଠି ଗୋଟେ ପାଟିତୁଣ୍ଡ ହଉଛି କି ହଲାଗୁଲା ହଉଛି ଲୋକଙ୍କ ଭିତରେ ସେଟା ତାକୁ କହିଛି ଏଠି ଲେଖୁଛି ମେ ପ୍ଲେସ୍ ଦ୍ୟାଟ୍ ପାର୍ଟ
that supports
ସେଟା
that supports the incident
was
the occurrence is there that means
କିନ୍ତୁ
ସେଠି ଗୋଟେ ଘଟଣା ଘଟିଥିଲା କୁକୁର ଭୁକୁଥିଲେ ରବ ବେହେରା ରସ ପକେଇଲେ
that speaks of an incident.
ଦଶ କହୁଛି ଯେ ସକାଳ 9ଟାରେ ପୋଲିସ ଆସିଥିଲା ଆଲିଙ୍ଗି ଛକକୁ
Investigation had already commenced.
The evidence on record at least indicates that these 2 persons had accompanied the deceased.
Yes.
That is 161, 164
Everywhere it is there.
trial. So 2 ଜଣ accompany କରିଥିଲେ deceased କୁ deceased ର dead body X ଜାଗାରୁ ମିଳିଥିଲା
That is
it will be also deceased died a homicidal death that is also there. Question ହଉଛି the author of the crime whether these are the PW4 and 8 or anybody else or these accused persons who have committed the crime. That is the crux of the matter.
4 and 8 ରେ ଆପଣ କହିବା କଥା since there is no animosity the question of implication does not arise no apprehension could have been there. In absence of that whether this evidence is to be accepted or not.
Yes,
because no animosity is there.
No animosity and all the witnesses are consistently saying that PW2, PW6, PW5 they are consistently saying that the deceased along with the PW4 and 8 all have accompanied.
No, that is there.
Accompanied ରେ କହିଲୁ that is there.
Authorship ରେ ଆମର ବର୍ତ୍ତମାନ ଅଛି authorship ରେ the though both PW4 and 8 have also consistent in their material particular with regard to the persons who assaulted whether this evidence is believable or not. So this is a core aspect.
Yes,
just the core aspect keeping in view the conduct of these witnesses. This is only to be related, that's all. There is no chance apparently in absence of any material of animosity to have been implicated. So
only
that is
there
also
is
ruled
only
out. Now why then whether these discrepancies appearing in the evidence would give a consistency to the evidence of PW4 and 8 to be believed. with the discrepancies.
So, we'll take up on Thursday
Yes.
and we'll conclude it on that day. So whatever note, etc. you want to prepare it, citation, no close portion. है ना? भाई अच्छी हो गई हार्डिंग पार्ट पर original हाँ और further hearing इला गुटा अगर गुटा हार्डिंग पार्ट है ना further hearing करो
Further hearing.
हाँ ते language लिखी utilize करी कि नहीं for the रखी दे 16.
Pardon to make mention, my lord. So death reference case now year 2024 along with the jail criminal appeal.
Another bench.